Check 1 2 3. Check. Check. Check 1 2 3. Check. Check 1 2 3. Check.
Please take your seats. Good morning to one and all. Medicine is one of the noblest professions entrusted with the responsibility of preserving human life. However, when negligence occurs, the law steps in to ensure accountability and justice. As rightly said, where there is a duty of care, there must also be responsibility for breach. Justice is not only about punishing wrongdoer, it is also about protecting trust in professions that safeguard human life. Good morning to one and all. Today's seminar aims to create awareness about the legal principles governing medical negligence and patent rights and the responsibility of healthcare professionals. Let us now begin this auspicious program. I request all the dignitaries to come on the dais. I request all the dignitaries to come on the dais. Thank you all. This is the program. To commence the program, I request all the dignitaries and the audience to kindly rise for the Nadagite. Please everyone be seated. Every good beginning is made sacred through prayer. To invoke the blessings of alumni, I invite Mr. Uttam Kamble from LLB second year to present the prayer song.
ತಾಯಿ ಶಾರದೆ ಲೋಕ ಪೂಜಿತೆ ಜ್ಞಾನದಾತೆ ನಮೋಸ್ತುತೆ. ತಾಯಿ ಶಾರದೆ ಲೋಕ ಪೂಜಿತೆ ಜ್ಞಾನದಾತೆ ನಮೋಸ್ತುತೆ. ಪ್ರೇಮದಿಂದಲೇ ಸಲಹು ಮಾತೆ, ಪ್ರೇಮದಿಂದಲೇ ಸಲಹು ಮಾತೆ, ನೀಡು ಸನ್ಮತಿ ಸೌಖ್ಯದಾತೆ. ತಾಯಿ ಶಾರದೆ ಲೋಕ ಪೂಜಿತೆ ಜ್ಞಾನದಾತೆ ನಮೋಸ್ತುತೆ. ಅಂಧಕಾರವ ಓಡಿಸು, ಜ್ಞಾನ ಜ್ಯೋತಿಯ ಬೆಳಗಿಸು. ಅಂಧಕಾರವ ಓಡಿಸು, ಜ್ಞಾನ ಜ್ಯೋತಿಯ ಬೆಳಗಿಸು. ಹೃದಯ ಮಂದಿರದಲ್ಲಿ ನೆಲೆಸು, ಚಿಂತೆಯ ಆಳಿಸು, ಶಾಂತಿಯ ನೆಲೆಸು. ತಾಯಿ ಶಾರದೆ ಲೋಕ ಪೂಜಿತೆ ಜ್ಞಾನದಾತೆ ನಮೋಸ್ತುತೆ. ನಿನ್ನ ಮಡಿಲಿನ ಮಕ್ಕಳಮ್ಮ, ನಿನ್ನ ನಂಬಿದ ಕಂದನಮ್ಮ. ನಿನ್ನ ಮಡಿಲಿನ ಮಕ್ಕಳಮ್ಮ, ನಿನ್ನ ನಂಬಿದ ಕಂದರಮ್ಮ. ನಿನ್ನ ಕರುಣೆಯ ಬೆಳಗಲಮ್ಮ, ನಿನ್ನ ಕರುಣೆಯ ಬೆಳಗಲಮ್ಮ. ಬಾಳನು ಬೆಳಗಮ್ಮ, ನಮ್ಮ ಕೋರಿಕೆಯ ಆಲಿಸಮ್ಮ. ತಾಯಿ ಶಾರದೆ ಲೋಕ ಪೂಜಿತೆ ಜ್ಞಾನದಾತೆ ನಮೋಸ್ತುತೆ. ಒಳ್ಳೆ ಮಾತವನಾಡಿಸು, ಒಳ್ಳೆ ಕೆಲಸವ ಮಾಡಿಸು. ಒಳ್ಳೆ ಮಾತವನಾಡಿಸು, ಒಳ್ಳೆ ಕೆಲಸವ ಮಾಡಿಸು. ಒಳ್ಳೆ ದಾರಿಯಲೆಮ್ಮ ನಡೆಸು, ವಿದ್ಯೆಯ ಕಲಿಸು, ಆಸೆ ಪೂರೈಸು. ತಾಯಿ ಶಾರದೆ ಲೋಕ ಪೂಜಿತೆ ಜ್ಞಾನದಾತೆ ನಮೋಸ್ತುತೆ. ಪ್ರೇಮದಿಂದಲೇ ಸಲಹು ಮಾತೆ, ನೀಡು ಸಮ್ಮತಿ ಸೌಖ್ಯದಾತೆ. ತಾಯಿ ಶಾರದೆ ಲೋಕ ಪೂಜಿತೆ ಜ್ಞಾನದಾತೆ ನಮೋಸ್ತುತೆ. ಜ್ಞಾನದಾತೆ ನಮೋಸ್ತುತೆ, ಜ್ಞಾನದಾತೆ ನಮೋಸ್ತುತೆ. ಥ್ಯಾಂಕ್ ಯು.
Thank you, Uttam, for the soulful prayer. A warm welcome makes every gathering meaningful and memorable. To formally welcome the dignitaries and the participants, I now invite Professor Dr. Archie Kulkarni, Dean and Principal, School of Law BLD, deemed to be University Vijaypura, to deliver the welcome address.
Thank you, Lavanya. A doctor is not negligent if he is acting in accordance with a practice accepted as proper by a reasonable body of medical men skilled in that particular art, merely because there is a body of such opinion that takes a contrary view. Lord Justice McNair. Good morning, one and all. Dignitaries on and off the dais, delegates from various sectors, esteemed colleagues and dear students. Today, we all gathered here for the inaugural session of one-day national level seminar on law relating to medical negligence, jointly organized by Karnataka Institute for Law and Parliamentary Reforms, that is KILPAR, Bengaluru, and BEd deemed to be University's School of Law, Vijaypura. Due to the unavoidable circumstances, it is not possible for our Honorable Chancellor, Sri B.M. Patil Sir, and Honorable Pro-Chancellor, Professor Dr. Y.M. Jaira Sir, to attend today's national level seminar on law relating to medical negligence. However, they have communicated their best wishes for the grand success of today's event. It is my immense pleasure to extend a warm welcome to the dignitaries of today's function. First of all, on behalf of BEd deemed to be University's School of Law and KILPAR, I extend a warm welcome to the chief guest of today's function, Professor Dr. Arun C. Ramdar Sir, Honorable Vice Chancellor, BEd deemed to be Vijaypura. I extend a warm welcome to the President of today's function, Professor Dr. C.S. Patil sir, Director, Kilpar, Bengaluru. Welcome sir. I extend a warm welcome to the guest of honor, Dr. R.V. Kulkarni sir, Registrar, B.Ed. Deemed University, Vijayapur. Welcome sir. I extend a warm welcome to Dr. Evaya Vadia, Research Head, Kilpar, Bengaluru. Welcome sir. I extend a warm welcome to the resource persons of today's function, Dr. Yogananda Reddy sir, Vice President, Karnataka Medical Council, Ballari. Welcome sir. I extend a warm welcome to another resource person, Dr. Pawan Kumar Patil, Member, KMC, Weather. Welcome sir. Also, I extend a warm welcome to another resource person, Dr. Babu Bada Patil, Associate Professor, PM Salgapur College of Law, Goa. Welcome sir. I extend a warm welcome to the Superintendent of Police, Vijayapura, Sri Lakshman Nimbarigi sir. Welcome sir. I extend a warm welcome to the police officers of Vijayapura district. I welcome the principals and professors of law colleges and other professional colleges. I extend a warm welcome to the delegates from various colleges of Karnataka. I welcome the students of B.Ed. DU's constituent colleges. I welcome the special invitees and medical persons and also media persons. I welcome the teaching and non-teaching staff of our college. Last but not the least, I welcome the students of our School of Law. Thank you. Thank you.
Thank you, sir, for your warm and gracious words of welcome. I also welcome Professor Dr. Archie Kulkarni, Dean and Principal, School of Law, for this auspicious function. I welcome you, sir. Respect for wisdom and experience is the foundation of academic excellence. We shall now proceed to the garlanding ceremony as a mark of honor and respect to our esteemed dignitaries. I request Ms. Nikita, Lecturer, School of Law, to kindly proceed with the garlanding ceremony.
Now I request Professor Archie Kulkarni, Principal, School of Law, B.Ed. Deemed University, to present garlands to Professor C.S. Patil sir, Director, Kilpar. C.S. Patil sir, Director, Kilpar, to give garlands to Dr. Arun C. Inamdar, Vice Chancellor, B.Ed. Deemed University. Now I request Dr. Nandesh Karpol to present welcome to Dr. Raghavendra V. Kulkarni, Registrar, B.Ed. Deemed University. Now I request Dr. Prasanna Kumar, Librarian, to give welcome to Dr. Ravaya Odiar, Research Head, Kilpar.
Now, I request Dr. Bindu Madhav Endigeri from Forensic Department to felicitate Professor Dr. Archie Kulkarni, Principal and Dean, School of Law. Thank you, sir. I also request Archie Kulkarni, Professor Dr. Principal, School of Law, to felicitate our SP Nimbargi sir. Thank you, sir. Knowledge grows when institutions collaborate. I take great pleasure to inviting Dr. Revaya Vodeyar, Research Head, Kilpar, Bangalore, to deliver the introductory speech.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಕರ್ನಾಟಕ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆ ಹಾಗೂ BLDE ಸಂಸ್ಥೆಯ ಕಾನೂನು ಕಾಲೇಜಿನ ಸಹಯೋಗದಲ್ಲಿ ಇದು ಲಾ ರಿಲೇಟಿಂಗ್ ಟು ಮೆಡಿಕಲ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ರಾಷ್ಟ್ರೀಯ ವಿಚಾರ ಸಂಕಿರಣವನ್ನು ಉದ್ಘಾಟನೆ ಮಾಡಲಿರುವ ಡಾಕ್ಟರ್ ಅರುಣ್ ಸಿ ಇನಾಮದಾರ್ ಸರ್ ಅವರೇ, ಈ ಕಾರ್ಯಕ್ರಮದ ಘನ ಅಧ್ಯಕ್ಷತೆ ವಹಿಸಿಕೊಂಡಿರ್ತಕ್ಕಂತಹ ನೆಚ್ಚಿನ ಗುರುಗಳು, ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ವಿಶ್ರಾಂತ ಪ್ರಾಧ್ಯಾಪಕರು, ವಿಶ್ರಾಂತ ಕುಲಪತಿಗಳು, ಕರ್ನಾಟಕ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆಯ ನಿರ್ದೇಶಕರು ಆಗಿರುವ ಪ್ರೊಫೆಸರ್ CS ಪಾಟೀಲ್ ಸರ್ ಅವರೇ, ನಮ್ಮೊಂದಿಗೆ ಜೊತೆಗೆ ಇರುವ ಡಾಕ್ಟರ್ RV ಕುಲಕರ್ಣಿ ಸರ್, ರಿಜಿಸ್ಟ್ರಾರ್ ಸರ್ ಅವರೇ, ನಮ್ಮೆಲ್ಲರನ್ನ ಅಲ್ಲಿ ಸೇರಿಸಲಿಕ್ಕೆ ಕಾರಣರಾಗತಕ್ಕಂತಹ ಮತ್ತು ಸೇರಿಸ್ತಿರುವ ರಘುವೀರ್ ಕುಲಕರ್ಣಿ ಸರ್ ಅವರೇ, ನೆರೆದಿರುವ ಸಂಪನ್ಮೂಲ ವ್ಯಕ್ತಿಗಳೇ, ವಿದ್ಯಾರ್ಥಿ ಮಿತ್ರರೇ, ಪೊಲೀಸ್ ಇಲಾಖೆಯ ಸಮಸ್ತ ಸಿಬ್ಬಂದಿ ವರ್ಗದವರೇ, ವೈದ್ಯಕೀಯ ಇಲಾಖೆಯ ವೈದ್ಯಕೀಯ ವಿಭಾಗದ ವಿದ್ಯಾರ್ಥಿನಿಯರೇ, ಕರ್ನಾಟಕ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆ 2005ರಲ್ಲಿ ಸ್ಥಾಪಿತವಾಗಿ ನಿರಂತರವಾಗಿ ಕಾನೂನು ವಿಷಯಗಳಲ್ಲಿ ಹೊಸ ಹೊಸ ಆವಿಷ್ಕಾರಗಳನ್ನು, ಅನ್ವೇಷಣೆಯನ್ನು, ಸಂಶೋಧನೆಯನ್ನು ಮಾಡ್ತಾ ಬಂದಿದೆ. ಈ ನಿಟ್ಟಿನಲ್ಲಿ ನಾವು ಜನರಿಂದ ಕಾನೂನುಗಳು ರಚನೆ ಆಗಬೇಕು, ಕೇವಲ ಅಸೆಂಬ್ಲಿಯಲ್ಲಿದ್ದವರು, ಪರಿಷತ್ತಿಲಿದ್ದವರು ಅಷ್ಟೇ ಕಾನೂನುಗಳನ್ನು ರಚನೆ ಮಾಡೋದಲ್ಲ, ಜನರು, ವಿದ್ಯಾರ್ಥಿಗಳು, ಸಂಶೋಧಕರು, ತಜ್ಞರು ರಚನೆ ಮಾಡಿಕೊಡಬೇಕು ಎನ್ನುವ ಪರಿಕ್ರಮದೊಂದಿಗೆ ಈ ಸಂಸ್ಥೆ ಆರಂಭವಾಗಿದೆ. ಇದರ ಅಧ್ಯಕ್ಷರು ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳು, ಇದರ ಉಪಾಧ್ಯಕ್ಷರು ಮಾನ್ಯ ಕಾನೂನು ಸಚಿವರು, ಉಳಿದಂತೆ ವಿಧಾನಸಭೆಯ ಸಭಾಧ್ಯಕ್ಷರು, ವಿಧಾನ ಪರಿಷತ್ತಿನ ಸಭಾಪತಿಗಳು ಇದರ ಪ್ರಮೋಟರ್ಸ್ ಆಗಿರ್ತಾರೆ. ಇಂತಹ ಮಹತ್ವದ ಸಂಸ್ಥೆ 2005ರಿಂದ ಕಾನೂನು ವಿಷಯಗಳನ್ನು ಜನರಿಗೆ ತಲುಪಿಸುವ, ಕಾನೂನುಗಳನ್ನು ರಿಪೀಲ್ ಮಾಡಲಿಕ್ಕೆ ಅವಶ್ಯ ಇದ್ದರೆ ಅದನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಸಲಹೆ ಮಾಡುವ, ರಚಿತವಾದ ಕಾನೂನುಗಳನ್ನು ಜನರಿಗೆ ಮತ್ತು ವಿದ್ಯಾರ್ಥಿ ಸಮುದಾಯಕ್ಕೆ ತಲುಪಿಸುವ ಹೊಣೆಗಾರಿಕೆಯನ್ನು ಅವತ್ತು ಕೆಲಸ ಮಾಡ್ತಾ ಬಂದಿದೆ. ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಸುಮಾರು 300ಕ್ಕೂ ಹೆಚ್ಚು ಸೆಮಿನಾರ್ಗಳನ್ನು ಮಾಡಿದ್ದೇವೆ. ಪ್ರಕಟಣೆ ವಿಷಯದಲ್ಲಿ 85ಕ್ಕೂ ಹೆಚ್ಚು ಮಾಡಿದ್ದೇವೆ. ವಿದ್ಯಾರ್ಥಿಗಳಿಂದ ವಿಧಾನಸಭೆ ಮತ್ತು ಮಾಡೆಲ್ ಸಂಸತ್ತನ್ನು ಮಾಡ್ತಾ ಬಂದಿದ್ದೇವೆ. ಈ ಹೊಸ ಪರಿಕ್ರಮವಾಗಿ 2023ರಿಂದ ಸರ್ಕಾರ ರಚನೆಯಾದ ಸಂದರ್ಭದಿಂದ ಜಾರಿ ಬಂದ ಕಾನೂನುಗಳನ್ನು ತಜ್ಞರಿಂದ ಅವುಗಳಿಗೆ ಅಭಿಮತ ಬರೆಸಿ 100 ಕಾನೂನುಗಳು 100 ಅಭಿಮತ ಎನ್ನುವ ಸಂಪುಟಗಳನ್ನು ಬಿಡುಗಡೆ ಮಾಡಿ ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಿಗೆ ಸಮರ್ಪಣೆ ಮಾಡಿದ್ದೇವೆ. ಹೊಸ ವಿಷಯವಾಗಿ ತಮ್ಮಂತಹ ಸಂಶೋಧನಾ ತಂಡಗಳ ಮೂಲಕ ಕಾನೂನನ್ನು ರಚನೆ ಮಾಡಿ ಆ ಕಾನೂನುಗಳು ಜಾರಿಗೆ ಬೇಕು, ಮುಂದಿನ ಭವಿಷ್ಯದ ಕರ್ನಾಟಕಕ್ಕೆ ಕಾನೂನುಗಳು ಬೇಕು ಎನ್ನುವ ಉದ್ದೇಶದಿಂದ 105 ಕಾನೂನುಗಳನ್ನು CS ಪಾಟೀಲ್ ಸರ್ ಅವರು ಮಾನ್ಯ ಕಾನೂನು ಸಚಿವರ ಮೂಲಕ ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಿಗೆ ಸಮರ್ಪಿಸಿದ್ದೇವೆ. ಆ 105 ಕಾನೂನುಗಳಲ್ಲಿ 80 ಕಾನೂನುಗಳು ಯೋಗ್ಯವಾಗಿವೆ, ಅವುಗಳ ಜಾರಿ ಮಾಡುತ್ತೇವೆ ಎಂದು ವಿವಿಧ ಇಲಾಖೆಗಳು ಅವುಗಳಿಗೆ ಅನುಷ್ಠಾನಕ್ಕೆ ಅಣಿಯಾಗಿವೆ. ಇಂತಹ ಮಹತ್ವದ ಸದುದ್ದೇಶದೊಂದಿಗೆ ಸಂಸ್ಥೆ ನಿರಂತರವಾಗಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದೆ. ನಿಮ್ಮ ಮೂಲಕ ಇನ್ನೂ ಯಾವುದೇ ಕಾನೂನುಗಳು, ಇಂತಹ ಕಾನೂನು ತಿದ್ದುಪಡಿಗೆ ಅಗತ್ಯವಿದೆ ಎನ್ನುವ ವಿಷಯವಾಗಲಿ, ಇಂಥ ವಿಷಯದಲ್ಲಿ ಕಾನೂನು ಇಲ್ಲ, ಕಾನೂನು ಬೇಕು ಎನ್ನುವ ವಿಷಯವಾಗಲಿ, ಅಥವಾ ಬೇರೆ ರಾಜ್ಯದಲ್ಲಿ ಕಾನೂನು ಇದೆ, ಇಲ್ಲಿ ನಮಗಿಲ್ಲ ಅನ್ನೋದಾಗಲಿ, ಇಂತಹ ವಿಷಯಗಳೇನಾದರೂ ಇದ್ದರೆ ದಯವಿಟ್ಟು ನಮ್ಮ ಸಂಸ್ಥೆಗೆ ತಿಳಿಯಪಡಿಸಿ ಅವುಗಳ ಬಗ್ಗೆ ಸಂಶೋಧನೆ ಮಾಡಿ ಸರ್ಕಾರಕ್ಕೆ ವರದಿ ಮಾಡುವಂತೆ ನಾವು ಕೆಲಸ ಮಾಡುತ್ತೇವೆ. ಈ ಮುಖೇನ ಲಾ ರಿಲೇಟಿಂಗ್ ಮೆಡಿಕಲ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಏನಿದೆಯಲ್ಲ, ಇದು ಕಾನೂನು ವಿಚಾರದಲ್ಲಿ ಅನೇಕ ತೊಡಕುಗಳು ಕ್ಷೇತ್ರದಲ್ಲಿ ಗೊತ್ತಾಗ್ತಾ ಇದೆ. ಅದು ಪೊಲೀಸ್ ಇಲಾಖೆ, ವೈದ್ಯಕೀಯ ಇಲಾಖೆ ಮತ್ತು ಕಾನೂನು ಇಲಾಖೆ, 3 ಇಲಾಖೆಗಳು ಈ ವಿಷಯದಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸಬೇಕಾದ ಅಗತ್ಯವಿದೆ. ಅದು ಎಲ್ಲಿ ತೊಡಕು ಆಗ್ತಾ ಇದೆ ಅಥವಾ ಎಲ್ಲಿ ಏನಾದರೂ ತಿದ್ದುಪಡಿ ಅಗತ್ಯವಿದೆಯೇ, ಈ ವಿಚಾರಗಳು ಇಂದು ಚರ್ಚೆ ಆಗಬೇಕಾಗಿದೆ. ಅವುಗಳನ್ನ ತಜ್ಞರು ಚರ್ಚೆ ಮಾಡಬೇಕು ಮತ್ತು ವಿಷಯಗಳನ್ನು ವಿದ್ಯಾರ್ಥಿ ತಲುಪಿಸಬೇಕು. ಇಂತಹ ವಿಷಯಗಳನ್ನ ಇವತ್ತು ಪಡೆದುಕೊಳ್ಳ್ರಿ. ಫಲಾನುಭವಿಗಳು ತಾವಾಗಲಿ ಅಂತ ಹೇಳುತ್ತಾ ಈ ಎರಡು ಸಂಸ್ಥೆಗಳಿಂದ ತಮಗೆ ಈ ಕಾರ್ಯಕ್ರಮ ಆಯೋಜಿಸಲಾಗಿದೆ. ಆಯೋಜನೆಗೆ ಅವಕಾಶ ಮಾಡಿರ್ತಕ್ಕಂತಹ ಈ ವಿಶ್ವವಿದ್ಯಾಲಯಕ್ಕೆ ನೆರೆದಿರುವ ತಮಗೆ ನನ್ನ ಮಾತುಗಳನ್ನು ತಮಗೆ ವಂದಿಸಿ ನನ್ನ ಮಾತು ಮುಗಿಸ್ತಾ ಇದ್ದೇನೆ. ಜೈ ಹಿಂದ್, ಜೈ ಕರ್ನಾಟಕ.
Thank you, sir, for setting the tone for the seminar with your insightful introduction. Darkness cannot drive out darkness. Only light can do that, as rightly said by Martin Luther King. Lighting the lamp symbolizes the removal of ignorance and the spread of knowledge. I now request all the dignitaries on the dais to kindly come forward for the lighting of the lamp.
मोहन भाई ಸ್ವಲ್ಪ ಸ್ವಲ್ಪ
Thank you all. Everyone, please take your seats. Thank you all.
सर थैंक यू.
In the field of medical negligence, the law strives to balance two important values, the protection of patents and the dignity of medical professionals. It is now my privilege to invite our chief guest, Dr. Arun C. Inamdar, Honorable Vice Chancellor, BLD, deemed to be University, to deliver the speech.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. The dignitaries on the dais and off the dais. First, I bring the wishes from President of our association, Sri M.B. Patil, the Honorable Minister, and our Chancellor, Sri B.M. Patil. And from University, myself, the Vice Chancellor of the University, brings wishes to all the delegates who have assembled here. First, I must thank the School of Law principal and his team for organizing every month one or the other such seminars, and I really congratulate them. ನಾನು ಕನ್ನಡ ಮತ್ತು ಇಂಗ್ಲೀಷ್ ಎರಡೂ ಮಿಕ್ಸ್ ಮಾತಾಡ್ತಾ ಇರ್ತೀನಿ. ನೋಡು, ಕೆಲವೊಮ್ಮೆ ಮಾತೃಭಾಷೆಯಲ್ಲಿ ಹೇಳಿದರೆ ಬಹಳ ತಡ್ತದೆ, ಕೆಲವೊಮ್ಮೆ ಮಾತೃಭಾಷೆಯಲ್ಲಿ ಹೇಳಲಿಕ್ಕೆ ಆಗಲಾದಂಥ ವಸ್ತುಗಳು ಅಥವಾ ವಿಷಯಗಳಿದ್ದದನ್ನು ಇಂಗ್ಲೀಷ್ನಲ್ಲಿ ಹೇಳಲಿಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡ್ತೀನಿ. ಇದು ಒಂದು ಈ ನ್ಯಾಷನಲ್ ಲೆವೆಲ್ ಸೆಮಿನಾರ್, ಲಾ ರಿಲೇಟಿಂಗ್ ಟು ಮೆಡಿಕಲ್ ನೆಗ್ಲಿಜೆನ್ಸ್. ಈಗಾಗಲೇ ಅವರು ಹೇಳಿದರು ಸರ್, ಒಡೆಯರ್ ಸರ್ ಭಾಳ ಚೆಂದ ಹೇಳಿದರು. ಅಂದರೆ ಆಲ್ರೆಡಿ ಅವ್ರು ಡಿಸೈಡ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ, 3 ಮಂದಿ ನಡುವೆ ಡಾಕ್ಟರ್ಗಳೇ ಇರಬೇಕು, ಲಾ, ಪೊಲೀಸ್ ಮತ್ತು ಪಬ್ಲಿಕ್. ಸೊ ಇದು ಆಲ್ರೆಡಿ ನಾವು ವಿಕ್ಟಿಮ್ This seminar is on the laws relating to the medical negligence. That means there will be a discussion about the laws which are related to already the medical negligence. You think that already we have done a mistake and things are going to be discussed. I will discuss in two parts. One, I am not a law expert, but some names where we are supposed to, as a doctor, if there are few of us are doctors here, and also the other officials also should understand what we know also minimum. And second thing, how being a doctor myself and the fellow doctors here, how we can protect ourselves from getting trapped in this triangle. So this is more important than reading the law related to the medical negligence. This is what I believe. Medicine today is practiced in an environment very different from what it was few decades ago. ಇದಕ್ಕೆ ಏನು ಹೇಳ್ತಾರೆ, ದೇವರಿದ್ದಂಗೆ, ಈಗಲೂ ನಮ್ಗೆ ದೇವರಿದ್ದಂಗೆ ಅಂತ ಕೆಲವೊಬ್ರು ಹೇಳ್ತಾರೆ. ಅವರು ನೀನೇ ಹೊಟ್ಟೆಗೆ ಹಾಕೋಬೇಕಪ್ಪ, ಎಲ್ಲ ದೇವರಿದ್ದಂಗೆ. ನಾ ಹೇಳ್ತೀನಿ, ದೇವರಿದ್ದಂಗೆ ಅಲ್ಲ ನಾವು. ಯಾಕಂದ್ರೆ ಅದು ದೇವ್ರ ಕಲ್ಪನೆ ಕಲ್ಲ ಅಂತ ತಿಳ್ಕೊ, ಏನಾರ ಒಂದು ತಿಳ್ಕೊ, ಒಂದು ವಸ್ತು ಅಂತ ತಿಳ್ಕೊ, ಅದು ಮಾತಾಡೋದಿಲ್ಲ. ಇದು ನಾವು ಮಾತಾಡಬೇಕಾಗ್ತದೆ. ದೇವರೆಲ್ಲ ದೇವ್ರು ಹೇಳಿ ನಮಗೊಂದು ಇದು ಕೆಲಸ ಕೊಟ್ಟ, ಈ ಥರ ನೀವು ಕೆಲಸ ಮಾಡಿರಿ. ಕೆಲವೊಬ್ಬರು ಹೇಳ್ತೀವಿ ನಾವು, ಭಾಳ ದಿವಸದಿಂದ ಭಾಳ ಕೆಲಸ ಮಾಡತ್ತೀರಿ ನೀವೆಲ್ಲ ಡಾಕ್ಟ್ರುಗಳು. ಕರೆಕ್ಟ್. ನಾ ಹೇಳಿದೆ, ದೇವರು ಯಾವಾಗ ಏನು ಶಿಕ್ಷೆ ಕೊಡಬೇಕಾಗಿತ್ತಂದ್ರೆ ಅವ್ರು ಹೇಳ್ತಾರಂತ, ಫಸ್ಟ್ ಅಂದ್ರೆ ಡಾಕ್ಟರ್ ಆಗಿಬಿಡ್ನಿ, ಆದರೆ ಯಾವಾಗ ಏನೋ ಟೈಮ್ ಗೀಮ್ ಏನೂ ಇಲ್ಲ, ಯಾವಾಗಲೂ ಕೆಲಸ ಮಾಡಬೇಕು. ಮೋಸ್ಟ್ ಪ್ರಾಬಬ್ಲಿ ಸರ್ ನಗ್ಲಾಗತ್ತಾರೆ, ಲಕ್ಷಣ ನಿಬ್ಬರಿಗೆ ಸರ್ ನೆಕ್ಸ್ಟ್ ಶಾಪ್ ಅಂತಂದ್ರೆ ಮೋಸ್ಟ್ಲಿ ಪೊಲೀಸ್ ಇರ್ಬೋದು. ಸೊ ಆ ದಿನಗಳು ಹೋಗ್ಯಾವ. ಈಗ ಡಾಕ್ಟರ್ಗಳು ದೇವರು ಅನ್ನುವಂಥ ಯಾಕೆ ಅಂತಂದರೆ ಪೇಷಂಟ್ ಅವೇರ್ನೆಸ್ ಇಸ್ ಮೋರ್. ಅವ್ರ ಬಗ್ಗೆ ತಮ್ಮ ಬಗ್ಗೆ ತಪ್ಪು ತಿಳುವಳಿಕೆನೇ ಹೆಚ್ಚಿರ್ತಾವೆ. ಈಗೆಲ್ಲ ಗೂಗಲ್ ಡಾಕ್ಟರ್ಗಳು ಬರ್ತಾರೆ, ಅದನ್ನು ತಿಳ್ಕೊಂಡು ತಾವೇ ಡಯಾಗ್ನೋಸ್ ಮಾಡ್ಕೊಂಡು ಬಂದಿರ್ತಾರೆ. ಅವ್ರು ಎಲ್ಲರಿಗೂ ಅದನ್ನು ಹೇಳೋದಿಲ್ಲೋ ಅವ್ರಿಗೆ ಸಮಾಧಾನ ಆಗೋದಿಲ್ಲ. ಬಟ್ ಅದು ಸತ್ಯದೋ ನಿತ್ಯದೋ ಅದನ್ನು ಅವ್ರಿಗೆ ತಿಳಿಯಾಕೆ ಹೋಗ್ಬೇಕಂದ್ರೆ ಅದು ಇಷ್ಟು ಟೈಮ್ ತೊಗೋತದಂದ್ರೆ ಅದು ಡಿಫಿಕಲ್ಟ್ ಟಾಸ್ಕ್. ನಿಮಗೊಂದು ಉದಾಹರಣೆ ಹೇಳ್ತೀನಿ. ಅವರು ಒಂದು ಸರ್ಪುಣ್ಣಾಗಿದೆ, ಹರ್ಪಿಸ್ ಜೋಸ್ಟರ್ ಅಂತ ಇಂಗ್ಲೀಷ್ನಾಗ ಕರಿತೀವಿ. ಅವ್ರು ಪೇಷಂಟ್ಗಳು ಬರ್ತಾರೆ, ನಾವು ನೋಡಿದೆ ಸರ್ಪುಣ್ಣಾಗಿದೆ, ಏನಾಗೋದಿಲ್ಲ, ಒಂದು ವಾರ ಗುಳಿಗೆ ತಗೋ ಹೋಗಿಬಿಡ್ತದೆ. ಸರ್ಪುಣ್ಣಾಗಿದೆ ಸರ್ ಅಂದ್ರೆ ಒಮ್ಮೆ ಎದೆ ಹೊಡ್ಕೊಂಡಂಗೆ. ಯಾಕಂದ್ರೆ ಅವ್ರು ಊರಾಗ ಹೇಳಿರ್ತಾರೆ, ಅದು ಭಾಳ ಕೆಟ್ಟ, ಅದು ಕುತ್ತಿಗೆ ಸುತ್ತದ, ನೀ ಸತ್ತು ಬಿಡ್ತಿ ಅಂತ. ಅವರು ಒಂದು 10 ಸರಿ ಕೇಳ್ತಿರ್ತಾರೆ, ಬಟ್ ಏನಾಗೋದಿಲ್ಲ ಸರ್, ಏನೂ ಆಗೋದಿಲ್ಲ, ನಮಗೆ ತಲೆಯಾಗ ಬತ್ತಿ ಆಗಿರ್ತದೆ ಆಲ್ರೆಡಿ. ಇವ್ರು ಏನು ವಿಚಾರ ಮಾಡಾಕ್ತಾರೆ, ಆ ವಿಚಾರ ಹೇಳೋದಕ್ಕೆ ಅವನಿಗೆ ಸಮಾಧಾನ ಆಗೋದಿಲ್ಲ. ನೀವು ಬೇಕಾದ ಗುಳಿಗೆ ಬರೀರಿ. ನಾ ಏನು ಹೇಳ್ತೀನಿ, ನನ್ನ ಪರ್ಸ್ನಲ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಹೇಳ್ತೀನಿ. ಯಾವಾಗ ನೋಡಪ್ಪ, ಇದರಿಂದ ಮಾತ್ರ ನೀವು ಸಾಯೋದಿಲ್ಲ, ನಾನು ಮತ್ತು ನೀನು ಬೇರೆ ಕಾರಣದಿಂದ ಸಾಯ್ಬೋದು. ಸೊ ಇದ್ರ ಬಗ್ಗೆ ಏನೂ ಚಿಂತೆ ಮಾಡಬೇಡ. ಯಾಕೆ ಮೊದಲು ನಾನು ಹೇಳ್ಕೋಬೇಕು, ಅವನ ಕೊನೆ ಸಾಯ್ತಾನೆ ಅಂತಂದ್ರೆ ಮತ್ತವನಿಗೆ ಬೇಜಾರಾಗ್ತದೆ. ಫಸ್ಟ್ ಏನು ಹೇಳ್ತೀನಿ, ಇದರಿಂದ ಸಾಯೋದಿಲ್ಲ, ಬಟ್ ಬೇರೆ ಕಾರಣದಿಂದ ನಾನು ಹೋಗ್ತೀನಿ, ನೀನು ಹೋಗ್ತೀನಿ, ಏನು ಚಿಂತೆ ಮಾಡಬೇಡ. ಸೊ ಅವರು ರೆಡಿಯಾಗಿ ಬಂದಿರ್ತಾರೆ, ಹೀಗೆ ಹೇಳಬೇಕು ಡಾಕ್ಟರ್ ಇವರು. ಸೊ ಇಂಥ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ನಾವಿದ್ದೀವಿ. ಇದೆಲ್ಲ ಏನು ಇನ್ಫಾರ್ಮೇಷನ್ ಏನು ಈ ಸೋಷಿಯಲ್ ಮೀಡಿಯಾ ಅಂದರೆ ವಾಟ್ಸಪ್ ಯೂನಿವರ್ಸಿಟಿ ಒಳಗೆ ಅವ್ರು ಏನು ತಿಂದ್ರೆ ಏನಾಗ್ತದೋ ಏನೇನೋ ಹೇಳ್ತಿರ್ತಾರೆ. ಅವ್ರು ಬರ್ತಾರೆ, ಖಾವಾಗ್ಯದ್ರಿ ನಮಗೆ. ಖಾವಾಗ್ಯಂದ್ರೆ ನಾ ಹೇಳ್ತೀನಿ, ಸ್ವಲ್ಪ ಥಂಡಿನ ಕೂತ್ಬಿಡು, ಹೋಗ್ಬೋದು ಜಡ್ನಿ ಅಂತ. ಕೆಲವೊಮ್ಮೆ ಹಂಗೆ ನಗಸ್ಕೋತ ಹೇಳಿ ಅವ್ರಿಗೆ ನಾವು ಸೈನ್ಸ್ ಅಥವಾ ವಿಷಯನ ಅವರು ಓದಿರಂಗಿಲ್ಲ, ನಾವು ಓದಿರ್ತೀವಿ. ಸೊ ಅವ್ರಿಗೆ ಒಮ್ಮೆ ಅವನಿಗೆ ಹೇಳಕ್ಕೆ ಬರುವುದಿಲ್ಲ, ಒಂದು ಇಂಜೆಕ್ಷನ್ ಕೊಟ್ಬಿಟ್ರೆ ಜಟ್ನಿ ಎಲ್ಲ ಹೋಗಿಬಿಡ್ತದಂತ. ಖರೆ ಆ ಜಡ್ಡಿಗೆ ಇಂಜೆಕ್ಷನ್ ಇಲ್ಲ, ಬರೀ ಗುಳಿಗೆ ಅದಾವ, ಅದರಲ್ಲಿ ತೊಗೊಂಡ್ರೆ ಚಲೋ ಆಗ್ತದೆ ಅಂತ ಹೇಳೋ ಕರ್ತವ್ಯ ನಮ್ದದು. ಪ್ರಾಬಬ್ಲಿ ಇವೆಲ್ಲ ನಾವು ಮಾಡಿದ್ರೆ ಆ ಟ್ರ್ಯಾಂಗಲ್ದಾಗ ನಾವು ಸಿಕ್ಕೊಳ್ಳೋದಿಲ್ಲ ಅಂತ ನನಗೆ ಅನಿಸ್ತದೆ. ಬಟ್ ಎ ಮೇಜರ್ ಟರ್ನಿಂಗ್ ಪಾಯಿಂಟ್ ಆಕರ್ಡ್ ವೆನ್ ಮೆಡಿಕಲ್ ಸರ್ವಿಸ್ ವೆರ್ ಬ್ರಾಟ್ ಅಂಡರ್ ದಿ ಕನ್ಸ್ಯೂಮರ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆ್ಯಕ್ಟ್ ಫಾಲೋವಿಂಗ್ ದಿ ಲ್ಯಾಂಡ್ಮಾರ್ಕ್ ಜಜ್ಮೆಂಟ್ ಇನ್ ಇಂಡಿಯನ್ ಮೆಡಿಕಲ್ ಅಸೋಸಿಯೇಷನ್ ವರ್ಸಸ್ BP ಶಾಂತ. ಅವಾಗಲಿಂದ ಏನಾಯಿತು, ಈ ಮೆಡಿಕಲ್ ಪ್ರೊಫೆಷನ್ ನೋಬೆಲ್ ಪ್ರೊಫೆಷನ್ ಹೋಗಿ ಅಗ್ನಿ ಬಿಜಾಪುರ ಭಾಷೆ ಹೇಳ್ಬೇಕಂದ್ರೆ ಅದೊಂದು ದಂಧ ಇದೆ. ನೀವು ರೊಕ್ಕ ತೊಗೊಂಡಿರಿ, ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿರಿ, ನಾವೊಂದು ಹೇಳಿರ್ತೀವಿ, 1 ತಿಂಗಳು ತೊಗೋರಿ ಚಲೋ ಆಗ್ತದೆ. 3 ದಿವಸನಾಗ ಬರ್ತಾನೆ, 1 ತಿಂಗಳಾದ್ಮೇಲೆ ಬರ್ತಾನೆ. ಮೊನ್ನೆ ಬಂದಿದ್ದೇವಲ್ರಿ ಡಾಕ್ಟ್ರುಗಳು ಬಂದು ಎಂದೂ ಈ ಮೊನ್ನೆ ನಿನ್ನೆ ಏನೂ ಅನ್ನಬಾರ್ದು. ಮೊನ್ನೆ ಅಂದ್ರೆ 3 ದಿವಸ ಬಂದಿದ್ರೆ ಮತ್ತೆ ಯಾಕೆ ಬಂದಿ ಅಂತ ಕೇಳ್ತೀವಿ. ಸೊ 3 ದಿವಸ ಟ್ರೀಟ್ಮೆಂಟ್ ಇರೋಂಗಿಲ್ಲ. ರಣಿ ಇತ್ತಂದ್ರೆ ಹೇಳ್ತೀವಿ 3 ದಿವಸ ತಗೋರಿ, ಆಮೇಲೆ ಅದು ಸರಿಯಾಗಿ ಹೋಗ್ತದೆ. ಸೊ ಇಂಥ ತಿಳುವಳಿಕೆಗಳು ಸಹಿತ ನಾವು ತಿಳುವಳಿಕೆ ಕೊಡಬೇಕಾಗ್ತದೆ. ಸೊ ಯಾವಾಗಿದು ಲೈನ್ ಶುರು ಆಯಿತು ಅವಾಗ ಡಿಫೆನ್ಸಿವ್ ಪ್ರಾಕ್ಟೀಸ್ ಶುರು ಆಗ್ಲಿಕ್ಕಾಗ್ತದೆ. ಡಿಫೆನ್ಸಿವ್ ಅಂದರೆ ಏನು? ಈ ನನ್ನ ಕಡೆ ಒಂದು ಸೀರಿಯಸ್ ಪೇಷಂಟ್ ಬಂತು, ನೋಡ್ದಂಗೆ ಮಾಡಿ ಎಲ್ಲ ಮಾಡಿ, ಮೋಸ್ಟ್ಲಿ ಇದಕ್ಕೆ ಇಲ್ಲೇ ಬಿಜಾಪುರದಾಗ ಆಗ್ಬೋದು, ಬಟ್ ರಿಸ್ಕ್ ತೊಗೊಂಡು ಆ ದಿವಸ ನನ್ನ ತಲೆ ತಿನ್ಬೋದು. ಮುಂದೆ ಅವ್ರು ಯಾರ್ಯಾರೇ ಹಕ್ಕಿ ವಕೀಲ ಅಂತ ಲಾಯರ್ ಅವ್ನು ಬಿಡಬೇಡವನ್ನ ತನ್ನವ್ರು ಯಾರು ಇದ್ರೆ ಅಂದ್ರೆ ಅವ್ರು ಒಳ್ಳೆ ಸಜೆಷನ್ ಕೊಡ್ತಾರೆ ಯಾವಾಗ ನಮ್ಗೆ, ಅದು ಬೇರೆ. ಸೊ ಅವಾಗ ನಾವು ಡಿಫೆನ್ಸಿವ್ ಆಗ್ತೀವಿ. ಏನು ಆಗ್ತೀವಿ? ಮುಂದಕ್ಕೆ ಹೋದ್ರೆ ಸಾಕು. ಇಲ್ಲ ನೋಡೀನಿ, ನನಗೆ ಅನಿಸ್ತದ ಒಂದು ಸ್ವಲ್ಪ ಇದಕ್ಕೆ ಬೇರೆ ಇದು ಬೇಕು, ನಮ್ಮಲ್ಲಿ ಅದು ಮಷಿನ್ ಅಥವಾ ಟ್ರೀಟ್ಮೆಂಟ್ ಸ್ವಲ್ಪ ಇದು ಆಗ್ತದೆ, ಈ ಬಿಜಾಪುರದವ್ರು ಏನಂದ್ರೆ ಸೋಲಾಪುರಕ್ಕೆ ಹೋಗ್ಬಿಡ ಅಂತ ಹೇಳಿಬಿಡ್ತೀವಿ. ಸೋಲಾಪುರದವರು ಪುನಾಗೆ ಕಳಿಸ್ತಾರೆ, ಪುನಾದವರು ಬಾಂಬೆಗೆ ಕಳಿಸ್ತಾರೆ. ಸೊ ಇದು ಡಿಫೆನ್ಸಿವ್ ಪ್ರಾಕ್ಟೀಸ್ ಆಗಿ ಸಿಗಬೇಕಾದ ಸೌಲಭ್ಯ ಸಿಗಲಿಕ್ಕಿಲ್ಲ. ಒಂದು ಭಾಳ ಸರಿ ಏನಾಗ್ತದೆ, ಇಲ್ಲಾಂದ್ರೆ ಏನು ಮಾಡ್ತಾರೆ, ನೀವು ಎಲ್ಲರೂ ಕೆಲವರಿಗೆ ಅನುಭವ, ಇದು ಸತ್ಯವಾಗಿದ್ದು ಹೇಳ್ತೀನಿ. ನಮ್ಮ ಕಡೆ ಯಾರೋ ಬಂದಿರ್ತಾರೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್, ಭಯಂಕರ ಉದ್ದೆಲ್ಲ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಬರ್ದಾರ್ರಿ, ಎಲ್ಲ ಮಾಡಿಸ್ಕೊಂಡು ನೋಡ್ರಿ ಅಂತಾರೆ. ಅದೂ ಡಿಫೆನ್ಸಿವ್ ಪ್ರಾಕ್ಟೀಸೇ. ಮುಂದೆ ನಾವು ಲಾಯರ್ ಸಾಹೇಬ್ ಅಲ್ಲಿ ಹೋದಾಗ ಕಟ್ಕಟ್ಟೆ ನಿಂತ ಕೇಳ್ತಾರೆ, ಅದು ಯಾಕೆ ಪರೀಕ್ಷೆ ಮಾಡಲಿಲ್ಲ? ನಾ ಹಂಗೆ ತಿಳ್ಕೊಂಡೆ ಸರ್. ತಿಳ್ಕೊಳ್ಳೋದಲ್ಲ ಸರ್, ಇಲ್ಲಿ ಬರ್ದಿರೇನು ಅಂತ ಕೇಳ್ತಾರೆ ಅವರು. ಸೊ ಇಂಥವೆಲ್ಲ ವಿಷಯಗಳು ಸಹಿತ ಇದು ಎರಡೂ ಮಕ್ಕಳು ಹೇಳಕತ್ತೀನಿ ನಾನು. ನನ್ನ 35 ವರ್ಷ ಪ್ರಾಕ್ಟೀಸ್ ಅನುಭವ ಪ್ಲಸ್ ಜನರ ಅಪೇಕ್ಷೆಗಳೇನಿರ್ತಾವ ಅವತ್ತನ್ನು ಹ್ಯಾಂಗೆ ನಾವು ಡ್ರೌಸ್ ಮಾಡ್ತೀವಿ, ಯಾವ ರೀತಿಯಲ್ಲಿ ಇದು ಮೊಬೈಲ್ ಪ್ರೊಫೆಷನ್ ಹೋಗಿ ದಂಧ ಯಾವಾಗ ಶುರು ಆಯಿತು ಅನ್ನೋದಕ್ಕೆ ನಿಮಗೆ ಇದು ತಿಳುವಳಿಕೆ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. Then the first medical negligence litigation has become more common. However, the Supreme Court in Jacob Matthew and State of Punjab clarified that negligence must be judged based on whether a doctor acted according to accepted medical standards. ಇದು ಬಹಳ ಇಂಪಾರ್ಟೆಂಟ್. ಈಗ ಒಂದು ಯಾವುದೋ ಒಂದು ಕಾಯಿಲೆ ಇರ್ತದೆ, ಆ ಮೆಡಿಕೇಶನ್ ಕೊಟ್ಟಾನೇನಲ್ಲ ಅಷ್ಟೇ, ಆ ಕೊಟ್ಟ ಮೇಲೆ ಬೈ ಚಾನ್ಸ್ ಏನಾರೇ ಅದರದ್ದು ನೋನ್ ಸೈಡ್ ಎಫೆಕ್ಟ್ಸ್ ಇರ್ತಾವೆ, ಅನ್ನೋನ್ ಸೈಡ್ ಎಫೆಕ್ಟ್ಸ್ ಇರ್ತಾವೆ, ಅದ್ರ ಬಗ್ಗೆ ನಾವು ಇಲ್ಲ ಹಿಂಗೆ ಆಗ್ಬೋದು ಅಂತ ತಿಳುವಳಿಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಒಂದು ಗುಳಿಗೆ ಕೊಡ್ತೀವಿ, ರಿಫ್ಯಾಮಿಸಿನ್ ಅಂತ ಒಂದು ಗುಳಿಗೆ ಇರ್ತದೆ. ಅವ್ರಿಗೆ ಕೊಟ್ಕೊಳ್ಳೆ ನಾವು ಹೇಳಬೇಕು, ಕಾಲ್ಮಡಿ ಕೆಂಪು ಹೋಗ್ತಾವೆ, ಇಲ್ಲಾಂದ್ರೆ ಮರುದಿವಸ ಏನು ಸರ್ ಎಲ್ಲ ರಕ್ತ ಬೀಳಕತ್ತದ ಅಂತ ಮನೆ ನಮ್ಮ ಕಡೆ ಬಂದು ಭೇಟಿ ಆಗ್ತಾನೆ. ಅದು ಎಂಗ್ಸೈಟಿ ಆಯಿತು. ಅವು ಬಂದು ಭೇಟಿ ಆದರೆ ಭಾಳ ಚಲೋ ಆಯಿತು. ಅಕಸ್ಮಾತ್ ಹಕ್ಕಿ ವಕೀಲ ಸಾಹೇಬ್ರ ಭೇಟಿಯಾಗಿ ನೋಡಿ ಸರ್ ಗುಳಿಗೆ ಕೊಟ್ಟನೆಲ್ಲ ರಕ್ತ ಹೊಂಟದ ಏನು ಮಾಡಲಿ, ಹಾಕೋನಿಗೆ ಒಂದು ಕೇಸ್ ಅಂದ್ರೆ ಏನು ಮಾಡೋದು? ಸೊ ಇದು ಬರೀ ತಿಳುವಳಿಕೆ ಪ್ಲಸ್ ಅದು ನಾರ್ಮಲ್ ಅಂತ ಅವನಿಗೆ ಅನಿಸ್ಬೇಕು. ಅದೇ ಗುಳಿಗೆ ಅಕಸ್ಮಾತ್ ನಾವು ಮತ್ತು ದಿವಸ ಕಾಮಣೆ ಆಗ್ಯದ್ರಿ ಅಂತ ಬಂದ ಬರ್ಬೋದು, ಆ ರಿಫ್ಯಾಮಿಷನ್ ಗುಳಿಗೆ ಲಿವರ್ ಮೇಲೆ ಇಫೆಕ್ಟ್ ಮಾಡ್ತದೆ. ಅವಾಗ ನಿಮ್ಮ ಡಾಕ್ಯುಮೆಂಟೇಶನ್ ಬೇಸ್ ಲೈನ್, ಅದಕ್ಕೆ ನಾವು LFT ಅಂದರೆ ಲಿವರ್ ಫಂಕ್ಷನ್ ಟೆಸ್ಟ್ ಮಾಡಿದ್ವಿ, ಅವಾಗ ಎಷ್ಟಿತ್ತು. ಕೆಲವೊಮ್ಮೆ ಗುಳಿಗೆ ಕೊಟ್ಟು 2 ವಾರ ಆದಮೇಲೆ ಕೆಲವೊಂದು ಎಂಜೈಮ್ 2 ಪಟ್ಟು ಹೆಚ್ಚಾಗ್ತವೆ. ಅವಾಗ ಅದನ್ನು ಇಲ್ಲ ಅದನ್ನು ಬಂದ್ ಮಾಡೋನು, ಬೇರೆ ಅದಕ್ಕೆ ಚಿಕಿತ್ಸೆ ಕೊಡೋನು. ಇವೆಲ್ಲ ಈಗ ಹೆಂಗೆ ನೆಕ್ಸ್ಟ್ ಅಂದರೆ ಇದು ಈ ಥರ ಮೆಡಿಕಲ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಲಾ ಮತ್ತು ಹೇಗೆ ಅದನ್ನು ಆಗ್ತಾ ಇದೆ. ಮೂರನೇದು ಅಂತಂದ್ರೆ ಪ್ರಾಪರ್ ಡಾಕ್ಯುಮೆಂಟೇಶನ್ ಇಸ್ ಎಸೆನ್ಷಿಯಲ್. ಇವೇನು ಬರೀತೀರಿ ಅಲ್ಲಿ ಬರೀರಿ. ನಿನ್ನೆ ಒಂದು ಚೈಲ್ಡ್ ಬಂದಿತ್ತು, 3-4 ತಿಂಗಳ ಕೂಸದ, ಯಾರೋ ನೋಡಿದ್ರು ಮುಂದೆ ಆಮೇಲೆ ನಮ್ಮ ಕಡೆ ಬಂದರು. ನಾ ಹೇಳಿದೆ ಇದು ಅಡ್ಮಿಟ್ ಮಾಡಿ ಈ ಥರ ಕೆಲವೊಂದು ಔಷಧ ಕೊಡೋದಿರ್ತದೆ, ಕೊಟ್ಟರೆ ಚಲೋ ಆಗ್ತದೆ. ಅವರು ಬಂದವರಿಬ್ಬರು ಒಬ್ಬರೊಬ್ಬರು ಮುಖ ನೋಡ್ಕೊತ ನಿಂತರು. ನಾ ಹೇಳಿದೆ ಹಿಂಗೆ ವಿಚಾರ ಮಾಡ್ಕೊತ್ಕೊಂಡ್ರದಲ್ಲ, ಇದೇ ಅದಕ್ಕೆ ಕರೆಕ್ಟ್ ಟ್ರೀಟ್ಮೆಂಟು, 5 ನಿಮಿಷ ಟೈಮ್ ಕೊಡ್ತೀನಿ, ಹೊರಗೆ ಹೋಗಿ ಬಂದು ಹೇಳ್ರಿ. ಇಲ್ಲ ಸರ್ ಔಷಧ ಕೊಟ್ಟು ನೋಡ್ರಿ, ಔಷಧ ಕೊಡೋದು ಹಂಗೆ ಇರಂಗಿಲ್ಲ. ಇಲ್ಲ ಸರ್ ಏನ್ರ ಮಾಡಿ. ನಾ ಏನು ಬರ್ದೆ ಎಲ್ಲ ಡಯಾಗ್ನೋಸಿಸ್ ಬರೋದು, ಆಪ್ಷನ್ ಅಡ್ಮಿಷನ್, ಅಡ್ವೈಸ್ ಅಡ್ಮಿಷನ್, patient attenders refused admission on the ground that they will come tomorrow. ಓಕೆ, ಅವ್ರಿಗೆ ಏನು ತಿಳಿತೋ ಮತ್ತೆ 5 ನಿಮಿಷ ಒಳಗೆ ಬಂದು ಇಲ್ಲ ಸರ್ ಮಾಡಿಬಿಡ್ರಿ ಅಂತ. 2 ಆಯ್ತು ಇಲ್ಲಿ. ಒಂದು ಐ ಟ್ರೈ ಟು ಕನ್ವಿನ್ಸ್ ದೆಮ್, ಪ್ಲಸ್ ಐ ಟ್ರೈ ಟು ಸೇವ್ ಮೈ ಸ್ಕಿನ್ ಆಲ್ಸೋ. ಇದು ನಿಮಗೆಲ್ಲ ಅನಿಸ್ತದೆ ನೀವು ಬರ್ದ ನಿಮ್ಮ ಕೆಲಸ ಮುಗೀತು, ಬಟ್ ಐ ಹ್ಯಾವ್ ಟ್ರೈಡ್ ಮೈ ಮ್ಯಾಕ್ಸಿಮಮ್. ಅದನ್ನು ಯಾರು ಈ ವಿಷಯಗಳಿಗೆ ಈ ಇಂಥ ಡಿಸ್ಕಷನ್ನು ಲಾ ತಗೊಂಡ ಅಥವಾ ಪೊಲೀಸವರು ಅದ್ರ ಬಗ್ಗೆ ವಿಚಾರಣೆ ಮಾಡಿದಾಗ ಅದನ್ನು ಅವರು ತುಲನಾತ್ಮಕವಾಗಿ ವಿಚಾರ ಮಾಡ್ತಾರೆ ಡನ್ ಡೌಟ್. ಅದು ಆಗೋದಿಲ್ಲ. ಅವ್ರಿಗೊಂದು ಇದು ಇರ್ತದೆ, ಡಾಕ್ಟರ್ ಹಾಗೆ ಮಾತಾಡ್ತಾನೆ ತಗೋ ಅಂತ ಒಂದು ಫಿಕ್ಸ್ಡ್ ಐಡಿಯಾ ಇತ್ತು ಅಂದರೆ ಡಿಫಿಕಲ್ಟ್. ಆ ಸಿಚುವೇಶನ್ನಲ್ಲಿ ಈಗ ನಾನು ನಿನ್ನಿದೆ ಉದಾಹರಣೆ ಹೇಳಿದೆ, ನಾ ಯಾವ ಥರ ಅವರಿಗೆ ಟ್ರೈ ಟು ಕನ್ವಿನ್ಸ್ ಅನ್ನೋದು ಒಂದು ಇನ್ನೇನಾಗ್ತದೆ ನೆಕ್ಸ್ಟ್ ನಾನು ಹೇಳ್ತೀನಿ. ಪ್ರಾಬಬ್ಲಿ ನಾವು ಏನೇ ಪೇಷಂಟ್ ಎಲ್ಲರಿಗೂ ಒಂದೊಂದು ವಿಡಿಯೋ ಕೊಡಬೇಕು. ನಾವು ಹೆಂಗೆ ಮಾತಾಡಿದೀವಿ ಕೆಲವು ಹಾಗೆ ಆಗ್ತದೆ. ನಾವು ಕೆಲವು ಅಂತಿರ್ತೀವಿ ನಾನು ಜೋಕಿಂಗ್ಲಿ, ಅದು ಹಂಗೆ ಹೇಳಿದ್ದಿಲ್ಲ ಸರ್ ನೀವು, ಹೌದಪ್ಪ ನಾ ಹೇಳೀನಿ ಇಲ್ಲಿ ಬರ್ದೀನಿ, ನೀವು ಹಂಗೆ ಹೇಳಿಲ್ಲ ಅಂದಮೇಲೆ ಹೇಳಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನಿಮ್ಗೆ ವಿಡಿಯೋ ಮಾಡ್ಕೊಂಡು ನಿಂತ್ಕೊಂಡು ನಿಂತಂತ. ಸೊ ಆ ಪರಿಸ್ಥಿತಿನೂ ಬರಬಹುದು. ಸೊ ಇದು ರಿಕಾರ್ಡ್, ಪ್ರಾಪರ್ ಡಾಕ್ಯುಮೆಂಟೇಶನ್ ಇವೆಲ್ಲ ಇಂಪಾರ್ಟೆಂಟ್. ಲಾಸ್ಟ್ ಅಂದರೆ ಇತ್ತೀಚೆಗೆ ನಾವು ಭಾಳ ಸರಿ ಈಗ IMAದವರು ಎಲ್ಲ ಇದು ಪ್ರಾಬ್ಲಮ್ ಗೊತ್ತು. ದಿ increasing violence against healthcare professionals reflecting the growing strain in doctor-patient relationship. ಯಾರಿಗೊಬ್ಬರಿಗೆ ಲಾಸ್ ಆದಾಗ ಭಯಂಕರ ಸಿಟ್ಟಿನಲ್ಲಿ ಇರ್ತಾರೆ, ಬಟ್ ಅವ್ರಿಗೆ ನಾವು ಸೈನ್ಸ್ ಹೇಳಕ್ಕೆ ಹೋಗಿ ಹಿಂಗೆ ಆಗ್ತದೆ ಹಿಂಗೆ ಅಂತೀವಿ ಅಂದ್ರೆ ವೆರಿ ಡಿಫಿಕಲ್ಟ್. ಹೌ ಟು ಡೌಸ್ ಅನ್ನೋದು ನಿಮ್ಗೆ ಆಮೇಲೆ ಹೇಳ್ತೀನಿ. ಮತ್ತು ಯಾರೋ ನಮ್ಮ ಫ್ರೆಂಡ್ ಇವತ್ತು ಮುಂಜಾನೆ ಒಬ್ಬರು ಬೇರೆ ಡಿಸ್ಕಷನ್ದಲ್ಲಿ ಅದು ಬಂದಿರ್ತಾ ರೀಡ್ ದ್ಯಾಟ್ ಆಲ್ಸೋ ಲೇಟರ್. ಸೊ ಇವೆಲ್ಲ ಇದು ನಮಗೆ ನಿಮಗೆ ಜನರಿಗೆ ಮತ್ತು ಡಾಕ್ಟ್ರದು ಹೇಗೆ ರೂಲ್ಸ್ ಶುರುವಾದವು, ನೋಬೆಲ್ ಪ್ರೊಫೆಷನಾಗ ಹೇಗೆ ಇದೊಂದು ಬಿಸ್ನೆಸ್ ಆಯಿತು. ಬಟ್ ಆದರೂ ಸಹಿತ ನಾವೇನ ತೂಗು ಕತ್ತಿ ಒಳಗಿದ್ದಂಗೆ ಬಿಸ್ನೆಸ್ ಆದರೂ ಕೆಲವೊಂದು ನಮನಿ. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಸಿಂಪಲ್ ಹೇಳ್ಬಿಡ್ತೀನಿ, ಯೋಗಾನಂದ ರೆಡ್ಡಿ ಅದಾರ, ನಮ್ಮ ಪವನ್ ಅದಾರ. ಯೋಗಾನಂದ ರೆಡ್ಡಿ ಅವ್ರು ನಮ್ಮ ಕಾಲೇಜ್ದವರು MBBS, ನಾವು ಅವರು ಕೂಡಿ ಕಲ್ತೀವಿ. ನನಗೆ ಒಂದೆರಡು ನಾನು ಜೂನಿಯರ್ ಅನ್ನೋದಿಲ್ಲ, ಕಲಿಗಿದ್ರು ಅವರು. ಪವನ್ ಅವರು ನಮ್ಮ MBBS ಇಲ್ಲೇ ಕಲ್ತಾರ. ಅವರು ಬಿಸ್ನೆಸ್, ಈಗ ಸಿಮೆಂಟ್ ಮಾರಾಮ ಬಿಸ್ನೆಸ್. ಆಮೇಲೆ ಅವ ಒಂದು ಪೇಪರ್ದಾಗ ಕೊಟ್ಟಿರ್ತಾನೆ ವಿದೇಶ ಪ್ರಯಾಣ. ಅವರು ACC ಸಿಮೆಂಟ್ ವತಿಯಿಂದ ಇಷ್ಟು ಅವ್ರು ಮಾರಿದ್ದಕ್ಕೆ ಅವ್ರಿಗೆ ವಿದೇಶ ಪ್ರಯಾಣಕ್ಕೆ ಕರ್ಕೊಂಡು ಹೊಂಟಾರ. NMG ಅವರು ಯಾರೋ ಡಾಕ್ಟರ್ಗಳು ಎದಕ್ಕೋ ತಮ್ಮ ಕಾನ್ಫರೆನ್ಸ್ ಹೋಗಿದ್ರು ಸಹಿತ ಭಾಳಷ್ಟು ಮಂದಿ, ಒಮ್ಮೆ 10 ಮಂದಿ ಹೋಗೋಣ, ನಿಮಗೆ ಯಾರು ಸ್ಪಾನ್ಸರ್ ಮಾಡಿದರು ಡಾಕ್ಟರ್ಗಳಿಗೆ, ಯಾವ ಫಾರ್ಮಸ್ಯೂಟಿಕಲ್ ಕಂಪ್ನಿ, ಒಮ್ಮೆ ದಂಧ ಅಂತಾರೆ, ಒಮ್ಮೆ ಪ್ರೊಫೆಷನ್ ಅದು ನೋಬೆಲ್ ಅದ, ನೀವು ಹಂಗೆ ರೊಕ್ಕ ತೊಗೊಂಡು ಹೋಗ್ಲಕ್ಕೆ ಬರುವುದಿಲ್ಲ. ಸೊ ಇಂಥ ದ್ವಂದ್ವಗಳು ಭಾಳ ಅದ. ನನಗೆ ಅನಿಸ್ತದೆ ಇಂಥದಕ್ಕೂ ಒಂದು ಭಾಳಷ್ಟು ನಾವು ಡಿಸೆಕ್ಟ್ ಅಂದರೆ ಹಡ್ಕೋತ ಹೋದೀವಿ, ಹಿಂಚ್ಕೋತ ಹೋದೀವಿ ಅಂತಂದ್ರೆ ಮನುಷ್ಯತ್ವ ಕಡಿಮೆ ಆಗ್ತದೆ. ನಾ ಹೇಳಿದ್ನಲ್ಲ, ಡಿಫೆನ್ಸಿವ್ ಪ್ರಾಕ್ಟೀಸ್, ಇಲ್ಲೇ ಸಿಗುವಂಥ ಟ್ರೀಟ್ಮೆಂಟ್ ನೀವು ಬಾಂಬೆಗೆ ಹೋಗಿ ತಗೊಳ್ಳೋದ. ಸೊ ಇಂಥ ಪರಿಸ್ಥಿತಿ ಬರ್ಬೋದು. ನನಗೆ ಅನಿಸ್ತದೆ ಈ ಟ್ರ್ಯಾಂಗಲ್ನಲ್ಲಿ ನಾವು ಸಿಗಬಾರ್ದು ಅಂತಂದರೆ ಎಸ್ಕೇಪಿಸಮ್ ಅಲ್ಲ, ಯಾವ ರೀತಿ ಎಚ್ಚರ ಇದ್ದರೆ ನಾವು ಈ ವಿಷಯದ ಬಗ್ಗೆ ಹೆಚ್ಚಿನ ಕಾಳಜಿ ಮಾಡಬಹುದು. ಐ ಹ್ಯಾವ್ ಕಾಲ್ಡ್ ಇಟ್ ಆಸ್ 10 commandments, 10 ಮೆಡಿಕೋ ಲೀಗಲ್ ಕಮಾಂಡ್ಮೆಂಟ್ಸ್ ಫಾರ್ ಡಾಕ್ಟರ್ಸ್. ಇದು ನಮಗೆ ಇನ್ಕ್ಲೂಡಿಂಗ್ ನಮ್ದ. ಇದು ಪೊಲೀಸ್ ಆಫೀಸರ್ಗಳಿಗೆ ಅಂದ್ರೆ ಸರ್ ನಾವು ಎಲ್ಲ ಟ್ರೈ ಮಾಡ್ತೀವಿ, ಆದರೂ ಸಹಿತ ಕೆಲವೊಂದು ಆಗ್ತಿರ್ತದೆ. ಒಮ್ಮೆ ಬಂದ ಕೂಡಲೇ ಸ್ವಲ್ಪ ಆ್ಯಕ್ಷನ್ಸ್ ನಮ್ಮನ್ನು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಮಾಡ್ಕೊಂಡು ತಗೊಳ್ರಿ ಅಂತ ಹೇಳಿ ನಾನು ಹೇಳ್ತೀನಿ. ನೋ ಯುವರ್ ಲಿಮಿಟ್ಸ್, ಪ್ರಾಕ್ಟೀಸ್ ಓನ್ಲಿ ವಿದಿನ್ ಯುವರ್ ಟ್ರೈನಿಂಗ್ ಆ್ಯಂಡ್ ಕಾಂಪಿಟೆನ್ಸ್. ಈಗ ಮೊನ್ನೊಂದು ಈ ಕಂಕಳ ಬಗಲ್ನಾಗ ಒಂದು ದೊಡ್ಡ ಗಂಟು ಆಗೋಪ್ಪ ನನ್ನ ಕಡೆ ಬಂದ. ನಾನು ನೋಡಿದೆ ಅದು ಅಪ್ಸೆಸ್ ಇತ್ತು ದೊಡ್ಡದು, ಸರ್ಜನ್ನೇ ಓಪನ್ ಮಾಡಬೇಕು. ನಾನು MBBS ಓದಿನಿ, ಮಾಡಬಹುದು. ನಾನು ಡರ್ಮಟಲಾಜಿಸ್ಟ್, ಸ್ಕಿನ್ ಸ್ಪೆಷಲಿಸ್ಟು, ನನಗೆ ಆ OT ಸೆಟಪ್ ಇರುವುದಿಲ್ಲ, ನಾ ಮಾಡಬಾರದು. ಎರಡನೇದು, ನನಗೂ MBBS ನಾಲೆಜ್ ಗೊತ್ತು, ಒಂದು ಆ್ಯಂಟಿಬಯೋಟಿಕ್ ಕೊಟ್ಟು ಹೆಂಗಾದ್ರೂ ರೋಗ ಕೊಟ್ಟಾನ ಒಂದು 5 ದಿವಸ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಟ್ಟು ನೋಡೋನು ಅಂತ ಅನ್ನಬಹುದು. ನಾ ಏನೂ ಮಾಡಲಿಲ್ಲ. ಇದು ಅಬ್ಸೆಸ್, ಸರ್ಜನ್ಸ್ ಒಪಿನಿಯನ್ ಆ್ಯಂಡ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಬೈ ಸರ್ಜನ್. ಓಕೆ, ನಾ ಏನು ಮಾಡ್ತೀನಿ, ಉಳಿದವ್ರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ನನಗದು ಭಾಳ ಚಲೋ ಅನ್ನಿಸ್ತು. ಗಟ್ಟಿ ಹೊಡೆದು ಅವನಿಗೆ ಡಾಕ್ಟರ್ ನಮ್ಮ ರಿಸೆಪ್ಷನಿಸ್ಟ್ ಹೇಳಿದೆ, ಇವನಿಗೆ ರೊಕ್ಕ ಕೊಡೋರಿಗೆ ಹೊಳ್ಳಿ, ಅದು ನಮ್ಮ ಕೇಸಲ್ಲ, ಸರ್ಜನ್ ಕಡೆ ಹೋಗಬೇಕು. ಇಷ್ಟು ಹೇಳಿದ್ರೆ ನೀವು ಸೇವ್ ಆಗ್ತದೆ. ನನಗೂ ಗೊತ್ತದ ಅಂತ ಹೇಳಿ ಅದು ಓಡೋದು ರಮರಾಡಿಯಾಗಿ ಅವ ನಾವು ಭಯಂಕರ ಮುಂದೆ ಅದಕ್ಕೆ ಆಪ್ರೇಷನ್ ಆಯ್ತು ರೀ, ಒಂದು 20,000 ಖರ್ಚಾಯಿತು. ಥ್ರೂ ಹಕ್ಕಿ ಸರ್ ಒಂದು ನಮಗೊಂದು ಕೇಸ್ ಹೆಟ್ಟಿದ್ರೆ ಅಂದ್ರೆ ಮುಗಿದಾಯ್ತು. ರೊಕ್ಕ ಇಂಪಾರ್ಟೆಂಟ್ ಅಲ್ಲ, ಮಾನಸಿಕ ನೆಮ್ಮದಿ ಕಡಿಮೆ ಆಯಿತು. ನಾವು ಅದಕ್ಕೆ ಪ್ರಿಪೇರ್ಡ್ ಇರುವುದಿಲ್ಲ. ಬಟ್ ಮೊದಲೇ ಯಾಚರಿದ್ರೆ ಮುಗದೇ ಹೋಗಿಬಿಡ್ತದೆ. communicate clearly. Good doctor-patient communication prevents most medico-legal disputes. ಚಲೋತ್ನಾಗೆ ಮಾತಾಡೋದು, ಮೃದು ವಚನ ಮೂಲೋಕ ಗೆಲ್ಲುವುದು. ಸಾಫ್ಟ್ ಅವ ಎಷ್ಟು ಏರ್ ಕೇಳ್ತಾನೆ ಅಷ್ಟು ನೀವು ಸಾಫ್ಟ್. ನೀವು ಟೆಂಪ್ರೇಚರ್ ಏರಿದೆ ನಾವು ಮತ್ತೆ ಮುಗುಲು ಮುಟ್ಟಿಸ್ತಾನೆ. ನಮ್ಮಲ್ಲೊಬ್ಬರು ಇದು ಇದ್ರು, ನನ್ನ ಜೋಡಿ ಕಲೀಗ್ ಪ್ರೊಫೆಸರ್ ಅಥನಿಕರ್ ಅಂತ ಹೇಳಿ, ಸ್ಕಿನ್ ಡಾಕ್ಟರ್, ಅವ್ರಿಗೆ ಧಾರವಾಡದಾಗ. ಅವ್ರು ನಮ್ಮ ಒಪ್ಪಿಡಿಯಾಗ ಎಲ್ಲರೂ ಚಪ್ಪಲ್ದಾಗ ನಿಮ್ಗೆ ಗೊತ್ತಿರಬೇಕು, ಒಂದೇ ಕಡೆ ಕೊಂಡಿರ್ತಿದ್ದೀವಿ ನಾವು. ಪೇಷಂಟ್ ಯಾಕೆ ಜೋರು ಹೇಳ್ತಾರೆ ಅವ್ರು ಸಾವಕಾಶ ಹೇಳೋರು. ಆ ಪೇಷಂಟ್ ಕಡೆಗೆ ಬೇಸರಾಗಿ ಬಿಡ್ತಿದ್ದೋ ಅಂತ ತಿಳ್ಕೊಂಡು ಬಿಡ್ತಿದ್ದೋ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಬಟ್ ಎಂತೂ ಅವ್ರು ಯಾರು ಜೋಡಿ ಜಗಳಾಡಿದ್ದು ನೋಡಿ ನಾವು 2 ಸರಿ ಕೇಳಿದ್ರೆ ಅವಾಗಿನ ಕಾಲದಾಗ ಮೋಸ್ಟ್ಲಿ ಪವನ್ ಇವತ್ತು ನಮ್ಮ ಸರ್ ಹೇಗಿದ್ರು ಈಗೆಲ್ಲ ಹೇಳೀನಿ ಮತ್ತೆ ಹೇಳೋದಂದ್ರೆ ಏನೋ ಅಂತ ಹಿಂಗೆ ಕೇಳ್ತಿದ್ವಿ ಬಿಜಾಪುರ ಸ್ಟೈಲ್. ಕೆಲವೊಮ್ಮೆ ಅದಕ್ಕೂ ಹೆದರ್ತಾರೆ ಬಿಜಾಪುರ. ಹೆದರ್ತಾರಂತ ಅಂದರೆ ಹೆದರ್ಸೋ ವ್ಯಕ್ತಿ ಅಲ್ಲ ಅವರು. ಡಾಕ್ಟ್ರುಗಳು ಪೇಷಂಟ್ಗಳು ಭಾಳ ಶಾಣೆ ಇರ್ತಾರೆ, ನಿಮಗೆಲ್ಲ ಗೊತ್ತು, ನಿಮಗೂ ವಿಚಾರ ಮಾಡಿರ್ತೀರಿ. ಡಾಕ್ಟರ್ ಸಿಲೆಕ್ಟ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಮೊದಲೇ ವಿಚಾರ ಮಾಡಿರ್ತಾರೆ ಇವ ಹ್ಯಾಂಗ್ ಅದಾನ ಅಂತ ಹೇಳಿ. ಇವನಿಗೆ ಇಷ್ಟೇ ಮಾತಾಡಬೇಕು. ಮೊನ್ನೆ ಪೇಷಂಟ್ ಸರ್ ಇನ್ನೊಂದು ಪ್ರಶ್ನೆ ಕೇಳ್ಬೇಕಂತ ಮಾಡೀನ್ರಿ ನಿಮ್ಮ ಅಂತ ಕೇಳಲ್ಲ. ಎಲ್ಲಿ ಸರ್ ಹೇಳ್ಯಾರ ಹೊರಗೆ ಭಾಳ ಕೇಳಬಾರ್ದು ಅಂತ ಹೇಳಿ. ಇದು ಒಂದು ರೀತಿಯಿಂದ ಕೆಲವು ಅಡ್ವಾಂಟೇಜು ಇರ್ತದೆ. ಬಟ್ ಎನಿವೇ ಯಾವಾಗಲೂ ಅದನ್ನೇ ಒಂದೇ ಸೇಮ್ ಶರ್ಟ್ ಡಸಂಟ್ ಸೂಟ್ ಫಾರ್ ಎವ್ರಿಬಡಿ. ಓಕೆ, ಟೇಕ್ ಪ್ರಾಪರ್ ಇನ್ಫಾರ್ಮ್ ಕನ್ಸೆಂಟ್ ಬಿಫೋರ್ ಎನಿ ಪ್ರೊಸೀಜರ್ ಆಸ್ ಎಂಫಾಸಿಸ್ಡ್ ಇನ್ ಸಮೀರಾ ಕೋಹ್ಲಿ ವರ್ಸಸ್ ಡಾಕ್ಟರ್ ಪ್ರಭಾ ಮನ್ಚಂದ್ರ ಕೇಸ್. ದಿಸ್ ಇಸ್ ರಾ ರಿಲೇಟೆಡ್ ಪ್ಲಸ್ ಇನ್ಫಾರ್ಮ್ ಕನ್ಸೆಂಟ್ ತಗೋಬೇಕು. ಈಗ ಒಮ್ಮೆ ನಾನು ಅದನ್ನೇ ಹೇಳಿದ್ನಲ್ಲ, ಅಪ್ಸೆಸ್ ಬಂದಿತ್ತು, ನಡಿ ಒಳಗೆ ಹೋಗೋರು ಅದು ತೆಗೆದುಬಿಡೋಣ ಅಂತ ಹೇಳಿ. ಕನ್ಸೆಂಟ್ ತಗೋಬೇಕು, ಅನಿಸ್ಟಿಕ್ ಕೊಡ್ತೀವಿ, ಟಾಪಿಕಲ್ ಹಾಸ್ತೀವಿ, ತೆಗಿತೀವಿ. ಸಡನ್ ಆಗಿ ತೆಗೆದುಕೊಳ್ಳಕ್ಕೆ ಒಮ್ಮೆ ಪೇನಿಗೆ ಸಹಿತ ಕೊಲ್ಯಾಪ್ಸ್ ಆಗ್ತಾರೆ. ಆ 2 ಮಿನಿಟ್ನಾಗ ಮತ್ತೆ ರಿಕವರಿ ಆಗ್ತಾರೆ. ಬಟ್ ಹೆಸರೇನೋ ಮಾಡೋಣ ಒಮ್ಮೆ ಬಿದ್ದೆ ಬಿಟ್ಟು ರೀಸರವ ಅಂತ ಮಂದಿಗೆ ಏನು ಗೊತ್ತಾ, ಅವ್ರು ಸೈನ್ಸ್ ಓದಿರಂಗಿಲ್ಲ. ಸೊ ಇಂಥ ವಿಷಯಗಳಲ್ಲಿ ಸಹಿತ ನಾವು ಎಚ್ಚರ ಇರಬೇಕು. ಡಾಕ್ಯುಮೆಂಟ್ ಎವ್ರಿಥಿಂಗ್. ಇಫ್ ಇಟ್ ಈಸ್ ನಾಟ್ ರಿಟರ್ನ್ ಇಟ್ ವಾಸ್ ನಾಟ್ ಡನ್. ನಮ್ಮ ಹಕ್ಕಿ ಸರ್ ಭಾಳ ಹೇಳ್ತಾರೆ ಯಾವಾಗ, ಮೊದಲು ಬರ್ಕೋರಿ ನೀವು ಏನು ಮಾಡಿದ್ರು ಸಹಿತ. ಇಫ್ ಇಟ್ ಈಸ್ ನಾಟ್ ರಿಟರ್ನ್ ಇಟ್ ವಾಸ್ ನಾಟ್ ಡನ್. ನಾ ಹೇಳಿದ್ನಲ್ಲ, ನಾ ಬರದೆ, ಇದು ನನ್ನ ಕೇಸ್ ಅಲ್ಲ, ಇವ್ರ ಕಡೆ ಹೋಗ್ರಿ, ಅದು ನನ್ನ ಕೆಲಸ ಮುಗಿತು. ಅವ ಎಲ್ಲರೂ ಹೋಗಿ ಅಪರಾಧಾಗಿ ಅಂತ ಆದರೂ ಸಹಿತ ಇನ್ನೊಂದು ಡಾಕ್ಟರ್ ಕಡೆ ಹೋಗಿದ್ದಾಗ ನಾನು ಪೇಪರ್ ತೊಗೊಂಡು ಬಾ, ಪೇಪರ್ನಾಗ ನಾನು ಬರ್ತೀನಿ ಅವಾಗ ಟು ಸೇವ್ ಮೈ ಸ್ಕಿನ್ ಅವಾಗ. ಓಕೆ, then follow standard medical practice, a principle reinforced in Jacob Matthew and State of Punjab. Standard medical practice. ಇದಕ್ಕಿದೆ ಔಷಧ. ನನಗೆ ನಾ ಕೊಟ್ಟಾಗಿದೆ ಎಲ್ಲ ಚಲೋ ಆಗ್ತದೆ ಅಂದರೆ ನಿನಗೆ ತಿಳಿದದ್ದು ಕೊಟ್ಟಿ ಅಂತಂದ್ರೆ ಕೋರ್ಟ್ ಆಫ್ ಲಾದಾಗ ಏನಾಗ್ತದೆ ಅಲ್ರಿ, ಈ ಮಲೇರಿಯಾಕ್ಕೆ ಕ್ಲೋರೋಕ್ವಿನ್ ಅಥವಾ ಹೈಡ್ರೋಕ್ಸಿಕ್ಲೋರೋಕ್ವಿನ್ ಇಂಥ ಏನೋ ಅದಾವ ಕೊಡಬೇಕಾಗಿತ್ತು. ಇಲ್ರಿ ನಾ ಬರೇ ನಾವೊಂದು ಕಂಡು ಹಿಡಿದೀನಿ ಸರ್, ಅದನ್ನು ರೆಗ್ಯುಲರ್ ಕೊಟ್ಟರೆ ಅದೇ ಹೋಗ್ತದೆ. ಅದೂ ಅಲ್ಲ, ರಿಕಾರ್ಡೆಡ್ ಇರಬೇಕು. ಮೆಡಿಕಲ್ ಬುಕ್ನಲ್ಲಿರ್ಬೋದು, ಮೆಡಿಕಲ್ ಜರ್ನಲ್ನಲ್ಲಿರ್ಬೋದು. ಅದ್ರ ಹೆಸರು ಇತ್ತು ಅಂತಂದ್ರೆ ಅದಕ್ಕೆ ಯಾರು ಏನು ನಿಮಗೆ ಪ್ರಶ್ನೆ ಮಾಡೋದಿಲ್ಲ. ರಿಸ್ಪೆಕ್ಟ್ ಪೇಷಂಟ್ ಕಾನ್ಫಿಡೆನ್ಷಿಯಲಿಟಿ ಎಕ್ಸೆಪ್ಟ್ ವೆನ್ ಡಿಸ್ಕ್ಲೋಜರ್ ಇಸ್ ಲೀಗಲಿ ರಿಕ್ವೈರ್ಡ್. ಕೆಲವೊಮ್ಮೆ ಆಗ್ತದೆ, ಒಂದು ಯಾವುದೋ ಒಂದು ಫ್ಯಾಮಿಲಿಗೆ ಒಂದು ಪೇಷಂಟ್ ನೋಡಿರ್ತೀನಿ, ಬಂದು 4 ಮುಂದೆ ಅವ್ರನ್ನ ಬರ್ತಾರೆ, ಹುಡುಗಿ ಬಂದಿದ್ದು ನೋಡ್ರಿ ಆಕೆಗೆ ಏನಾಗಿದ್ರಿ ಅಂತ ಕೇಳ್ತಾರೆ. ನಾ ಏನೂ ಹೇಳ್ಬಾರ್ದು, ಅವನ ಬೀಗ್ರಿರಲಿ ಬೇಜರಿರಲಿ. ಅಕಸ್ಮಾತ್ ಏನೋ ಒಂದು ಬಿಡುಪಿತ್ತು ಅಂತ ತಿಳ್ಕೊಂಡು ವೈಟ್ಲಿಗೋ ಅಂತ ಇರ್ತದೆ, ಅವ್ರಿಗೆ ಮುಂದೆ ಹೆಣ್ಗಂಡು ಕೊಡೋದು ಏನೋ ಒಂದು ಕಾತಿರ್ತದೆ ಅವರು. ಅದನ್ನು ನಾವು ಎಂದೂ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಬಾರ್ದು. ಇವನ್ ತಂದೆ ಸಾಯಂಕಾಲ ಸತಿ ಹೇಳಬೇಕು, ಎಲ್ಲ ಹೇಳಿ ಹಿಂಗೆ ಅದನ್ನೇ ಮನೆ ಮುಂದೆ ನೋಟಿಸ್ ಬೋರ್ಡ್ ಹಾಕೋದಲ್ಲ, ನಮ್ಮ ಮಗಳಿಗೆ ಹಿಂಗೆ ಐತೆ ಅಂತ ಹೇಳಿ. ಸೊ ಇದು ಸಹಿತ ತಿಳುವಳಿಕೆ ಕೊಡಬೇಕಾಗ್ತದೆ. ರೈಟ್ ಕ್ಲಿಯರ್ ಪ್ರಿಸ್ಕ್ರಿಪ್ಷನ್ ವಿತ್ ಕರೆಕ್ಟ್ ಡೋಸ್, ಡ್ರಗ್ ಡೋಸ್ ಆ್ಯಂಡ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್. ಹೆಸರು ಕರೆಕ್ಟ್ ಬರೀಬೇಕು. ಇದು ಭಾಳ ಮಿಸ್ಟೇಕ್ ಆಗ್ತಿರ್ತವೆ. ಯಾವುದೋ ಒಂದು ಗಿಳಿ ಎಮ್ದಿಂದ ಶುರುವಾಗ ಆಮೇಲೆ ಅಲ್ಲಿ ಮೆಡಿಕಲ್ ಶಾಪ್ನಾಗ 10th ಫೇಲ್ ಆದವ ಔಷಧ ಕೊಡ್ತಿರ್ತಾನೆ. ಎಮ್ ಬರೋಣ ಅವ ಏನು ತಿಳ್ಕೊ ಇದೇ ಇರಬೇಕು ಅಂತ ಕೊಟ್ಟಿರ್ತಾನೆ. ನೀವು ಹೊಳ್ಳಿ ಚೆಕ್ ಮಾಡಿಲ್ಲ, ಒಂದು ವಾರಗಣ ಬರ್ತಾನೆ ಪೇಷಂಟ್, ಒಂದು ಏನೂ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಏನಾಗೋದಿಲ್ಲ, ಇದು ತಗೋ ಬೇರೆ ಕೊಡ್ಬೋದು, ತಪ್ಪೇನ ಅಂತ ಹೇಳ್ಬೋದು. ಬೇರೆನೇ ಕೊಟ್ಟು ಏನ್ರಿ ಆಗಿತ್ತು ಅಂದ್ರೆ ನಾ ಬರ್ದದ್ದೊಂದು ಕೊಟ್ಟದ್ದೊಂದು ಅಂದ್ರೆ ಅವ್ನು ನನ್ಗೇನು ಗೊತ್ತ್ರಿ ಸರ್ ನೀವು ಹೇಳ್ಬೇಕಂತ ಹೇಳ್ತಾನೆ. ಅದು ಅಗ್ದಿ ಕರೆಕ್ಟ್ ಅದು. ಸೊ ಇವೆಲ್ಲನೂ ಸಹಿತ ಎಚ್ಚರ ಇರಬೇಕು, ಕ್ಲಿಯರ್ ಬರೀಬೇಕು. ಮಂದಿ ಏನು ತಿಳ್ಕೊತಾರೆ ಎಲ್ಲರೂ, ಅದಕ್ಕೆ ಈಗ ಇವನ್ NMC ರೂಲ್ ಮಾಡ್ಯಾರ ಏನೋ ಫಸ್ಟ್ ಲೆಟರ್ದಾಗ ಬರೀಬೇಕಂತ. ಆದರೂ ಸಹಿತ ನಾವು ಹಿಂಗೆ ಮಾಡಿ ಬರೀತಿರ್ತೀವಿ. ಕೆಲವೊಬ್ರು ಯಾರೋ ಬಂದಿದ್ರು ಒಂದು ಭಯಂಕರ ಕತ್ತಿದ್ದು, ಸೊ ಇದೊಂದು ಸ್ವಲ್ಪ ಲೆಟರ್ ಬಂದದ್ರಿ ಒಂದು ಓದ್ಕೊಡ್ರಿ ಅಂತಂದ್ರೆ, ಅದಕ್ಕಂದ್ರೆ ಡಾಕ್ಟ್ರಿಗೆ ಅಷ್ಟೇ ತಿಳಿತದ ಅಂತ ಹೇಳ್ಯಾರಿ ಅಂತ ನನಗೂ ತಿಳಿದಿಲ್ಲ ಬಿಡೋದು. ರಿಕಾರ್ಡ್ ರೆಫ್ಯೂಸಲ್ ಆಫ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಆರ್ ಲಾಮಾ ಲೀವ್ ಅಗೇನ್ಸ್ಟ್ ಮೆಡಿಕಲ್ ಅಡ್ವೈಸ್ ವಿತ್ ಪ್ರಾಪರ್ ಡಾಕ್ಯುಮೆಂಟೇಶನ್. ನಾ ಆಗಲೇ ಹೇಳಿದೆ, ಪೇಷಂಟ್ ನಾ ಹೇಳಿದೆ ಇದು ಆಗಬೇಕು, ಅಡ್ಮಿಟ್ ಆಗಬೇಕು, ನಾ ಹೇಳಿದೆ ಪೇಷಂಟ್ ಅಟೆಂಡೆನ್ಸ್ ರೆಫ್ಯೂಸ್. ಆದರೂ ಕೌನ್ಸಿಲಿಂಗ್ ಡನ್ ರಿಗಾರ್ಡಿಂಗ್ ದಿ ಅರ್ಜೆನ್ಸಿ ಆಫ್ ಗೆಟಿಂಗ್ ಅಡ್ಮಿಟೆಡ್ ಆ್ಯಂಡ್ ದಿ ನೆಸೆಸರಿ ಟ್ರೀಟ್ಮೆಂಟ್. ಅಲ್ಲೇನೋ ಡ್ರಗ್ ಬರೆಯೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ನೆಸೆಸರಿ ಟ್ರೀಟ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಅಡ್ವೈಸ್ಡ್. ಆಮೇಲೆ ಇದು ಎದಕ್ಕೆ ಇಂಪಾರ್ಟೆಂಟ್ ಅಂತಂದ್ರೆ ಸ್ಟೇ ಅಪ್ಡೇಟೆಡ್ ವಿತ್ ಮೆಡಿಕಲ್ ಲಾಸ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಕನ್ಸ್ಯೂಮರ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆ್ಯಕ್ಟ್ ಅಂಡ್ ಅದರ್ ರೆಗ್ಯುಲೇಟರಿ ಗೈಡ್ಲೈನ್ಸ್. ಒಂದು ಕನೂರಾಯ ವರ್ಸಸ್ ಆಂಬ್ರಿ ಹಾಸ್ಪಿಟಲ್ ಕಲ್ಕತ್ತಾ 7 ಕೋಟಿ ರೂಪಾಯಿ ಕಾಂಪೆನ್ಸೇಷನ್, 7 crore. 7 crore rupees. ಅದು ಯಾಕೆ ನನಗೆ ಗೊತ್ತದಂತ 2 ರೀತಿಯಿಂದ. ಒಂದು ನಾನು ಸ್ಕಿನ್ ಡಾಕ್ಟರ್ ಅಂದದು ಟಾಕ್ಸಿಕ್ ಎಪಿಡರ್ಮೋನೆಕ್ರಲೈಸಿಸ್ ಅಂತಂದ್ರೆ ಕನ್ನಡದಾಗ ಹೇಳ್ಕೊಂಡು ಚರ್ಮ ಸುಲ್ದಂಗೆ ಫುಲ್ ಸುಟ್ಟು ಹೋಗಿರ್ತದೆ. ಒಂದು ಗುಳಿಗಿಂದ ರಿಯಾಕ್ಷನ್ ಆಗ್ಯದ. ಬಟ್ ಎಂಬ್ರಿದವ್ರು ನೆಗ್ಲಿಜೆನ್ಸ್ ಏನು ನಡೀತಾ ತಗೋ ವಿ ಆರ್ ಡೂಯಿಂಗ್ ಇಟ್ ಅಂತ ಹೇಳಿ ಅದು ನಿಮಗೆ ಹೆಚ್ಚು ಮೆಡಿಕಲ್ ಇದು ಹೇಳೋದು ಬೇಕಲ್ಲ. ಬಟ್ ಅದು 15 ವರ್ಷಗಟ್ಟಲೆ ಕೇಸ್ ನೋಡೋದು 7 ಕೋಟಿ ರೂಪಾಯಿ ಇಂಟ್ರೆಸ್ಟ್ ಸಹಿತ ಕೊಡಬೇಕಾಯ್ತು. ಕೇಸ್ ಹಾಕಿದಾಗ ಅವನು ಡಾಕ್ಟ್ರೇ USA ಕೆಲಸ ಮಾಡೋದು. ಆ ಪೇಷಂಟ್ ಯಾರು, ಅವರು ಕ್ಲಿನಿಕಲ್ ಸೈಕಾಲಜಿಸ್ಟ್, ಅವರು ಒಬ್ಬರು ಡಾಕ್ಟರ್ ಇದರೊಳಗೆ ಕೆಲಸ ಮಾಡೋದು. ಸೊ ಅವೆಲ್ಲ ಅಪ್ಡೇಟೆಡ್ ಇರಬೇಕು ಅಂತ ನನಗಿದು. ಆ್ಯಂಡ್ ವಾಟ್ ಈಸ್ ಲಾಸ್ಟ್ ಆ್ಯಂಡ್ ದ ಬೆಸ್ಟ್ ಈಸ್ ಪ್ರಾಕ್ಟೀಸ್ ಎಥಿಕಲ್ ಕಂಪ್ಯಾಷನೇಟ್ ಮೆಡಿಸಿನ್, ದ ಬೆಸ್ಟ್ ಸೇಫ್ ಗಾರ್ಡ್ ಅಗೇನ್ಸ್ಟ್ ಲಿಟಿಗೇಷನ್. ಈಗ ಅವ್ರು ನೋನ್ಯಾಗಿ ಬಂದಿರ್ತಾರೆ, ಅವ್ರು ನೋಡಿ ನೀವು ಅಳಾಕ್ ಬರುವುದಿಲ್ಲ, ಬಟ್ ಸಿಂಪೆಥಿಕ್ ಒಂದು, ಬಟ್ ಸಿಂಪೆಥಿಕ್ಕಿಂತ ಎಂಪತಿ ಇರಬೇಕು. ಸಿಂಪತಿ ಅಂದ್ರೆ ಹೆಂಗೆ, ಭಾಳ ತ್ರಾಸಾಗಿದೆ, ಹೌದ್ರಿ ಭಾಳ ತ್ರಾಸಾಗಿದೆ, ಏನು ಮಾಡೋನು ಏನು ಮಾಡಿ ನಾನು ಒಂದು ಜೋಡಿ ಹಿಂಗೆ ಕೂತ್ನಂದ್ರೆ ಹೆಂಗೆ ನಿಮ್ಮ ಕೆಲಸ ಅದು ಅಲ್ಲ. ಎಂಪತಿ, ಹೌದು ನನಗೆ ಗೊತ್ತಾಗ್ಲಾಗತ್ತದ, ಭಾಳ ತ್ರಾಸದ, ಇದನ್ನು ಮಾಡೋನು ಚಲೋ ಆಗ್ತದೆ. ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳ್ತಿರ್ತಾರೆ ಕೆಲವೊಬ್ರು. ಇಂತ ನಮ್ಮಲ್ಲಿ ಡಾಕ್ಟರ್ ಉಮರ್ಜಿ ಸರ್ ಅಂತಿದ್ರು, ಅವ್ರು ಬರೇ ನೋಡಿದ್ರೆ ಸಾಕು ಅಂದ್ರೆ ಅವ್ರೇ ಏನಾದ್ರು ತಗೋ ಹಿಂಗೆ ಇದೇ ಶಬ್ದ ಅಂತಿದ್ರು. ಅಕ್ಕಿ ಸರ್ ಗೊತ್ತಿರ್ಬೋದು. ಸೊ ಇಂಥದ್ದು ಈ ಸಿಂಪತಿ ಅಲ್ಲ, ಎಂಪತಿ ಇಂಪಾರ್ಟೆಂಟ್. ಸಿಂಪತಿ ಬರೇ ಕೆಟ್ಟ ಅನ್ಸ್ಕೊಳ್ಳೋದು, ಎಂಪತಿ ಅಂದರೆ ಆ ಕೆಟ್ಟ ಆಗಿದ್ದನ್ನು ಹ್ಯಾಂಗೆ ನಾವು ಸರಿ ಮಾಡೋದು ಎಂಪತಿ ಅಂತ ಹೇಳ್ತೀವಿ. ಸೊ ದೀಸ್ ಆರ್ ದ 10 commandments. ಸೊ ಏನು ಇದರೊಳಗೆ ಅಲ್ಟಿಮೇಟ್ಲಿ 3 C's: ಕಮ್ಯುನಿಕೇಷನ್, ಕನ್ಸೆಂಟ್ ಆ್ಯಂಡ್ ಕೇರ್ಫುಲ್ ಡಾಕ್ಯುಮೆಂಟೇಷನ್. ಇವು 3 ಮಾಡಿದ್ರೆ ನಾವು ಈ 3 ಚಕ್ರವ್ಯೂಹದಾಗ ಸಿಗೋದಿಲ್ಲ. ಲಾ, ಪೊಲೀಸ್ ಆ್ಯಂಡ್ ಪಬ್ಲಿಕ್, LPP. ಸೊ 3 C's ಫಾರ್ ಟು ಬಿ ನಾಟ್ ಇನ್ ದಿ ಟ್ರಯಾಂಗಲ್ ಆಫ್ LPP. ಮತ್ತೊಮ್ಮೆ ಅರ್ಜುನ್ ಕುಲಕರ್ಣಿ ಸರ್ಗೆ ಮತ್ತು ಆ್ಯಕ್ಚುಲಿ ಇದಕ್ಕೆ ಯಾಕೆ ಮುಂದೆ ಬಂದದ್ದು, ಬೇರೆಯವ್ರು ಯಾರು ಬರಲಿಲ್ಲ, ನಾನು ಒಂದು ಭಾಷಣ ಮಾಡೋಕ್ಕಾಗಿತ್ತು. ಇಲ್ಲೇ ನಿನ್ನೆ ಒಂದು ಏನೋ ತೆಗೆದು ಇದ್ರೊಳಗಿಂದ ನಾನು ಮಾತಾಡಿದೆ. ನನಗನ್ನಿಸ್ತು ನನ್ನ ಅನುಭವ ಆ್ಯಸ್ ವೈದ್ಯಕೀಯ ವ್ಯಕ್ತಿಯಾಗಿ ಏನು ಮಾತಾಡಿದ್ರೆ ಚಲೋ ಅನಿಸ್ತು, ನಾನು ಮಾತಾಡಿದೆ. ಆ್ಯಕ್ಚುಲಿ ಬರ್ಲಿಕ್ಕೆ ಇನ್ನೊಂದು ಕಾರಣ ಅಂದ್ರೆ CS ಪಾಟೀಲ್ ಸಾಹೇಬ್ರದ್ದು ಭಾಷಣ ಕೇಳಿ ಅವ್ರು ಕೇಳೋದೇ ಒಂದು ಮಜಾ ಇತ್ತು. ಕೆಲವೊಮ್ಮೆ ಯಾಕೆ ಭಾಷಣ ಕೇಳಬೇಕು ಎಲ್ಲರೂ ಅಂತಂದ್ರೆ ಹ್ಯಾಂಗೆ ಚಲೋ ಮಾತಾಡಬೇಕು ಅಂತ, ಹ್ಯಾಂಗೆ ಮಾತಾಡಬಾರ್ದು ಅನ್ನೋದು ಕಲೀಲಾಕಿರ್ತದೆ. ಸೊ ಮತ್ತೊಮ್ಮೆ ತಮ್ಮೆಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳು. ಕರ್ನಾಟಕ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಲಾ ಆ್ಯಂಡ್ ಪಾರ್ಲಿಮೆಂಟರಿ ರಿಫಾರ್ಮ್ಸ್ನ ರೇವಯ್ಯ ಒಡೆಯರ್ ಸರು, CS ಪಾಟೀಲ್ ಸರು ಮತ್ತು ನಮ್ಮ ರಿಜಿಸ್ಟ್ರಾರ್ ಸರ್ RV ಕುಲಕರ್ಣಿ, ಇವರೆಲ್ಲರಿಗೂ ನನ್ನ ತುಂಬ ಹೃದಯದ ಧನ್ಯವಾದಗಳು. ಇಷ್ಟೆಲ್ಲ ಬಿಜಿ ಇದ್ದರೂ ಸಹಿತ ಲಕ್ಷ್ಮಣ ಹೆಬ್ಬರಿಗೆ ಸಾಹೇಬರು ಬಂದು ನಮ್ಮ ಆಡಿಯನ್ಸ್ನ ಕೂತಾರೆ. ಅವ್ರು ಮೊದಲೇ ನಮ್ಗೆ ನಾನು ಕೇಳಿದೆ, ಸಾಹೇಬ್ರಿಗೆ ಅಲ್ಲೇ ಕೊಂಡಿರ್ಸಿರ ಅಂತೇಳಿ. ಇಲ್ಲ, ಅವ್ರು ಮೊದಲು ಈ ನಮ್ಮ ಸ್ಕೀಮ್ನಾಗ ಇದ್ದಿದ್ದಿಲ್ಲ. ಇರಲಿ, ಆದರೂ ನಿಮ್ಮಂಥವ್ರು ಬಂದು ಹಿರಿಯರು ಬಂದ ಕುಂತ್ರಿ ಅಂತಂದ್ರೆ ನಿಮ್ಮ ಪೊಲೀಸ್ ಸಿಬ್ಬಂದಿಗೂ ಸ್ವಲ್ಪ ಹೆಚ್ಚಿನ ಸ್ಥೈರ್ಯ ಬರ್ತದೆ. ಇಷ್ಟು ಹೇಳಿ ಒಂದೆರಡು ಮಾತುಗಳನ್ನು ಮುಗಿಸ್ತೀನಿ. ನಮಸ್ಕಾರ.
Thank you, sir, for your valuable insight and guidance. Leadership in academia is not only about administration, but also about inspiring knowledge and ethical responsibility. Now I request Professor Dr. C.S. Patil sir, Director Kilpar, Bangalore, to deliver the presidential remarks.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ನಿನ್ನೆ ಮಹಿಳಾ ಯೂನಿವರ್ಸಿಟಿಗೆ ಹೋಗಿದ್ವಿ. ಅಲ್ಲಿ ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ ಅಂದ್ವಿ, ಯಾರು ನಮಸ್ಕಾರ ಅನ್ನಲಿಲ್ಲ. ನೀವು ಬಿಜಾಪುರದವರು, ಸುಸಂಸ್ಕೃತರು, ಯಾರಾದರೂ ನಮಸ್ಕಾರ ಅಂದರೆ ನಮಸ್ಕಾರ ಅಂತಾರೆ ಅಂತಂದು ನಿರೀಕ್ಷೆಯಿಂದ ನಮಸ್ಕಾರ ಅಂದಿರ್ತೀವಿ ನಾವು. ಅದಕ್ಕೆ ಎರಡೆರಡು ಸಲ ಮತ್ತೆ ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. We have to make certain of the things habits, and good habits are very essential. ಕಲ್ಚರ್ ಕಳ್ಕೊಂಡ್ಬಿಟ್ಟಿವಿ. ಕಾರಣ ಏನೇ ಇರ್ಬೋದು, ನಮ್ಮವರನ್ನ ನಾವು ಯಾವ ರೀತಿ ನೋಡ್ಕೋಬೇಕು, ನಡೆಸ್ಕೋಬೇಕು ಅನ್ನೋದನ್ನು ನಾವು ಮರ್ತ್ಬಿಟ್ಟಿವಿ ಅಂತಂದರೆ ಭಾಳ ಕಷ್ಟ ಆಗುತ್ತದೆ. ಅದಕ್ಕೋಸ್ಕರ ಎಷ್ಟು ಉಳಿದ ಸಂಸ್ಕೃತಿ ಅದನ್ನು ಉಳಿಸ್ಕೊಂಡು ಹೋಗ್ಬೇಕು. ನಾವು ರಾಯಚೂರವರು, ಬಿಜಾಪುರದವ್ರನ್ನ ನೋಡಿದರೆ ನಮಗಿಂತ ಶ್ರೇಷ್ಠ ಅನಿಸ್ತದೆ ನಮಗೆ. ಬಿಜಾಪುರದವ್ರಿಗೆ ಮತ್ತೆ ಬೇರೆ ಯಾರನ್ನಾದ್ರೂ ನೋಡಿದರೆ ಶ್ರೇಷ್ಠ ಅನಿಸ್ಬೋದು. ಒಬ್ಬರನ್ನೊಬ್ಬರು ನೋಡ್ಕೊಂಡು ಬೆಳೀತಾ ಹೋಗೋದಂತೆ. ನಮ್ಮ ಡಾಕ್ಟರ್ ಅರುಣ್ ಸಿ ಎನಾಮ್ದಾರ್ ಸಾಹೇಬರು ಭಾಳ ಚೆನ್ನಾಗಿ ಮಾತಾಡಿದರು. ದಿಸ್ ಈಸ್ ಎ ಸಿಚುವೇಶನ್ ವೇರ್ ಇನ್ two professions are meeting. Law and medicine are meeting in the presence of police force. Everyone is a gentleman in the presence of a policeman. Kulkarni, principal of the college, and R.V. Kulkarni sir, registrar, they have planned it. ಈ ವಕೀಲರು, ಡಾಕ್ಟ್ರು ಹೆಚ್ಚು ಕಡಿಮೆ ಮಾತಾಡಿ ಮತ್ತೆ ಇಲ್ಲೇ ಬಡ್ದಾಡಕ್ಕೆ ನಿಂದಿರಬಾರ್ದು, ಪೊಲೀಸ್ನವರು ಇರಲಿ ಒಂದು ವೇದಿಕೆ ಅಂತ ಅವರು ಸೇರಿಸ್ಕೊಂಡಿದ್ದಾರೆ. ಅಡ್ವೊಕೇಟ್ ಅಕ್ಕಿ ಸರ್, ಸುರೇಶ್ ಅಕ್ಕಿ, ಶ್ರೀ ಲಕ್ಷ್ಮಣ್ ನಿಂಬರ್ಗಿ ಸರ್, ಡಾಕ್ಟರ್ ಯೋಗಾನಂದ ರೆಡ್ಡಿ, Dr. Pawan Kumar, Dr. Baba Gowda. I am a law doctor, Baba Gowda is a law doctor, and these people are medical doctors. ಸಾಹೇಬರು ಮಾತಾಡುವಾಗ ಹೇಳಿದ್ರು, ದಂಧೆ ಆಗಿಬಿಟ್ಟದೆ ಅಂತ, ವೃತ್ತಿ ದಂಧೆ ಆಗಿಬಿಟ್ಟದೆ. See, we have to look into the evolution of profession. See, at the initial stage, it was chaotic. Anybody could become anything. Somebody may become a doctor, somebody may become a carpenter, somebody may become whatever. He will learn that and he will pursue that discipline. From chaos, the movement of profession was towards organization. From chaos to organization. And once they got organized, the movement was towards autonomy. So chaos, organization, autonomy. Once the professions become autonomous, all our professional friends are here. Government will not decide who will be a doctor. Medical council will decide who should be a doctor. Government will not decide who will continue as a doctor. Medical council decides who will continue as a doctor. Who should be a doctor, what should be qualification, how he has to practice, what is your code of ethics, everything is done by doctors themselves. Vaidyanarayana Hari, we people in the society, we trust you, we believe. You decide what you have to do. Why we trust you? We trust you because of your knowledge, because of your specialization, because of your expertise. What is a profession? Profession is an occupation pursued by an intellectual class of people as a matter of public service. As a matter of public service. No less a public service, even if incidentally it is a means of livelihood. Right? So this element of pro bono publico is intertwined in profession. ಯಾರಾದರೂ ದಂಧೆ ಮಾಡ್ತಾ ಇದ್ರೆ ಅವರು ಪ್ರೊಫೆಷನಲ್ ಅಲ್ಲ. ಎನಿ ಡಾಕ್ಟರ್ ಯು ಮೇ ಹ್ಯಾವ್ ದಿಸ್ ಬ್ಯಾಚ್ ಆಫ್ ಡಾಕ್ಟರ್, ಬಟ್ ಇಫ್ he is not rendering service, public service, if his aim is to earn money, he is not a doctor, he is not a professional, he is a businessman. He is serving. See, at this age, last time when I came to Bijapur, he came to greet me. By then he had taken rounds. He had completed his rounds and then he came to meet me. Now aವಾಗಿನ ಕಣ್ಣು ಕಂಬಳಲ್ಲಿ ಹಿಂಗೆ ಹೊರಗೆ ಬಂದಿದೆ, ಡಾಕ್ಟರ್ ಬಂದಿದೆ ಅಷ್ಟೊತ್ತಿಗೆ ಮಾತಾಡ್ಸಕ್ಕೆ. So he is on job. Patients are there. ಆ ಪೇಷಂಟ್ ಏನನ್ನಾಗಲಿ ಅವ್ರ ಜೋಡಿ ಇದ್ದವ್ರಿಗೆ ಡಾಕ್ಟ್ರ್ ಬಂದು ಹೋಗ್ಯಾರಂತ, ಡಾಕ್ಟ್ರ್ ಬಂದು ಹೋದ್ರೆ ಅಷ್ಟು ಸಮಾಧಾನ ಆಗ್ತದೆ. ಸೊ ಈಸ್ ಎ ಪ್ರೊಫೆಷನಲ್, ಹಿ ಹ್ಯಾಸ್ ಟು ಡೂ ದಟ್. ಬಟ್ ಸಂಬಡಿ ಎಲ್ಸ್, ಇಫ್ he is doing it for money, he is not a professional. Earning should be incidental to practice of profession. ಅಲ್ಲಿ ಮಂಡ್ಯದಲ್ಲಿ ಒಬ್ಬರು ಡಾಕ್ಟರ್ ಇದ್ದಾರೆ, ₹5 ಡಾಕ್ಟರ್, ನೋಡಿರಲ್ಲ ವಾಟ್ಸಪ್ನಾಗ ಎಲ್ಲ ಕಡೆ ಬರ್ತೀವಿ. ಅವ್ರು ಹೋಗಿ ಬಸ್ ಸ್ಟಾಪ್ನಾಗ ಅದು ಕಟ್ಟೆ ಮ್ಯಾಗ ಏರ್ಕೊಂಡು ಕುಂತ್ಬಿಟ್ಟಿರ್ತಾರೆ, ಒಂದು ದೊಡ್ಡ ಕ್ಯೂನೇ ಬರ್ತಿರ್ತಾರೆ ಜನ. ₹5 ಅಂತೆ. ಅವರು ನೋಡ್ತಾರೆ, ಡಯಾಗ್ನೋಸ್ ಮಾಡ್ತಾರೆ, ಮೆಡಿಸಿನ್ ಬರ್ಕೊಡ್ತಾರೆ. ದೇರ್ ವಾಸ್ ಒನ್ ಡಾಕ್ಟರ್ ಶಂಬಣ್ಣ ಇನ್ ಮೈಸೂರು JSS. ಅವರೊಂದು ಉಂಡಿ ಇಟ್ಬಿಟ್ಟಿದ್ರು ಆಸ್ಪತ್ರೆಗೆ. ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡ್ರೆ ನಿಮ್ಮದು ಫೀಸ್ ಏನಿದ್ರು ಅದ್ರಾಗ ಉಂಡೆಗೆ ಹಾಕಿ ಹೋಗಿ ಕೇಳೋದು. ಅದು ನಾನು ನೋಡಿಲ್ಲ ಉಂಡಿ, ಬಟ್ ಐ ಹ್ಯಾವ್ ಹರ್ಡ್ ಆಫ್ ಇಟ್. ಮತ್ತೆ ವಾಪಸ್ ರೊಕ್ಕ ತಗೊಂಡು ಹೋಗಕ್ಕೆ ಬರ್ತಿರ್ತಿಲ್ಲೋ ಗೊತ್ತಿಲ್ಲ. ಅದ್ರಾಗ ವೆರಿ ಸ್ಪೆಷಲ್ ಪೀಪಲ್, ವಿ ರೆಸ್ಪೆಕ್ಟ್ ದೆಮ್, ವಿ ರೆಸ್ಪೆಕ್ಟ್ ದೆಮ್. ದೇ ಆರ್ ಪ್ರೊಫೆಷನಲ್ಸ್. ಸಿ, profession is bigger than career. A doctor should not think in terms of making a career out of the practice of medicine. Career is very small. Profession is bigger than career. And life is bigger than profession. We have to understand this difference. We should not be in confusion. What happened from those standards, pro bono publico service? See, what a chandra. Profession is not a private guild like that of bakers, butchers and candlestick bakers. ಮಾಂಸ ಮಾರುವ ಸಂಘ ಬೇರೆ, ವಕೀಲರು ಸಂಘ ಹಂಗಾಗಬಾರ್ದು. ವೈದ್ಯಕೀಯ ವೃತ್ತಿಯಲ್ಲಿರೋ ಸಂಘ ಆ ಥರ ಆಗಬಾರ್ದು. ಅವ್ರು ಇರ್ತಾರೆ, ಬಿಸ್ನೆಸ್ ಮಾಡೋರು ಇರ್ತಾರೆ, ಆ ವ್ಯಾಪಾರಿಗಳು, ಈ ವ್ಯಾಪಾರಿಗಳು, ಅವರೊಂದು ಸಂಘ, ಚೇಂಬರ್ ಆಫ್ ಕಾಮರ್ಸ್, ಅದು ಇದು ಏನೇನೋ ಮಾಡ್ಕೊಂಡಿರ್ತಾರೆ. ದೇ ಆರ್ ಬಿಸ್ನೆಸ್ ಪೀಪಲ್, ದೇ ಆರ್ ರೈಟ್ ಇನ್ ದೇರ್ ಪ್ಲೇಸ್. ಬಟ್ ದೀಸ್ ಪೀಪಲ್ ಆರ್ ಪ್ರೊಫೆಷನಲ್ಸ್. That is not a private guild of bakers and butchers. By contrast, they are learned people. If you are learned people, you have to behave and conduct yourself in a manner which is worthy of emulation. ನಿಮ್ಮನ್ನು ನೋಡಿದ್ರೆ, ನಿಮ್ಮ ಸೀನಿಯರ್ ಡಾಕ್ಟರ್ನ ಯಾರು ನೋಡಿದರೆ, ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ನ ಒಬ್ಬರು ನೋಡಿದ್ರೆ ಉಳಿದಾರ ಹಿಂಗಾಗಬೇಕು ನಾವು ಅಂತ ಅವರಿಗೆ ಅನಿಸ್ಬೇಕು. That is the requirement, because you are learned people. And society has conferred autonomy on these professions because of this learning. We say the most basic preliminary training for a professional is intellectual in character, as distinguished from mere skill. Skills are different, intellectual abilities are different. So what happened? Society created trust in favor of the profession because of their ability, knowledge. We feel our interest is safe in your hands. And once we started feeling that our interest is not protected in your hands, legislation comes. See, profession is an area which should never be touched by legislations. We should not legislate in some areas, but unfortunately we have legislated in this area also, because that legislation became necessary. And because laws have come, You are on the defensive. You are on the defensive. Of the 10 commandments which Dr. Ramdas gave, ಅವ್ರು ಏನಂತಾರೆ, ನೀವೆಲ್ಲ ಕತ್ತಿ ಬಿಟ್ಬಿಟ್ರಿ, ಗುರಾಣಿ ಹಿಡ್ಕೊಂಡು ನಿಂದಿರಿ. ಸೇವ್ ಯುವರ್ ಸ್ಕಿನ್. ಅವರು ಡರ್ಮಟಾಲಜಿಸ್ಟ್. ಸೇವ್ ಯುವರ್ ಸ್ಕಿನ್. ನಾನು ಬದುಕಿಂದ ಸಾಕು, ಮೊದಲು ಪೇಷಂಟ್ ಏನನ್ನಾಗಲಿ ಏನನ್ನಾಗಲಿ, ನಾನಿಲ್ಲಿ ಇದನ್ನು ಮುಟ್ಟಬೇಕಂತಂದರೆ ಆ ಕೋರ್ಟಿನ ವಿಚಾರ ಮಾಡಿ ಬಿಟ್ಬೇಕು. ಏನಿಟ್ಕೋಬೇಕು? ಇವು ಡಾಕ್ಟ್ರು ಭಾಳ ವಿಚಿತ್ರ ಇರ್ತಾರೆ. ನಮ್ಮ ಡಾಕ್ಟ್ರ್ ಒಬ್ಬರು ಫೋನ್ ಮಾಡಿದ್ರು, ದೋಸ್ತ ನನಗೊಂದು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಬೇಕು. ಏನು? ಅವರು ಏನಿದು ಆರ್ಥೋಪೆಡಿಕ್ ಡಾಕ್ಟರ್. ಒಬ್ಬ ಬಂದಿದ್ದ, ನನ್ನ ಹಾಸ್ಪಿಟ್ಲ್ನಾಗ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದ. ಒಬ್ಬನೇ ಬಂದಿದ್ದ ಅವನು. ಯಾಕೆ ಬಂದಿದ್ದಂತೆ, ಅಲ್ಲಿ ಹೋಟೆಲ್ನಾಗ ಧಾರವಾಡ ಹೋಟೆಲ್ ಲಾಡ್ಜ್ನಾಗಿದ್ದ. ಜಾಕೆಟ್ ಬಿದ್ದಾನ, ತಾನೇ ಬಂದು ಅಡ್ಮಿಟ್ ಆಗಿದ್ದ, ಯಾರು ಅಟೆಂಡೆನ್ಸ್ ಇಲ್ಲ. ಫಿಕ್ಸ್ ಮಾಡಿದ್ವಿ, ಸರ್ಜರಿ ಮಾಡಿ ಭಾಳ ಎಲ್ಲ ಸರಿ ಹೋಗಿತ್ತು. ಆಮೇಲೆ ಇದ್ದಕ್ಕಿದ್ದಂಗೆ ಅದೇನೋ ಬ್ಲಡ್ ಕ್ಲಾಟ್ ರಿಲೀಸ್ ಆಗಿ ಏನಾಗಿ ಹಾರ್ಟ್ ರಿಲೀಸ್ ಆಗಿ ಸತ್ತೋಗ್ಬಿಟ್ಟ. ಏನು ಮಾಡೋದು ಈಗ? ಆ ಡೆಡ್ ಬಾಡಿನ ತಗೊಂಡು ಹೇಳೋರಿಲ್ಲ ಕೇಳೋರಿಲ್ಲ. ಅವನು ಬಾಜು ಬೆಡ್ನ ಒಂದು ಫೋನ್ ಇಸ್ಕೊಂಡು ಯಾರಿಗೋ ಫೋನ್ ಮಾಡಿದ್ದಂತೆ. ಅವನ್ನ ಕೇಳಿ ಯಾರಿಗೆ ಫೋನ್ ಮಾಡಿದ್ದ ಅದನ್ನು ಚೆಕ್ ಮಾಡಿ ಅದು ಫೋನ್ ಮಾಡಿದ್ರು. ಒಬ್ಬ ರೋಟ್ರಿ ಕ್ಲಬ್ ಮೆಂಬರ್, ಧಾರವಾಡದಲ್ಲಿ ರೋಟ್ರಿ ಕ್ಲಬ್ ಮೆಂಬರ್ಗೂ ಇದ್ದಾನೆ ಫೋನ್. ಇಲ್ಲರಿ ಅವ್ರು ನಮಗೆ ಪರಿಚಯ, ಬರ್ತೀವಿ ಅಂತಂದು ಅವ್ರು ಬಂದರು. ಡೆಡ್ ಬಾಡಿ ಕೊಡ್ರಿ, ನಾವು ಕ್ರಿಮೇಷನ್ ಮಾಡ್ತೀವಿ. ನಾವು ಡೆಡ್ ಬಾಡಿ ತಗೊಂಡು ಹೋಗ್ತೀವಿ ಅಂತ ಬರ್ಕೊಡ್ರಿ. ಬರ್ಕೊಟ್ರು. ಇವಾಗ ಅದನ್ನು ತಗೊಂಡು ಡೆಡ್ ಬಾಡಿ ಕೊಟ್ಟು ಹೋಯ್ತು. ಹೋದ್ಮೇಲೆ ಡಾಕ್ಟ್ರಿಗೆ ಅನುಮಾನ, ನಾನು ಮಾಡಿ ಸರಿ ಆಯಿತು ಇಲ್ಲೋ ಅಂತ ನನಗೆ ಫೋನ್ ಮಾಡಿದೆ. ನಾನು ಹಿಂಗೆ ಮಾಡಿದ ದೋಸ್ತ ಸರಿ ಐತಿಲ್ಲ ಅಂತ ಪರ್ಫೆಕ್ಟ್ ಅಂತಂದು ಹೇಳ್ಬಿಟ್ಟೆ ನಾನು. ನೀವು ಹೇಳ್ತಾರಲ್ಲ ಡಾಕ್ಟರ್ ಪೇಷಂಟ್ ಬಂದಾಗ, ವಾಟ್ ಯು ಹ್ಯಾವ್ ಡನ್ ಇಸ್ ಟೋಟಲಿ ಆಸ್ ಪರ್ ಲಾ, ಡೋಂಟ್ ವರಿ. He has done it already. ನಾವು ಮತ್ತಿನ ಯಾಕೆ ಎದುರಿಸ್ಬೇಕು? ಡಾಕ್ಟ್ರ್ ಮನೆ ಕಡೆ ನಿದ್ದೆ ಮಾಡಿ ಚಂದ. ಡಾಕ್ಯುಮೆಂಟೇಷನ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ವಾಟ್ ವಿ ಹ್ಯಾವ್ ಟು ಡೂ? ಸರ್ಟನ್ ಆಫ್ ದಿ ಪ್ರಿನ್ಸಿಪಲ್ ಒಂದು ಒಳ್ಳೆ ಪುಸ್ತಕ ಇದೆ, ದಿ ಪ್ರೊಫೆಷನಲ್ ಅಂತ, ಸುಬ್ರತ ಬಗ್ಚಿ ಬಂದರೆ. Police, you also can be professional. The driver can be professional. This teacher can be professional. Everybody can be a professional in another sense, common sense. A student can be professional. To become a professional, the requirements are, can you work unsupervised? You should have ability to work unsupervised. ಇವ್ರು ಮಾಡ್ತಾರೆ, ಪೆಟ್ರೋಲಿಂಗ್ ಕಳಿಸ್ತಾರೆ ಕೆಳಗಡೆ ಇದ್ದವ್ರನ್ನ, ಕಾನ್ಸ್ಟೇಬಲ್ ಒಬ್ಬೊಬ್ಬನೇ ಕಳಿಸೋದಿಲ್ಲ. ಪೆಟ್ರೋಲಿಂಗ್ ಇಬ್ಬರಿಬ್ಬರನ್ನ ಕಳಿಸ್ತಿರ್ತಾರೆ, ಕಳಿಸಿ ಮತ್ತೆ ಅವ್ರನ್ನ ಟ್ರ್ಯಾಕ್ ಮಾಡ್ತಿರ್ತಾರೆ. ರೈಟ್? ಇಫ್ ದಟ್ ಕಾನ್ಸ್ಟೇಬಲ್ ಕ್ಯಾನ್ ಡೂ ದಟ್ ಪೆಟ್ರೋಲಿಂಗ್ ಜಾಬ್ unsupervised, higher officers can spend their time for something else. Otherwise they have to supervise this one. Each one should be in a position to work unsupervised. And second, I should have ability to certify the completion of my work. I have done this job, I should feel happy about what I have done. And third, I have to do it with integrity. The standard question to be asked is, if my daughter comes to know what I have done, whether she will feel ashamed that her father has done this. This is the yardstick. If I feel my daughter will feel ashamed because of what I have done, I should not do that. Maybe difficult standard to be accepted, but these are the things which are preached. Doctors have become defensive. So I have read a large judgment I have read in my note, total judgment I have read. 7 crores compensation awarded for that. Analgesic. So that is huge. Doctor will go bankrupt. He will be liquidated. One such judgment, so doctor becomes defensive. The question arises, ethical dilemma, whether doctor should become defensive. Individually, you may be right when you say you should become defensive, but you will cease to be a professional once you are on the defense. That chilling effect is there, but a true professional should not bother. He has to customize depending upon the situation, he has to render services. Violence against Medicare workers. We got that law amended because of Yogananda Reddy, Pawan Kumar and all these people. That ambulance driver was not covered. Front office personnel were not covered. They were not Medicare workers. And they are the people who will be attacked first. Okay. Then they said we have to amend the law. Government of Karnataka accepted the argument and they amended that legislation. The question arises, why common people are beating professionals? ಪೇಪರಲ್ಲಿ ಬರೋದೇ ಬೇರೆ, ನಮಗೆ ಅರ್ಥ ಆಗೋದೇ ಬೇರೆ. ಎಲ್ಲೋ ಒಂದು ಹಾಸ್ಪಿಟಲ್ನಾಗ ನುಗ್ಗಿ ಡಾಕ್ಟ್ರಿಗೆ ದನಕ್ಕೆ ಬಡ್ದಂಗೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ರು. ಅಲ್ಲಿ ಒಂದು ಕಡೆ ಡಿಸ್ಕಷನ್ ಮಾಡುವಾಗ ಅದು ಬಂತು, ಜನ ನುಗ್ಗಿ ಡಾಕ್ಟ್ರಿಗೆ ಗಂಡ ಹೆಂಡತಿಗೆ ಎಲ್ಲ ಹಿಂಗೆ ಹೊಡೆದಿದ್ರು ಹಂಗೆ ಹೊಡೆದಿದ್ರು. ಅಲ್ಲಿ ಒಬ್ರು ವಕೀಲರು ಇದ್ದರು, ಅವ್ರು ಎದ್ದು ನಿಂತಿದ್ರು, ಸರ್ ಬಿಚ್ಚಿ ಹೇಳಿ ಯಾಕೆ ಹೊಡೆದ್ರು, ಅದನ್ನೆಲ್ಲ ತಗೊಂಡು ಇಲ್ಲೇನು ಮಾಡಿದ್ರು ಹೇಳ್ರಿ, ಯಾಕೆ ಹೊಡೆದ್ರು ಅನ್ನೋದು ಹೇಳ್ರಿ, ನೀವು ಓಪನ್ ಆಗಿ ಹೇಳ್ರಿ. ಅದು ಆಸ್ಪತ್ರೆ ಮೇಲೆ ಮನೆ, ಡಾಕ್ಟರ್ ಮನೆ, ಅವ್ರದ್ದೊಂದು ದೊಡ್ಡ ರಾಕ್ಷಸನಂತ ನಾಯಿ ಸಾಕ್ಯದ. ಹುಟ್ಟಿದ ಮಗನ್ನ ಆ ನಾಯಿ ಬಂದು ತಿಂದ್ಬಿಟ್ಟದು. ಕೊಡೋದು ಅವ್ರು ಅದನ್ನ ಹೇಳೋರು, ಡಾಕ್ಟ್ರಿಗೆ ಹೊಡೆದಾರ. ಅರೆ ಅದೇ ಆಗಲಿ, ಅದು ಹುಟ್ಟಿದ ಕೂಸಿನ ನಾಯಿ ಬಂದು ತಿನ್ನೋದಂತಂದ್ರೆ ಏನೋ ಹೊಡಿಲಾರ್ದ ಬಿಡ್ತಾರೆ. Utter negligence. See, certain of the things. ಪೊಲೀಸರು ಕುರ್ಚಿ ಅಲಗಾಡಬಾರ್ದು. See, we have to look into specific cases, then only we will understand when a noble profession loses its nobility. ನಾನು ಡಾಕ್ಟರ್ ಬಗ್ಗೆ ಹೇಳ್ತೇನಂತಲ್ಲ, ನಾವು ಲಾಯರ್ಸ್ ಬಗ್ಗೆ. ಬಿಫೋರ್ ಮೆಮರಿ ಫೇಡ್ಸ್ ಅಂತ ಫಾಲಿ ನಾರಿಮನ್ ಅವರು ಒಂದು ಪುಸ್ತಕ ಬರ್ತಾರೆ, ಅದರಲ್ಲಿ ಕೊನೆಗೆ ಬರ್ತದೆ ಡಾಕ್ಟರ್ ಇದು ನಮ್ಮ ವಕೀಲರ ಬಗ್ಗೆ ಎಲ್ಲ ಬರೆದು. ವಾಟ್ ವಿ ವಿಲ್ ಡೂ, ವಿ ಹ್ಯಾವ್ ಲಾಸ್ಟ್ ರೆಸ್ಪೆಕ್ಟ್ ಇನ್ ದ ಸೊಸೈಟಿ. ಅವರು ವಕೀಲರನ್ನು ನೋಡಿದ್ರೆ ಜನ ಗೌರವ ಕೊಡೋದಿಲ್ಲ, ಭಯ ಪಡ್ತಾರೆ. ಏನು ಮಾಡೋದು, ಅವ್ರು ಕೊನೆಗೆ ಹೇಳ್ತಾರೆ, ಮೇಕ್ ಲಾಯರ್ಸ್ ಗುಡ್. ಹೌ ಯು ಮೇಕ್ ಲಾಯರ್ಸ್ ಗುಡ್? ಸೀನಿಯರ್ಸ್ ಶುಡ್ ಬಿಹೇವ್ like a role model. Juniors should follow their seniors. That's what they say. Maybe we do not know much about doctors' profession. Make doctors good sometimes, so that we will respect you. We will not fear you. We will respect you. Be in professional limits. That is a wonderful advice, sir. Doctors should know their limits. Otherwise, they will run into problems. Write in capital letters. ನಾವು ಭಾಳ ಚಂದ ಹೇಳ್ತೀವಿ ಕಾನೂನು. And 26th we are going to have a conference in Bangalore as to how to make laws in simple language. ಇದು ಒಂದು ಕಾನ್ಫರೆನ್ಸ್ ಮಾಡೋಕ್ಕೆ, ಮೇಕಿಂಗ್ ಲಾ ಇನ್ ಸಿಂಪಲ್ ಲ್ಯಾಂಗ್ವೇಜ್. ಡಾಕ್ಟರ್ ಹೇಳ್ತಾರೆ, ಯಾಕೆ ನಿಮಗೆ ಸೀದಾ ಬರೆಯಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅಂತ. ಅವರು ಹೇಳಿದ್ರಲ್ಲ ಸ್ಕ್ರಿಬ್ಲಿಂಗ್. ಈ ಮೊದಲು ರೈಟಿಂಗ್ ಇತ್ತು, ಆಮೇಲೆ ಈ ಡಾಕ್ಟರ್ ಬಂದಾಗಲಿಂದ ಸ್ಕ್ರಿಬ್ಲಿಂಗ್ ಸ್ಟಾರ್ಟ್ ಆಯಿತು. ಹಿಂಗೆ ಬರ್ಕೊಟ್ಬಿಡ್ತಾರೆ. ಚಂದ ಹೇಳಿದ್ರೆ ಯಾರೋ ಪತ್ರ ತಗೊಂಡು ಬಂದಿದ್ರು ಅಂತ, ಇದು ಓದ್ರಿ ಏನೋ ಬರೆದ್ರು. ಅವರೊಬ್ಬರು ಡಾಕ್ಟ್ರು ಸ್ವಲ್ಪ ಹೆಂಡತಿಗೆ ಜಾಸ್ತಿ ಗೌರವ ಕೊಡ್ತಿದ್ರು. ಎಮರ್ಜೆನ್ಸಿ ಕಾಲ್ ಬಂತು, ಆ ಹೆಣ್ಮಗಳು ಮಲಿಕೊಂಡಿದ್ಲು. ಸಿಮ್ಮನ್ನ ಎಬ್ಸೋದು ಬೇಡ ಅಂತಂದೇಳಿ ಒಂದು ಚೀಟಿ ಬರೆದಿಟ್ಟು ಬಿಡೋಣ ಅಂತಂದು ಚೀಟಿ ಬರೆದಿಟ್ಟು ಹೋಗ್ಬಿಟ್ರು. ಆ ಹೆಣ್ಮಗಳೆಲ್ಲ ನೋಡಿದ್ಲು, ಏನೋ ಬರ್ದು ಏನೋ ಅಂತ. ಡಾಕ್ಟ್ರಲ್ಲ, ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಅರ್ಥ ಆಗಿಲ್ಲ. ಆ ಮೆಡಿಕಲ್ ಶಾಪ್ಗೆ ಬರಲಂತೆ, ಸ್ವಲ್ಪ ನೋಡ್ರಿ ಇದನ್ನ ಅಂತ. ಅವರು ಅದನ್ನು ನೋಡಿ, ಮೇಡಮ್ ಎಷ್ಟು ಬೇಕು ನಿಮಗೆ ಅಂತ ಕೇಳಿ. ಸರ್, ಅಡ್ವರ್ಟೈಸ್ಮೆಂಟ್ ಬರೋಕೈತವ, ನಿಮ್ಮ ಡಾಕ್ಟ್ರ್ ಏನು ಪ್ರಿಸ್ಕ್ರೈಬ್ ಮಾಡಿರ್ತಾರಲ್ಲ ಅದೇ ಔಷಧಿ, ಅದೇ ಕಾಂಬಿನೇಷನ್ನು 40% ರೇಟ್ನಾಗ ನಿಮಗೆ ಕೊಡ್ತೀವಿ, ಇದನ್ನು ಡೌನ್ಲೋಡ್ ಮಾಡಿರಿ, ಇಲ್ಲಿಗೆ ಕಳಿಸ್ಕೊಡ್ರಿ ಅಂತ ಅವ್ರು ಹೇಳಿದರು. ಗೂಗಲ್ ಮಾಡೋದು ಅದು ಇಂಥ ಪರಿಸ್ಥಿತಿ. ಒಂದು ಏನು ಹೇಳ್ತಾರೆ ಅಂತಂದರೆ, In factory we manufacture cosmetics. In showroom we sell hopes. 5 ದಿವಸದಾಗ ಗೌರವ ವರ್ಣ ಆಗಿಬಿಡ್ತದೆ. 1 ತಿಂಗಳಲ್ಲೆಲ್ಲ ಫುಲ್ ಕ್ರಾಪ್. ಹಂಗಾಗೋದಿಲ್ಲ. They are selling hopes. ರೈಟ್. ಈ ಚಂದ ಆಗಬೇಕು. ಕರ್ಕೊಂಡು ಹೋದರು. ಡರ್ಮಟಾಲಜಿಸ್ಟು ಎಲ್ಲ ನೋಡಿದರು, ಬರ್ಕೊಟ್ರು. ಮುಂಜಾನೆ ರಾತ್ರಿ ಮಲಿಕೆವಾಗ ಇದನ್ನು ಹಚ್ಕೊಂಡು ಮಲಿಕೆಬೇಕು. ಮುಂಜಾನೆ ಎದ್ದ ತಕ್ಷಣ ಸ್ವಚ್ಛ ಮುಖ ತೊಳ್ಕೊಂಡು ಇದನ್ನು ಹಚ್ಕೋಬೇಕು. ಆಮೇಲೆ 2 ತಾಸು ಆದಮೇಲೆ ಮತ್ತೆ ಸ್ವಚ್ಛ ಮುಖ ತೊಳ್ಕೊಂಡು ಇದನ್ನು ಹಚ್ಕೊಂಡು ಹೊರಗೆ ಹೋಗ್ಬೇಕು. ಮತ್ತು ಹೊರಗೆ ಬಂದಮೇಲೆ ಇದು ಮುಂಜಾನಿಂದ ಸಂಜೆ ಅನ್ನತ್ತೆ ಕೆಂಪಾಗಿ ಹೋಗ್ತದೆ. ವಿಚಿತ್ರ. ಈಗ ಹಿಂಗಾದ್ರಲ್ಲಿ ಏಕೆ ಅಂತ ಮತ್ತೇನು ಮಾಡೋದು? ಮತ್ತೆ ವಾಪಸ್ ಹೊರತಕ್ಕ ಡರ್ಮಟಾಲಜಿ. ಮತ್ತೆಲ್ಲ ಡೂ ಒನ್ ಥಿಂಗ್, ಡೋಂಟ್ ಅಪ್ಲೈ ಆಲ್ ಆಫ್ ದಮ್. ಅರೆ ಮೊದಲು ಬರ್ದನೆ ಹಾಕಿ ಬಿಟ್ರು ನಾನು ಮತ್ತೆ ಹೋದ್ರೆ ಡೋಂಟ್ ಬಿಕಮ್ಸ್ ವೆರಿ ಡಿಫಿಕಲ್ಟ್. ಅವ್ರು ಔಷಧಿ ಕೊಡ್ತಾನೆ, ನಾವು ಅವನು ಒಂದ್ಗಡೆ ಅವನು ಹೇಳ್ತಾನೆ ಈ ಕಂಪ್ನಿ ಇಲ್ಲ ಸರ್, ಬೇರೆ ಕಂಪ್ನಿದು ಸೇಮ್ ಔಷಧಿ ಕೊಡ್ಲೇನ ಅಂತ ಕೇಳ್ತಾನೆ. ಅವ್ನು ಹಂಗೆ ಮಾಡ್ತಾನೆ ಅಂತಂದು ಇವ್ರಿಗೆ ಗೊತ್ತಿರೋದಕ್ಕೆ ಇವ್ರು ನಮಗೊಂದು ಅಡುಗೆ ನಾನು ಎಲ್ಲೆಲ್ಲ PhD ಮಾಡೀನಿ. ಅವ್ರು ಹೇಳ್ತಾರೆ ಪಾಟೀಲ್ರೆ ಗುಳಿಗೆ ತಗೊಂಡ್ಮೇಲೆ ಬಂದು ತೋರಿಸಿ ಹೋಗಿರುತ್ತೆ. ಗುಳಿಗೆ ತಗೊಂಡು ಮತ್ತೆ ವಾಪಸ್ ಅವ್ರ ತನಕ ಹೋಗ್ಬೇಕು, ಹೋಗಿ ತೋರಿಸ್ಬೇಕು. ಈ ಕನ್ಫ್ಯೂಷನ್ನಾಗ ಏನಾಗ್ತದೋ ಏನಿಲ್ಲೋ. ಮೊನ್ನೆ ಒಬ್ಬರು ಡಾಕ್ಟರ್ ನಾಗ್ನೂರ್ ಅಂತ ಇದರಲ್ಲಿ ಸಾಹೇಬರು ಅವರು ನನಗೆ ಒಂದಿಷ್ಟು ಮೆಸೇಜ್ ಕಳಿಸಿದ್ರು ಅಬೌಟ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನೀಸ್, ಅಬೌಟ್ ಫಾರ್ಮಸ್ಯೂಟಿಕಲ್ಸ್ ಆ್ಯಂಡ್ ಅಬೌಟ್ ಬಿಗ್ ಕಾರ್ಪೊರೇಟ್ ಹಾಸ್ಪಿಟಲ್ಸ್ ಎಲ್ಲ ಹೇಳಿ ಲಾಸ್ಟಿಗೆ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಬರೆದು, ಇಟ್ ಈಸ್ ಎ ಕ್ರೈಮ್ ಟು ಫಾಲ್ ಇನ್ ದಿಸ್ ಕಂಟ್ರಿ. ಇಫ್ ಯು ಫಾಲ್ ಇನ್ ದಿಸ್ ಕಂಟ್ರಿ ಇಟ್ ಈಸ್ ಎ ಕ್ರೈಮ್. ದಟ್ ಈಸ್ ದಿ ಸಿಚುವೇಶನ್ in which we are living. So it is time for us to introspect as to where we are going. As I have told you, if we do not retain that confidence of the society in the profession, law will come. And it is always very, very bad for any professional to get loss in this area. ಈ ವಕೀಲರಿಗೆ ಡಾಕ್ಟ್ರಿಗೆ ಒಂದು ಸ್ಪರ್ಧೆ ಇತ್ತಂತ. ಡಾಕ್ಟ್ರ್ ಹೇಳಿದರು ನಾವು ಬರೆದದ್ದು ಯಾರಿಗೆ ತಿಳಿಯೋದಿಲ್ಲ ಅಂತ. ವಕೀಲರು ನಾವು ಬರೆದು ಪ್ರಿಂಟ್ ಮಾಡಿ ಹಂಚ್ತೀವಿ, ಯಾರಿಗೆ ತಿಳಿಯೋದಿಲ್ಲ. ಅದಕ್ಕೆ ಅಲ್ಲೊಂದು ಗೋಡೆ ಮೇಲೆ ಹಾಕೋದು ಇದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಇರ್ತಾವಲ್ಲ, ಅಲ್ಲಿ ಸ್ವಪ್ನ ಬುಕ್ ಹೌಸ್ನಾಗ ಬೆಂಗಳೂರಾಗ ಮಾರ್ತಿರ್ತಾರೆ, ಅಲ್ಲಿ ಹೋಗಿ ನೋಡಿದ್ರು ಒಂದು ಭಾಳ ಚಂದ ಬರೋದು. A lawyer robs and a doctor robs and kills. ಇಂಥ ಪ್ಲೇಟ್ಗಳು ಮಾರಾಟ ಆಗಬಾರ್ದಂತಂದರೆ ನಾವು ಈ ಥರ ವೇದಿಕೆಯಲ್ಲಿ ಇದೆಲ್ಲ ಚರ್ಚೆ ಮಾಡಿ ನಮ್ಮ ಕ್ಷೇತ್ರ ಏನೈತೆ ಅನ್ನೋದನ್ನು ನಾವು ಸರಿಯಾಗಿ ತಿಳ್ಕೊಂಡು ಆ ಕ್ಷೇತ್ರದಲ್ಲಿ ಇದು ಕೆಲಸ ಮಾಡಬೇಕು. PLD ಸಂಸ್ಥೆ ದೊಡ್ಡ ಸಂಸ್ಥೆ. ಇಬ್ಬರಿಗೆ ಅವರು ಅವಾಗವಾಗ ಈ ರೀತಿ ಕಾರ್ಯಕ್ರಮಗಳನ್ನು ಹೇಳ್ತಿರ್ತಾರೆ. ನಮ್ಮ ರಘುವೀರ್ ಕುಲಕರ್ಣಿ ಭಾಳ ಎತ್ತರದ ಮನುಷ್ಯ, ಅವರು ಸಣ್ಣ ವಿಚಾರ ಮಾಡೋದಿಲ್ಲ, ಉಚ್ಚ ಮಟ್ಟದ ವಿಚಾರ ಮಾಡಿ ಇಷ್ಟೆಲ್ಲ ಜನರು ನಮ್ಮನ್ನೆಲ್ಲ ಸೇರಿಸಲೇ ಅವರಿಗೆ ಅಭಿನಂದನೆಗಳು. ಲಾಸ್ಟ್ ಒಂದು ವಿಚಾರ, ಲಕ್ಷ್ಮಣ್ ನಿಮ್ಮಲ್ಲಿ ಸಾಹೇಬರು ಅಲ್ಲಿ ಕೂತಾರಂತ. ನನ್ನ ಹತ್ರ ಒಂದು ಫೋಟೋ ಇದೆ. 22ನೇ ತಾರೀಕು ಬೆಂಗಳೂರಲ್ಲಿ ಒಂದು ಫಂಕ್ಷನ್ ಆಯಿತು. ವೀರಪ್ಪ ಮೊಯ್ಲಿ ಅವರು, ಜಸ್ಟಿಸ್ ನಾಗಮೋಹನ್ ದಾಸ್ ಅವರು, ಒಬ್ಬ 2 ವರ್ಷ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿರೋ ಒಬ್ಬ ವಕೀಲ, ಒಬ್ಬ ಯೂನಿವರ್ಸಿಟಿ ರಿಜಿಸ್ಟ್ರಾರ್, ಇವರು 4 ಜನ ವೇದಿಕೆ ಮೇಲಿದ್ದರು. ಜಸ್ಟಿಸ್ ಸಂತೋಷ್ ಹೆಗಡೆ, BV ಆಚಾರ್ಯ, ಇವರೆಲ್ಲ ಆಡಿಯನ್ಸ್ನಾಗ ಕೂತಿದ್ರು. ಕರೆಕ್ಟ್ ಐತೆ ಸರ್, ಯಾರೆಲ್ಲಿ ಕುಂದಿರ್ಬೇಕು ಅಲ್ಲೇ ಕುಂದಿರ್ಬೇಕು, ಅವಾಗೇ ಗೌರವ ಅದಕ್ಕೆ. ಥ್ಯಾಂಕ್ ಯು.
Thank you, sir, for your encouraging and thoughtful remarks. Now I request Mrs. Sana Kausar Mughlai, lecturer, School of Law, to present the vote of thanks.
Gratitude is the sign of noble souls. With immense pleasure and deep sense of gratitude, I take this opportunity to propose the vote of thanks on behalf of BLD School of Law, Dean to be University Vijaypura. First and foremost, I express my sincere thanks Today's chief guest, Dr. Arun C. Inamdar sir, Honorable Vice Chancellor BLD Deemed to be University, for his encouragement and support towards the academic initiatives. I extend my heartfelt thanks to today's President of the function, Professor Dr. C.S. Patil sir, Director Kilpar, Bangalore, for his constant support, guidance and presiding over today's session. I also thank to guest of honor, Dr. R.V. Kulkarni sir, Registrar, BLD Deemed to be University, for his valuable presence and support. I extend our special gratitude to Dr. Revaya Odier, sir, Research Head, Kilpar, Bangalore, for delivering the inspiring inaugural address and sharing the valuable insight on the topic. I sincerely thank Professor Dr. R.G. Kulkarni, Dean and Principal, School of Law, BLD Deemed to be University, for his warm welcome and continuous support in organizing this seminar. I would also like to extend our heartfelt thanks to all the distinguished members who participates. My sincere appreciation goes to all the police department officers who have joined us today. I also extend our sincere thanks to doctors and medical professionals present here today. Your participation adds immense value to discussion as the topic of medical negligence directly concerns both medical and legal professions. My heartfelt thanks to all the teaching faculty members for their guidance and encouragement, and to the non-teaching staff for their valuable support in making this event successful. A special word of appreciation goes to organizing committee. I also extend my sincere thanks to IT department for their technical assistance and smooth management. I would also like to thank all the students for their active participation and support. Finally, I express our sincere gratitude to each and every participant present here today whose presence made this seminar a grand success. Thank you one and all. Have a good day.
To conclude the program, I request all the dignitaries and the audience to kindly rise for the national anthem.
Thank you all. I request all the dignitaries to please take their seats. So now it's time to have the technical sessions. Medicine saves lives and law safeguards the justice. With this, we conclude the inaugural session of the sessions, and then after the paper presentations. So now we will start with the technical sessions. as we all know that we have completed the inaugural session, now we move forward for the technical sessions. So now first will be the first technical session.
Good morning everyone. My name is Pragati Karni from second year LLB. Let us begin this technical session with a beautiful quote. Law and medicine are two noble professions that share a common objective, the protection of human life and dignity. When medical care falls short of the expected standards, the law intervenes to uphold justice and accountability. Ladies and gentlemen, to begin this technical session, it is my honor and privilege to invite our distinguished guest, Dr. Yoganand Reddy Sir, President, Karnataka Medical Council, Bellary, to kindly grace the dais. Sir, on behalf of organizing committee, faculty members and all the participants present here, I extend a very warm and cordial welcome to you, sir. We are truly delighted and honored by your gracious presence at this seminar on laws relating to medical negligence. It is now my privilege to briefly introduce our esteemed guest. Dr. Yoganand Reddy sir has completed their education of MBBS at Government Medical College, Bellary. Sir is gold medalist from Karnataka Medical College, Hubli in MD. Also, sir has completed DNB Pediatrics from National Board, New Delhi. And sir is the member of Indian Medical Association, Bellary, presently working as the consultant pediatrician in Prithvi Children's Hospital. Few of their administrative achievements are they are the President, Karnataka Medical Council, Karnataka, past Secretary and President of IMA and IAP Bellary, Secretary Old Students Association, VIMS Bellary, past Chairman Anti-Quackery Committee of IMA Karnataka, past Senior Vice President of IMA Karnataka, past President of IMA Karnataka, past CWC member of IMA Headquarters New Delhi, presently SWC member of IMA Karnataka, presently Chairman of IMA's Karnataka Social Security Scheme Hubballi, former Vice President of Karnataka Hemophilia Society Davangere, Vice Chairman Disaster Management Committee IMA Karnataka, past Governing Council member Vijayanagara Institute of Medical Science Bellary. We are indeed privileged to have such a distinguished personality among us today. As a token of our respect and gratitude, we would now like to felicitate our esteemed guest. May I request Principal, Dean, Professor Dr. Raghuveer Kulkarni sir to kindly come forward and felicitate Dr. Yoganand Reddy sir. Thank you, sir. Now, without taking much of your valuable time, I would like to respectfully invite Dr. Yoganand Reddy sir, President, Karnataka Medical Council, Bellary, to address the gathering and share valuable insights on the topic medical negligence, balancing patient rights and medical autonomy. Sir.
ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. ಬಿರು ಬಿಸಿಲಿನ ನಡುವೆ ಬಳ್ಳಾರಿಯಿಂದ ಬಿಜಾಪುರಕ್ಕೆ ಬಂದಾಗಿದೆ ಯಾಕೆ ತಪ್ಪು ಅನಿಸ್ತು. ಇಷ್ಟೊತ್ತಿಗೆಲ್ಲ ಬಳ್ಳಾರಿಯಲ್ಲಿ ನೀವು ನಡೆದಾಡೋಕ್ಕಾಗಲ್ಲ, ಅಷ್ಟು ಬಿಸಿ ಇರ್ತದೆ. ನಡೆದಾಡುವ ದೇವರನ್ನು ಕಂಡಂಥ ಊರು ವಿಜಯಪುರದಲ್ಲಿ ಇವತ್ತು ನಾವು ಶತಮಾನಗಳಿಂದ ನಡೆದುಕೊಂಡು ಬಂದಂಥ ವೈದ್ಯ ಮತ್ತು ರೋಗಿಯ ನಡುವಿನ ಅವಿನಾಭಾವ ಸಂಬಂಧಗಳ ಸಂಕೀರ್ಣತೆಯನ್ನು ವಿಶ್ಲೇಷಣೆ ಮಾಡ್ತಕ್ಕಂಥ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ನಾವಿದ್ದೀವಿ. ನನ್ನ ವೈಜ್ಞಾನಿಕ ಮಾತುಗಳನ್ನು ನೋಡೋದಕ್ಕಿಂತ ಮೊದಲು 2 ನಿಮಿಷ ನನ್ನ ಮನಸ್ಸಿಗೆ ತಟ್ಟುವ ಕೆಲವು ವಿಚಾರಗಳನ್ನು ಹೇಳಿ ನಾನು ವೈಜ್ಞಾನಿಕ ಭಾಷಣವನ್ನು ಪ್ರಾರಂಭಿಸ್ತೇನೆ. ನಿಮ್ಮೆಲ್ಲರ ಅಚ್ಚುಮೆಚ್ಚಿನ ಪ್ರಾಂಶುಪಾಲರು, ಪ್ರಮುಖವಾಗಿ ವೈದ್ಯಕೀಯ ಕ್ಷೇತ್ರಕ್ಕೆ ಅನುಕೂಲವಾಗ್ತಕ್ಕಂಥ ಒಂದು ಮಾತನ್ನು ಹೇಳಿ ತಮ್ಮ ಭಾಷಣವನ್ನು ಹೇಳಿದರು. ನಾನು ಹೋಗ್ತೀನಿ. ತದನಂತರ ಇಂದಿನ ಅಧ್ಯಕ್ಷತೆ ವಹಿಸ್ತಕ್ಕಂಥ CS ಪಾಟೀಲರು ಅಧಿಕಾರಯುತವಾದ ಮಾತಿನಲ್ಲಿ ವೈದ್ಯಕೀಯ ಕ್ಷೇತ್ರವನ್ನು ಸೂಕ್ಷ್ಮವಾಗಿ ಎಚ್ಚರಿಸಿ, ವೈದ್ಯಕೀಯ ಕ್ಷೇತ್ರದ ನಾವೆಲ್ಲರೂ ಕೂಡ ಆತ್ಮಾವಲೋಕನ ಮಾಡಿಕೊಳ್ತಕ್ಕಂಥ ಒಂದು ಸನ್ನಿವೇಶವನ್ನು ಅವರು ನಮಗೆ ಚುಚ್ಚಿ ನಾನು ಹೋಗ್ತೀನಿ ಸರ್. ಅಧಿಕಾರಯುತವಾಗಿ ಒಂದು ಪ್ರಬುದ್ಧ ಪ್ರೊಫೆಷನಲ್ ಮನುಷ್ಯರಿಗೆ ಸಲಹೆ ಕೊಡೋದಿದೆಯಲ್ಲ, ಅದು ಇಂದಿನ ಅನಿವಾರ್ಯತೆಯೂ ಕೂಡ ಆಗಿದೆ. ನೊಬಿಲಿಟಿ ಅನ್ನೋದನ್ನು ನಾವು ಕಳ್ಕೊಳ್ತಾ ಇದ್ದೀವಿ ಅಂತ ಹೇಳಿದ್ರು. ನಾನು ಹೋಗ್ತೀನಿ. ನನ್ನನ್ನು ನಿಮ್ಮೆಲ್ಲರಿಗೂ ಪರಿಚಯಿಸ್ತಾ ನನ್ನ ಹಲವಾರು ಬೇರೆ ಬೇರೆ ಕ್ಷೇತ್ರದ ಪದವಿ ಪುರಸ್ಕಾರಗಳನ್ನು ಹೇಳಿದರು. ಆದರೆ ನಾನು ಅತ್ಯಂತ ಇಷ್ಟಪಡುವ ಕೆಲಸ ಒಂದು ಮಗುವನ್ನು ನೋಡೋದು, ಮಕ್ಕಳ ವೈದ್ಯನಾಗಿ. ವೈದ್ಯನಾಗಿ ಉಳ್ಕೊಳ್ಳೋಕ್ಕೆ ನಾನು ಇಷ್ಟಪಡ್ತಿದ್ದೀನ, ಬೇರೆ ಯಾವುದೂ ಅಲ್ಲ. ನಾನು ಪ್ರತಿ ಒಂದು ಈ ಥರ ಸಮಾರಂಭಗಳಿಗೆ ಹೋದಾಗೆ, ವಿಶೇಷವಾಗಿ ವೈದ್ಯಕೀಯ ಕಾಲೇಜುಗಳಿಗೆ ಹೋದಾಗೆ, ಎಲ್ಲ ವೈದ್ಯಕೀಯ ಕ್ಷೇತ್ರದ ಆ ಕಾಲೇಜಿನ ಪ್ರೊಫೆಸರ್ ಅಂತ ಹೇಳಿ ಲೆಕ್ಚರ್ಸ್ ಎಲ್ಲರೂ ಬಂದಿರ್ತಾರೆ. ನಾನು ಭಾಷಣ ಶುರು ಮಾಡೋದಕ್ಕಿಂತ ಮೊದಲು ಹೇಳೋದು, ಇಲ್ಲಿ ಯಾರಿಗಾದರೂ ನಿಮ್ಮ ರೋಗಿಗಳನ್ನು ನೋಡ್ತಕ್ಕಂಥ ಒಂದು ಅನಿವಾರ್ಯ ಸನ್ನಿವೇಶ ಇದ್ದರೆ ದಯವಿಟ್ಟು ಮೊದಲು ಹೋಗಿಬಿಡಿ. ನನ್ನ ಮಾತಿಗಿಂತ, ನನ್ನ ಮಾತು ಕೇಳೋದಕ್ಕಿಂತ ಅದು ಕರ್ತವ್ಯ ಮುಖ್ಯ ಅಂತ. ಯಾಕೆ ಈ ಮಾತು ಹೇಳ್ತೀನಿ ಅಂದರೆ, ವೈದ್ಯರಾಗಿ ನಾನು ಇವತ್ತು ಬಂದು ಕೂತಿರೋದು ಕೂಡ ನನ್ನ ರೋಗಿಗೆ ನಷ್ಟ. ಇಷ್ಟೊಂದು ಆಂತರಿಕವಾದ ಒಂದು ಸಹನೆಯನ್ನು, ಆಂತರಿಕವಾದ ಒಂದು ಜವಾಬ್ದಾರಿಯನ್ನು ವಹಿಸಿಕೊಂಡು ವೈದ್ಯ ಇರಬೇಕಾದಂಥ ಒಂದು ಸನ್ನಿವೇಶ. ಹಾಗಾಗಿಯೇ ನಮಗೆ ಈ ಸಮಾಜ ಅತ್ಯುನ್ನತವಾದ ಕ್ಷೇತ್ರದಲ್ಲಿ ಅತ್ಯುನ್ನತವಾದ ಮರ್ಯಾದೆಯನ್ನು ಕೊಡ್ತಾ ಇದೆ. ಅದನ್ನು ಉಳಿಸ್ಕೊಳ್ಬೇಕಂತ ನಮಗೆ ಇಷ್ಟು ಹೇಳ್ತಾ, ಐ ಜಸ್ಟ್ ಸ್ಟಾರ್ಟ್ ವಿತ್ ಮೈ academic session, medical practice in the modern era, balancing patient rights and medical autonomy. The whole concept of medicine or service to humanity down the lines in centuries across the different geographical areas of the world were based on mutual trust and responsibility. Not only just trust and responsibility between the patient population and a doctor who provides cure to the patient. Trust alone is not enough. Trust with responsibility is more important. A patient to trust a doctor with a sense of responsibility. In the sense, he is responsible to give his details of the disease. He is responsible to take the advice, carry on the advice given by the doctor. Similarly, a medical man should have a trust in his patient's belief and he should deliver with responsibility. Just because somebody trusts me, I cannot be irresponsible. So trust and responsibility were the basement for the everlasting relationship between patient and the medical profession. ಅವಿನಾಭಾವ ಸಂಬಂಧ ಅಂತೀವಲ್ಲ ಇದನ್ನು we cannot tell it in words, we cannot tell it in descriptions, we cannot explain it in books. Down the line, what happened? Though the medicine as a profession of trust started facing modern challenges, the ethical principles of healthcare, probably ethical principles of any profession as such, that C.S. Patel explained very well, profession is followed by intellectual population with a social concern. The livelihood and earning we make as a professional is a byproduct of what service we give. This encompasses all the four things which I have told: beneficence, non-maleficency, autonomy and justice. Whatever a doctor, a professional does should be beneficial to the patient, society at large and the state at large and humanity at large. Anything which is not beneficial to the well-being of the society, the patient or the state cannot be a medical profession. To extend this, we have one more called non-maleficence. Do no harm to anybody. I am a pediatrician. If I am not able to cure my child, I should not be making any harm to that particular child by the interventions I make. It is a conscious effort. A doctor has to be awake each and every moment. Third is autonomy. Autonomy means it is not just a medical professional autonomy, it is a medical autonomy which includes patient's autonomy and the professional medical autonomy, which is well balanced. And patient's autonomy and the medical autonomy, the professional autonomy should meet at one point. Patient has the autonomy on his body, a medical professional has an autonomy on his intellectual capabilities and the skills he has learned during his medical course. Last and the very important, which individual doctors cannot guarantee, it is the responsibility of the state. Fair distribution of health care and equal treatment. Are we in the era where there is a fair distribution of health care? Equal treatment across the social strata, across the religious strata, across the geographical strata. Is this last one as an ethical responsibility or compromised fourth responsibility of this country is making us to deviate from beneficence, non-maleficence, autonomy? Yes. Non-equitable distribution of health care and lack of equal treatment irrespective of the caste, creed and financial status and economy of a person is a basic factor which we need to achieve at large in the long run. The evolution of doctor-patient relationship. ವೈದ್ಯೋ ನಾರಾಯಣ ಹರಿ ಎಲ್ಲ ಭಾಷಣಕಾರರು ತಮ್ಮ ಭಾಷಣದಲ್ಲಿ ಇದನ್ನು ಒಮ್ಮೆಯಾದರೂ ಹೇಳ್ತಾರೆ. It is a trust and belief the patient and the society puts on the medical profession, which makes medical profession more responsible towards delivery of the healthcare system of the society. A social responsibility, a service responsibility of the medical profession over the time down the line has become a business. ವೈದ್ಯಕೀಯ ಸೇವಾ ಕ್ಷೇತ್ರ ವೈದ್ಯೋದ್ಯಮವಾಗಿ ಬದಲಾವಣೆಯಾಗ್ತಾ ಹೋಯಿತು. ಹಾಗಾದರೆ ಉದ್ಯಮಕ್ಕೆ ಒಂದು ಎಥಿಕ್ಸ್ ಇಲ್ವಾ? Is it not true that any business should have an ethics? Even if you make a medicine as a business, it should have ethics. It should have professional conduct. Any business without ethics, society won't accept. This transition of service to business is not yet completed, at least in Indian context. We are on the crossroads. Historically, medicine relied on deep trust between doctors and patients, with patients having faith in medical knowledge and judgment. Believing medical knowledge or believing medical science as an imperfect science, every patient accepted failures. Consciously or unconsciously, knowingly or unknowingly, even the uneducated patient understands the limitation of medical profession. ನಿಮ್ಮ ಕೈಲಾದಷ್ಟು ನೀವು ಮಾಡ್ತೀರಿ ಮೇಲೆ ದೇವರಿದ್ದಾನೆ. To say this, a patient need not be educated because medicine is not a perfect science. 1 + 1 need not be always 2 in medicine. In medicine, there are various approaches to a given problem. By being there in Vijaypur, I feel an action of mine is very appropriate to that situation, but not when I am in New York in a best hospital. What if I am an MBBS doctor in a PSC remote area? At 2 o'clock, a snake bite patient comes without ASV. Though law of the land says ASV should be given immediately 10 vials if it is not available. I am in a PSC. Inequitable distribution of healthcare system in the society, ASV, anti-snake venom is not available in the PSC. I am an MD, pediatrician, a general physician. I know I have to give 10 vials of ASV, but it is not available. My decision at that stage is one which I chooses among 10 options I have. That's why this medicine is imperfect and situation based. But to the best of our knowledge, to the best of our ability, to the best of the patient's benefits, avoiding harm to the patient, we have to take a judgment, decision, clinical decision, and should communicate and treat appropriately. No society will question you. But if you are in a bigger hospital where every facility is available, if a snake bite patient comes, I am in the deep sleep at 3 o'clock in the night. If I just don't get up, if I don't advise properly, no society will excuse you. This basic understanding a medical professional man should have in his mind. That is where the responsibility lies. People say doctors work entirely. We work entirely in a group. I don't believe any doctor is made to work exhaustively in the government institutes and the private sector without having sympathy from the patients. Even patients sometimes ask me, "Sir, go home, have lunch and come back." That is the concern the society sees. Society will not ask me always work and work till death. No. Society has the responsibility of understanding the patients' and doctors' needs also. That is a trust and responsibility. Why this has changed down the years? I just want to touch upon certain legal concepts which came into existence in the Western world and also in the Indian context. Before 1957 in the UK, medical negligences were adjudicated without any framework, without any proper understanding. In a landmark case of Wallam versus Freer Hospital Management Committee, while treating a mentally ailing patient and giving ECT, so many events happen. Here, what your principal told, the basic concept of protecting the medical community came into the legal books. Created strong legal protection for medical professions. Doctor not negligent if practice is as accepted as a responsible medical body. A doctor working in a peripheral hospital has a limitation. A doctor with a lesser degree has a limitation. The Bohlem's principle do not apply only in the treatment, it is also in the diagnosis, process of diagnosis, treatment, and also communication and exposure of risk explanation. So as far as that doctor is within the framework of a common bodies, medical bodies protocols, it is not negligence. Risk disclosure largely determined by doctor. What happens if I don't treat? What happens if I give this treatment? The elaborate risk disclosure is the order of the day. Since 2015 onwards, 1957 to 2015, even this risk disclosure to a given patient is the decision of the doctor as per the Bohlem principle of 1957. That was the, people say, the legal context vote to the medical autonomy. That was the critic which ran for many years. Patient's right often was suppressed. So most of the medical negligence cases were based on this Bohlem principle as a landmark judgment since 1957 till 2015. How transition happened? That was the era when medical autonomy, professional autonomy was dominant over patient's rights and patient autonomy. Then came a very interesting 2015 incident, a judgment of Montgomery case. Montgomery was a lady who was in labor, who was diabetes, hence her baby inside, fetus inside was very big. She was not given option for various types of modes of delivery. But doctor there tried vaginal delivery, normal delivery, and patient developed shoulder dystocia. That means in the medical term, the shoulder was caught in the frame of the pelvis. Delivery happened late, baby did not cry, and baby developed long-term complication called cerebral palsy, neural deficiency, which is not treatable, and baby, child, adult is always patient, always a neurologically disabled person. This case came to the court, and there the shift started happening from the extreme professional autonomy to the patient rights, patient autonomy. The concept of medical autonomy came into existence. Medical autonomy speaks of patient's autonomy and also professional autonomy. Doctors must disclose material risks and alternatives. Started from 2015. We did not fall behind. The Indian courts also concurred, followed, echoed the same principles what were happening in the Western country. In the morning, the principal vice chancellor of the university was telling about Samira Koili versus Dr. Prabha Amanchand case of 2008. It was related to consent, that is informed consent. The concept of informed consent before any surgery or medical treatment came into limelight since 2015. Similarly, in the case of National Consumer Dispute Redressal Commission, Vinod Khanna versus R.G. Stone in the 2020, where it declared generic consent do not equal informed consent. ನಿಮಗೆಲ್ಲ ಅರ್ಥ ಆಗೋ ಥರ ಹೇಳ್ತೀನಿ. ಕನ್ಸೆಂಟ್ ಅಂದರೆ ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ಪೀಸ್ ಆಫ್ ಪೇಪರ್ ವೇರ್ ಯು ಟೇಕ್ ದಿ ಸಿಗ್ನೇಚರ್ ಆಫ್ ದಿ ಪೇಷಂಟ್. It is the continuous process of communication, dynamic process of communication. ಒಬ್ಬ ರೋಗಿ ನಿನ್ನ ಚೇಂಬರಲ್ಲಿ ಬಂದಾಗಿಂದ ಕೂಡ ನೀನು ಡಯಾಗ್ನೋಸಿಸ್ ಪ್ರಾಸೆಸ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದಾಗಿಂದ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಡೋವರೆಗೂ ಪ್ರತಿನಿತ್ಯ ಅವನ ರೋಗದ ಬಗ್ಗೆ ನೀನು ಅವನಿಗೆ ಹೇಳ್ತಾ ಹೋಗ್ತಿಲ್ಲ. ಅದು ದಟ್ ಇಸ್ ದ ಇನ್ಫಾರ್ಮೇಷನ್ ಯು ಆರ್ ಎಕ್ಸ್ಟೆಂಡಿಂಗ್ ಟು ದ ಪೇಷಂಟ್. So standard format consents, which most of us even today take, most of the patients ignorantly or blindfoldedly sign on those papers are not consent forms. That is the judgment of Vinod Khanna versus R.G. Stone. A generic consent on a piece of paper, a signature of anybody is not a consent. The dynamic process with which the doctor involves the patient and his family in explaining from day one to the time of surgery, post-operative every care is a continuous process of consent. This became a patient-oriented tilt towards patient autonomy. Having said, what are the patient rights? Every country has consumer roles. The Consumer Guidance Society of India is one of the most responsible and the most respected group of public who themselves coined what are the patient's rights and which are adopted by most of the courts. In that we have 7 important things. Last one is not somehow not included in that Consumer Guidance Society of India rights supported by CGSM. Information and transparency. It is the duty of a doctor to tell about the diagnosis, process of diagnosis, treatment plans and this. It is not a job, it is a continuous process which many of us knowingly or unknowingly are doing day in and out. The patient, the moment you come inside, we take the history, we also ask for it, we also diagnose, we tell the treatment, but where we err is, we don't look at the eyes of the patient, we don't look at the eyes of the attenders and tell them that you are telling something which is important. Every doctor starts writing a prescription and keeps speaking to himself so that he is expecting the patient to listen. Take a bit more time to explain what is happening with him, because you are always a doctor who treats some other body. A body autonomy is there to that patient. You are treating that particular body, a human body. So it is a responsibility to know that whatever you speak, whatever you write in your paper is understood by the patient. Just writing, I advise the patient for admission, patient refused is not enough. It is a process. It is a process which takes at least 2-3 minutes. Of course, every patient has right on his medical records. Within 72 hours, we have to give medical records. Even if you ask every hour, every day also, you may have to give sometimes. A law in India may change shortly so that a dynamic production of documents to the patient may come into picture very shortly, because 3 days is enough time for any tampering by any medical professional at any context of time. Because you are well learned, as Dr. C.S. Patel said, you are well controlled about subject and you have enough 72 hours of time to deal with your own documents. A medical case sheet written by doctors in the hospital becomes a document in the court of law after 72 hours. I don't think any police will accept this. A medical narration of a doctor will become a document, a legal document in the court after 72 hours. So this is going to change, I am sure, very shortly. But it is the responsibility of the doctor to note everything as and when he sees, as and when he approaches the patient, not afterthought, not after correction. To whatever extent we are intelligent, the legal system is so strong, so strongly based, the internal capacity of the legal system across the world is so intelligent, the cooked up afterthought case sheets can be easily made out. We have seen case sheets in Karnataka Medical Council where, I cannot be revealing, where the notes of a doctor extend beyond the date of death. And they come to us. Notes of a doctor is there even on 29th February when it is not there. Notes of a doctor is there when he is receiving Padma Shri. See, he has gone in February to receive Padma Shri in front of Rashtrapati by the President, and his notes are there in the case sheet. Is it not afterthought? Is our legal system so blind enough to disregard all this? No. So be a dynamic doctor, dynamic man who writes everything as and when it is said to the patient, as and when you observe, no afterthought. That will protect us. Consent for procedures, as I told, it should be dynamic process which begins the soon the patient enters your clinic. It is not a piece of paper, generic piece of paper, printed paper on which you take the signature of the patient. That is not valid. Confidentiality, the morning doctor said very clearly that this has to be maintained. We are not here to tell everything about the patient. If some patient, some person other than the kith and kin or the patient himself asking for a case sheet, I am not here to give him anything. Unless it is a court of law or a criminal proceedings is asking for me on an affidavit, on a genuine request. Otherwise, I am not here to disclose, except in interest of the state. That means I have to declare once COVID positivity in the interest of state. I have to declare one's mental health status in the interest of the state. So confidentiality of a patient needs to be maintained at any point of time, except in that if it is compromising the interest of the state. Second opinion, of course, every patient has a right to take a second opinion. You can't assume that nothing can be done henceforth with this patient and just say go home. That patient has every right to take second opinion. Give him proper discharge summary. Give him proper notes of his ailment, even if he is in the terminal stage of illness, so that he has the option to take second opinion. It is his right. I cannot assume myself how big I am, whatever the nature of a caliber, whatever the degree I have. I cannot say that it is the end of the day for him, take home. You can say that as a doctor, but you have to give him proper discharge summary so that he has an option to take a second opinion. It is the right of the patient. And never compromise with the dignity and safety of a patient. Respect and protection from unsafe practices. Till recently, the dignity of the patients were maintained. Of late, we are getting complaints, even the basic modesty of the patient is being tortured by the doctors. I am very sorry to say that. Where are we landing up? Last but not the least, refusal to treatment. I am a very good doctor with the highest degrees. My opinion is well recognized across all universities. I am a PhD owner. I have so many citations being done by others. Still, a patient can refuse my advice. It is his right. Even if it is detrimental to his life, patient can refuse. It is his right. This right is based on his determination to live. But this right has a rider. If patient refuses treatment by compromising the interest of the state, he cannot do that. In a COVID, simple example, because in recent memory, if somebody is a COVID positive, my prescription, my suggestion is to get isolated at home. Patient cannot say, I have a right to refuse your treatment, because the interest of the state is affected here. That's why in COVID period, the central government, parliament amended the act and gave post to the police department even to arrest such people, to put it behind the bar or whatever precautions you want. See, refusal of treatment is good as far as it is not hurting anybody, including your kith and kin. A mentally disabled, mentally violent patient, a psychiatric patient, cannot refuse treatment if he is causing harm to the people outside, his family members. He cannot. You have to hold him, give treatment. So to that extent, it is limited right of a patient to refuse treatment, and refuse treatment in a particular doctor in a particular hospital. He can go to any other hospital. When he goes to any other hospital, it is the duty of the doctor to give everything what you have done till that date. If you are not giving it, you are violating his right for having refusal of treatment. That's how the process has changed down the years from the doctor-centric approach to the patient's right-centric approach. The patient's right to autonomy and professional autonomy became a medical autonomy where both started joining together. Now the balancing act is the most difficult part of the medical profession. By respecting the patient's rights and autonomy, not undermining the scientific progress, not undermining the professional capabilities of a doctor, without contradicting the laws of the land, respecting the regulatory authorities, practicing medicine is a complex and very responsible job of the medical profession. Everything should be met. That is the balance. Courts emphasize on honesty, disclosure, and patient choice. Law supports accountability, not punishment to doctors. The laws of the land is not meant to punish doctors. They are meant to change the concept of health care, concept of relationship between a patient and a doctor for the betterment of society. When an autonomous profession like ours lost the self-respect, lost the responsibility of ourselves, lost self-regulation of ourselves, the law entered. It is inevitable. There is no law existing when Adam and Eve were born. Any law on the planet. Law came into existence when self-autonomy and self-regulation failed. In the down the line, the profession which was service-oriented, when it became a business like ದಂಧೆ ಅಂದರು, ದಂಧೆ ಅಂತ ಶಬ್ದ ಅಂದರೆ ಇಷ್ಟಪಡಲ್ಲ ನಾನು. ಆದಾಗೆ ಈ ರೆಗ್ಯುಲೇಷನ್ಸ್ ಬಂದವು. ಲಾ ಆಫ್ ದಿ ಲ್ಯಾಂಡ್ಸ್ came into existence to protect the interests of this profession, not to punish doctors. But informed communication is a communication process. It is not a piece of paper. I again and again tell the medical people and also the advocates here, it is not the piece of paper on which there are signatures. It is a continuous communication process between the patient and the doctor. Respect for dignity and shared decision making. The decision on treatment of a patient depends on the dignity and sharing of views between patient and doctor. I have to tell the patient that this is the treatment you need. I am going to refer you to that place. Are you okay for this place, or do you have any options on your own? Every decisions of a medical treatment relies upon the judgment or decisions mutually respected by both patient and the doctor. Doctor alone cannot dictate. Patient alone cannot dictate. If patient says, I want to go to this hospital, where there is no specialty at all, it is the duty of the doctor to say that this is a hospital, a very good hospital for orthopedics. There is no treatment for pediatrics. It is the duty of a doctor to tell that. Similarly, it is the duty of the patient to tell the doctor that, sir, you are referring the patient, my patient, to this hospital, but I am not affordable to that care. I want to go to a government hospital. Please tell me a good government hospital. That's how the decision making of the patient and the doctor should go hand in hand to get the best results. I just want to compare what is happening in India right now and what is happening in the Western countries. A simple example, United States. The medical ethics in India are based on Code of Ethics regulations of MCI 2002. This is duty-centric approach. The medical regulations in India is the duty-centric. Doctor is duty-bound to do this, do that, do this, do that. In the process, patients' rights are incidentally addressed. The Code of Medical Ethics in India reminds us of our duties, doctor's duties towards the patient. Incidentally, the rights of the patients are addressed. It is the ethical obligation to respect patient welfare. On the contrary, in Western countries including USA, patients' rights are clearly defined in their code of ethics. A right-centric healthcare model is there in the Western countries. A strong emphasis on patient autonomy, legal frameworks protect patient choice. I do not want to say which is right, which is wrong. In a given context, both are right, both are wrong. What is there in India now will change over to the Western system shortly, provided we don't introspect. Provided the medical profession won't get up to the task needed. Provided our association do not address to the issues faced by the medical profession. Provided governments do not give equitable health distribution in India. This change will come over to India also. From the duty-bound doctor to the duty of a doctor to right-bound society. Is it going to happen? Yes, it is going to happen shortly, unless we introspect ourselves or we fail to introspect ourselves. Having said this, is there no professional autonomy to a doctor? Yes, a doctor has the professional autonomy. I have studied MBBS after getting very good marks in a science subject, and I boast myself that I am studying in BLD Medical College, a prestigious institute. I completed 4.5 years. While doing my MBBS, every member of my society respects me. Every family member tells them, others, that my son is doing MBBS. And I study for 4.5 years. I studied Grace Anatomy, I studied Guidance Physiology, which are voluminous in nature, which no other profession reads, except legal department, law department. They also read voluminous reading and writing also. Similarly, we read volumes of books with a different opinion on different aspects of medicine. Having read all that, is there no autonomy for the professional decision of a doctor? Yes, we have the autonomy. But this autonomy as the writer. Rights of physicians to make independent clinical decisions are always there. Decision based on medical knowledge, training and evidence, what you have learned through MBBS and your post-graduation should be practiced. Focused on acting in the patient's best interest, beneficiaries. The knowledge which you have gained down the years by reading voluminous books should be to the benefit of a patient. Patient should not be your research material without his consent. Patient should not be your friend wherein he takes advice without any proper consent, proper informed consent. This professional autonomy is again granted by whom? It is granted by society with expectation of ethical responsibility. It is very important. The society believes I am an MBBS doctor, society invests on me to become a doctor, and this society gives me a autonomy to practice my medicine with the expectation of ethical responsibility. That is very important. Your autonomy is given by the society which nurtured you. It is not independent autonomy you gained by just reading, by acquiring medicine. And we have to follow professional guidelines and medical standards. As I said, I just simply gave an example of anti-snake venom. The protocol of treating a snake bite is everybody knows what it is. If I am working in a remote place when I am not able to meet a protocol, yes, this country has a law to support you. This country has a legal system to support you, don't bother about it. So what is to be followed in a given situation as per the guidelines and medical standards, we have to read individual line and we have to apply accordingly, because we are all knowledgeable, well-read, highly educated people. Then what is patient autonomy? Patient has an autonomy on his body. That is basic thing. This is my body, I have my control over the body, and if somebody wants to treat me, he has to take an informed consent from me only. Patient is required to inform the doctor about everything he has, cough, cold, fever, whatever he has to. He is smoking, he is alcoholic, everything he has to declare in front of a patient. It is his responsibility in front of the doctor. he is also duty bound to follow the doctor's advice. A patient has a chronic lung disease and doctor advises not to smoke and so forth. It is the duty of the patient to take the advice to the true spirit of it. So autonomy of a patient is restricted to that extent. He cannot say that as long as there is a bond between patient and doctor. Once you refuse treatment, the bond breaks. You can do whatever you want. As long as there is a constant bond between you and your patient, if a doctor says you should not drink alcohol and so forth, when within the contract period, you are not supposed to do that. He has to respect personal values, beliefs and preferences. There are so many societies in the country which never accept blood transfusion. Societies which never accept cesarean sections. Societies which never accept abortions. Doctors should also respect that religious or societal beliefs, but to what extent? If it is not hurting the interest of the state. So what is central principle in modern medical ethics is the autonomy is given by the patient to practice medicine as per the knowledge you gain. And autonomy to the patient is to follow the advice given by a doctor as far as there is a contract maintained between patient and doctor. So this is the final stage, balancing professional patient autonomy. Doctors provide medical expertise and recommendations. We are here to provide medical expertise and recommendations only. We are not here to boss on your body, on your disease, on your financial status, on your social status. Patients have the final right to accept or refuse treatment. It is a shared decision which makes or improves trust and outcome. Both trust and outcome. If it is a shared decision, give him enough time to understand what we are told, and then it becomes a trustful benefit to the patient. Ethical healthcare requires communication and respect to the patient. Our communication skills are very important. We have to tell the patient at length to make him understand. Look at his eyes, look at his emotions, modify your suggestions, keep telling him. It is a process. Final goal is patient welfare with respect to individual choice. There is again the rider. I am a doctor who expects the patient welfare, but with the individual choice. If patient refuses my welfare strategies, yes, he has the right to refuse. What has happened? Now, I'm in a situation where I slightly deviate. Katti bittu Gurani edukondru anta doctor ಹೇಳಿದ್ರು. Defensive strategies of a doctor has evolved over a period of time. That means this society is not able to balance between patient autonomy and professional autonomy, patient right and professional responsibility. When we are not able to balance between these two and meet at a particular point, the medical profession becomes a defensive practice. ಕ್ರಿಕೆಟ್ ಪಂದ್ಯ ನನಗೆ ಗೆಲ್ಲಕ್ಕಾಗಲ್ಲ ಅಂತಂದರೆ ಕಡೆ ಇನ್ನಿಂಗ್ಸ್ನಲ್ಲಿ ನಾವೇನು ಮಾಡ್ತೀವಿ, ಕೂತ್ಕೋತೀವಿ. ದಟ್ ಇಸ್ ಡಿಫೆನ್ಸಿವ್ ಪ್ರಾಕ್ಟೀಸ್. ನೀನು ಔಟ್ ಆಗೋದಿಲ್ಲ, ರನ್ ಹೊಡೆಯಲ್ಲ. Is defensive practice is accepted by the legal luminaries, laws of the land? No. Whether by omission or commission, you are challenged in the court of law. I am practicing as a pediatrician, claiming that I have a neonatal intensive care unit. If a patient, aggressive patient comes to me and I have a facility inside, just because of fear of violence or something of that extraordinary situations, if I refuse treating that patient, it is act of omission. There also you are not protected. Defensive medicine is not a protection. It is a protection simply for that moment. You are making the patient get out of this premises and refer it to some other else. The reference of a patient is accepted only when you do not have the facility, when you do not have the capability to treat that patient. Both omission and commission. You have to commit to treat the patient. You cannot omit to treat the patient. So defensive practice cannot be a strategy which is accepted in the course of law. So what happens in defensive practice? With the defensive practice, All cases do not go to the court. It is a loss to society. A capable man will not be doing any surgeries henceforth. A man who has experienced knee surgeries stops doing knee surgeries for some reasons. What happens? Down the line, within 2-3 years, that particular best doctor will lose skills. It is not only lost to patient, it is lost to yourself also. If you start doing a surgery once in a while, your skills are not that good, your fingers won't work. So defensive practice, choosy practice and safe practice is not good for both patients and also doctors. Doctors will start losing the skills acquired by very, very hard work you have put in for almost 10 years in your life. By reading voluminous books, by giving aspirations to your family, and you are well learned and you have got the awards, your skills are being lost because you are defensive. Both in the court of law, both in the personal aspect and societal aspect, this defensive practice is not acceptable. And as a doctor, as a hardened IMA man, as a regulator of this profession, I always say, never venture into defensive practice. Accept your mistakes, introspect yourselves. If you have done a wrong, you try to correct yourself. If you have not done a wrong, if there is an accusation, try to defend it. Do not change the authentic or responsible practice, but with the introspection. If you are a doctor who is not doing the job properly, if you don't introspect, my words won't suit there. You have to introspect first and sense that what you have done is right, defend it. Sense what you have done is right, go ahead with whatever you are doing down the line. Don't venture into defensive practice. Medical autonomy allows doctors to independently choose appropriate treatments, exercise judgment, make swift emergency decisions. In India, though the concept of informed consent is very popular, except in emergencies. In emergencies, doctor has to take appropriate decision. I cannot wait to police to come and give me the clearance to treat a road traffic accident patient. There I am a good Samaritan than a doctor. I have to treat that patient. I cannot escape. I am duty bound there. I cannot ask the patient to sign on the consent forms. In emergencies, a doctor has to take a responsible decision to attend to it. If he is capable of treating him, let him treat. If he is not capable, let him refer with due precautions, arranging an ambulance, and later on you think of other legal formalities. No society will tax you for that. You cannot, even in emergency, you cannot say that you are not signed the consent, no relative is there, I cannot treat. No, you are not supposed to do that. Building a balanced and ethical healthcare system, we have to understand patient rights, as I said already. We have to understand in depth of all these. Understanding of the patient rights is foundation for the responsible practice by a doctor. A time is not far off wherein the Indian context also will change from the doctor-centric treatment to the patient-centric treatment, the right-centric treatment. We have to understand these rights of a patient in depth and accommodate ourselves in society so that future practice of medicine is safe. Balancing courses in modern healthcare, we have three pillars of modern practice. Modern medical practice must balance patient rights, professional autonomy of a doctor, and regulatory oversight to ensure effective health care. I cannot say that I am the professor in an institute, I have published so many articles. Who is the regulatory authority to question me? I cannot say that I have treated hundreds of eczema patients. Who is this patient questioning me? I have to balance all these three. As a medical expert, I have to balance the patient's expectation and regulatory authority over me. To whatever the position we achieve, whatever the academic excellence I have to respect and balance all these three. And of course, When questioned, I have to respect the legal, I have to respect the police also. When questioned, I have to respect whatever be the caliber of my practice down the line. The medical councils maintain ethical standards, ensure professional competence, address complaints and conduct fair inquiries to preserve trust in the society. That's very important. Medical councils or any court of law is not here to punish doctors. The ultimate motto or goal of any of these regulatory authorities is to preserve trust between the patient and the doctor, so that the society gets benefit from the medical facilities available. It is not to punish anybody. For this to happen, what is required is a communication skill. The modern day doctors, modern day advocates, I always say you that be a very good communicator. Be a very good communicator. Not to the extent of fooling a person. Be a good communicator. Don't fool the patient. You cannot say to the patient that a simple appendectomy comes to you, it can be solved, that this, you can die tomorrow, day after tomorrow. And once the patient is cured, you cannot claim that I have saved you from death, so give me 2 lakhs rupees. You cannot do that. Your communications skills should be need-based, should be appropriate to the situation and the disease the patient is suffering. You cannot underestimate. Yes, as long as it is a first contact that is made. As long as the first contact, I always say patient, be assured you will be get cured. To infuse confidence. But you cannot keep on saying that even when the patient is in the deathbed. You have to come out with certain hard truths, at least to the patient and or to the attendants. Similarly, we cannot over-exaggerate any situation and say you have a cancer, a treatable cancer cannot be exaggerated and put to say he is cured from cancer, I have cured him. No. There are so many cancers which are curable. I cannot take the undue advantage of that scientific knowledge. So, communication skills should be appropriate, should not be fooling the society. With this, it is the duty of the society, doctor and the patient population to balance everything, and I have specifically put this slide wherein I believe in gender equality. Thank you, sir. So any discussions, questions, as the organizers wish, we are here to answer your questions. All the 3 lectures and take questions, or if you want to take questions right now, we are happy. So that because all the 3 lectures are overlapping.
Thank you very much, sir, for enlightening and insightful address. Your valuable thoughts and perspectives on the legal dimensions of medical negligence, that is balancing patient rights and medical autonomy, have certainly enriched our understanding of this important subject. We are truly grateful for your time and for sharing your knowledge with us. We will now take a short tea break. Tea and refreshments have been arranged behind the auditorium hall. Kindly proceed there and we will resume the session shortly. Thank you.
I request all the participants to please settle down in the auditorium hall. Please occupy your seats. Please be seated.
Good afternoon, everyone. I request everyone to kindly take their seats. Very shortly, we are going to resume with the second technical session. Good afternoon, everyone. I am Afin Kazi, a second year LLB student. They say a good conversation deserves a pause and a meaningful discussion deserves continuation. After a refreshing tea break, we are now ready to resume the intellectual journey of today's program. With great enthusiasm, we now begin the second technical session. Healthcare and law are 2 pillars that safeguard human life and dignity. and discussions on medical negligence help us understand the delicate balance between professional responsibility and legal accountability. Ladies and gentlemen, we shall now move forward to the next part of this technical session. It is now my privilege to invite our distinguished guest, Dr. Babugowda Patil sir, Associate Professor, V.M. Salgaonkar College of Law, Goa, to kindly grace the dais. Let us welcome our esteemed guest with a warm round of applause. Sir, it gives us immense pleasure to have you here today. On behalf of the organizing committee and all the participants present here, I extend a heartfelt welcome to you for this seminar on laws relating to medical negligence. It is now my honor to present a brief introduction of our respected guest. Dr. Babugowda Patil sir. Sir has been part of V.M. Salgaonkar College of Law from last 2.5 decades. Presently, sir is working as Associate Professor. Sir obtained his requisite qualifications from Karnataka University, Dharwad. During their post-graduation, they specialized in labor law. After teaching labor law along with other subjects, Sir chose human rights of disabled persons as their preferred choice for their Doctor of Philosophy. Sir submitted his work for award of PhD and was later awarded the same for his thesis bearing the name Right to Education and Employment of the Persons with Disability in the year 2012. Sir was associated with various programs organized in state of Goa relating to the same. Later, Sir worked on the connected areas of mediation and negotiation. Sir was instrumental in developing a competition on negotiation and making V.M. Salgaonkar College of Law as one of the pioneers in ADRS skills teaching. Along with the senior colleague, Sir developed modules for teaching skills of client counseling, teaching skills of negotiation and mediation. Sir also runs a certificate course in conflict management for students from various disciplines. Sir is visiting lecturer for the LLM program on Human Rights and ADR Certificate program at Shivaji University, Kolhapur, Maharashtra. Sir has been empaneled as a resource person in the Karnataka Institute for Law and Parliamentary Reform, that is KILPAR, Bangalore. Sir has been part of UGC initiative of e-Pathshala. Sir worked on access to justice and recorded 4 live lectures for the benefit of students. The lectures are available at the UGC website. Sir is the part of National Organizing Committee of Louis M. Brown and Boston Client Consultation Competition. Presently, Sir is a national consultant to Vyap Vikas, a social enterprise from Bangalore, working in the area of rights of senior citizens. Sir is member of Board of Studies of Dayananda Sagar University, Bangalore. Sir contributed to the law and process of adoption by being an advisory member of CARA, that is Central Adoption Resource Authority, under the Women and Child Development Department, Government of India. Sir has published 40 articles to their credit, along with many paper presentations at prestigious national and international seminars. Sir has authored a book titled In Search of Courtroom Ethics, published by Oak Bridge, a publishing house from Delhi. Sir has visited various institutions in Madhya Pradesh, Gujarat, Delhi, Kerala, Karnataka, Maharashtra to train teachers in FDP programs. We are truly fortunate to have such accomplished personality with us today. It is said in our culture, Atithi Devo Bhava, meaning the guest is God. With this spirit of respect and gratitude, we now take the privilege of honoring our distinguished chief guest. As a gesture of our appreciation and respect, we would now like to felicitate our honored guest. May I request Dr. Sharan Badigere sir to kindly come forward and felicitate Dr. Babugowda Patil sir, Associate Professor, V.M. Salgaonkar College of Law, Goa. Thank you, sir. Now, without further delay, I respectfully invite Dr. Babagowda Patil sir, Associate Professor, B.M. Salgaonkar College of Law, to address the gathering and share their valuable insights on the topic of Role of Consumer Protection Act 2019 in medical negligence case. Sir, the stage is all yours.
Good afternoon. Thank you very much for my introduction. And this is the second session of the day, and I must make a small confession. Yesterday I tried to deliver a lecture in Kannada. It was utter failure. So I will stick to English today because my Kannada is very poor, and I have been in Goa from last 25 years, so I have very little opportunity to speak on the stage in Kannada, so I prefer to stick to English. And another confession I want to make here is Sir has presented exceedingly well about few of the areas which I am going to overlap, but one difference will be there. You heard a doctor, now you are going to hear a lawyer, and how the same thing is spoken differently when our point of view changes. So, Sir mentioned about the whole thing, because here we have white coat, black coat and brown coat in the same hall. Medical negligence is looked upon by the white coat as a law which snatches bread and butter. Black coat looks at it as a law which gives bread and butter. So that's the difference, how we look at it. But today my main focus would be, like Sir, our main focus would be how to handle medical negligence matter and how to protect ourselves from these provisions of law. So when I look at the medical negligence and when I look at this, first thing I did is I expanded the scope of the law of medicine. See, now when you look at the health industry, doctors are one part of the health industry and they are not the health industry. So being a part of health industry, what constitute health industry are the three pillars. The first pillar is promotive health. Here doctors play a minimal role, and here we are talking about Khelo India scheme, where we promote healthy living, we provide health education, we provide all provisions where we promote healthy living style. Next is preventive. Here vaccinations come into picture, regular checkups that is demanded by the health industry. So these are about preventing them. And here the doctor's role increases to some extent. And then curative. Now here is the role, which is maximum role is played by the doctors and allied professions. When you look at this health industry, I checked United Nations rules and regulations. They recognize 70 professions are connected with the health industry. Doctors are one of them, but this 70 you don't take it seriously, because in India we have around 45 to 55 professions have been connected with the health industry. So why I expanded the scope of discussion is because when we talk about medical negligence, it is not the only doctors who are at the receiving end. It is much larger professions which are at the receiving end. So when we look at this, these 70 professions needs to be regulated, controlled, and also there needs to be given a kind of guidance of the work nature. The first one is regulating the professionals. See, profession is something which needs to be regulated in the form of different laws. We have National Medical Commission Act 2019, which regulates the doctor's profession. We have Pharmacy Act, we have National Nursing and Midwifery Act, and we have National Commission on Allied and Healthcare Profession Act. So these are the different legislations regulating the different professions, but all of them are connected with health. Next set of law is patient rights and safety. Here, this is the focus area of this seminar. We have Mental Health Care Act, we have Medical Termination Pregnancy Act. That's not a very general legislation. It's specifically related to certain functions of the doctors. Transplantation of Human Organs and Tissues Act. And the last one is the Consumer Protection Act, which specifically deals with medical negligence. Next set is about drugs and device regulations. These are again about cosmetics, the Drug and Cosmetics Act, magic remedies. Narcotic drugs has been, I have inserted but not directly related to health industry. Biomedical and waste management rules. And the last one, before the last one, penultimate one is public health and emergency responses. Here, establishment of hospitals, establishment of clinics, how it is done. In case of epidemic like COVID-19, how the law controls the epidemic diseases, national health mission framework, food safety standards, and the last one and the most important one is data protection. Again, doctors are directly involved in this, not only doctors, all other health industries, health professionals are involved in this. Information Technology Act and Digital Personal Data Protection Act. So these are set of laws which control the health profession or health industry, and all of them make specific demands to be met with. Sir was mentioning about being defensive is not an answer. I agree, completely agree with you, because you can't be defensive in this profession. Why we become defensive is because we are scared of consequences. And I assure you, the consequences is only one. Explain. You have to pick up pen, paper and explain why you did it. That if you are scared of explanation, then this is not the profession. Because you take decisions, you make a judgment, you take action, and then start explaining why you did it. If everything goes well, nobody questions. If something goes wrong, what is the consequence? You have to explain. As long as your action is in good faith, law will recognize that good faith. Law will find the good faith from that. That's why Sir said, medical profession is based on two things. It is situational. Judgment, because on situation, it was the best that I could do. If you are able to establish that, then law will definitely recognize that. So there is no need to be defensive. What is required here is you should stand up and explain why you did like that. If you are scared of that, you should not be scared of it specifically. I am coming from a most safe profession, teaching. If students pass, I tell that I put a lot of effort, that's why they passed. The students fail, I say that they are not reading, they are not studying, they are in the mobile all the time, that's why they fail. Anyway, I am protected. But I have been made to explain many things. University asks explanations. The management asks explanations. Student asks. And I keep on writing detailed explanation to them. I am a public information officer of my college. RT applications come, asking details about the people working in my department. I have to give, I have to explain. See, the world is not same as it was. And if you are scared of a change, then it is not the world for you. Change is bound to happen, and you have to adhere to that. You have to adjust to that change. And even, I understand, even many of the police friends who are sitting here, they are seeing the change, how people were looking at the police profession, and now how they are looking at it, now how they are questioning. And especially the things have become very difficult with mobile phones. They start recording. Even if you are saying what happened, they start recording. But are you scared of that? No, you should not be. If you want to record it. As long as I am within the boundaries of the law, why should I be bothered about it? So therefore, looking into all these things, I have divided 4 categories of the healthcare industry. 1 is hospitals, 2 pharmacy, 3 lab, for banks, healthcare banks, and final one is organ banks. So these are the different core categories of health industry, and all of them are brought under the definition of medical negligence. So before I get into medical negligence, let me deal with medical care and law. So when it comes to medical care and law, I have listed 7 legislations, and here police friends would be interested in some of them. First one is Consumer Protection Act. I will deal with in detail later. But the second one is law of evidence. In this, a doctor may be called to give expert testimony, or he may ask to submit medical records and medical documents. So here, in this, the doctor needs to develop a system in the hospital, in the functioning, where these 2 requirements are met. Next, privileged communication. Sir was mentioning about that the communication between patient and the doctor will not be revealed and should not be revealed. But there are 2 exceptions. One is court order. The court orders fall and then second one is public interest. So in these situations, they may ask for revealing the privileged communication, which is again part of the privileged communication. Law of evidence. Then comes the good faith. See, in the good faith, whenever your action is under good faith, the law excuses you no matter what are the consequences. Patient might have died, but you acted in good faith, you are protected. Now what is good faith? Take consent and operate. This is an action. See, law profession is one thing where we peep into the mind of the other person and identify what was going on in his mind when the actual action was taken place. And we do that through examinations, cross-examinations, chief examinations. They are quite torturous that we do in the open court. How do I assess whether you acted in good faith? I look into your conduct, your before, after, how you behaved. That will be assessed, and on that basis we fix intention. Is a good intention or malified intention would be identified by that. So therefore, first, take consent and operate is a rule, and exception is emergency. So if there is an emergency, taking consent and operating can be ruled out. But again, who is going to prove that you acted under emergency? It's the doctor. Doctor must establish that how he came to that conclusion. What are the driving factors behind your conclusion that there was an emergency? And you communicate in good faith, and every time when you act in good faith, it is protected, and that's an exception provided in the criminal law. Then we have the next one, that is accident in doing lawful act. Now this is a new legislation, it's been inserted in the year 2023, and there was a lot of debate on that. So I'll just briefly tell you what is the difference, and then I'll come to that, I'll continue. If there is a rash and negligent act leading to death, if it is done by a general public, 5 years imprisonment. But if it is done by a doctor, 2 years imprisonment. A doctor driving a car, meeting with an accident, causing the death, he comes under general public. When I say doctor, while discharging his duty as a doctor, leading to incident. Now, there are chances that it would be questioned why doctor is given a special treatment here, why doctors only 2 years and why me 5 years, violation of equality. These questions are going to come in the near future before the court. But if you look at the amendment, what they are looking at, why the difference is being made is because doctors work under tremendous pressure and situational, in a different situation. Under those circumstances, mistakes bound to happen. But only here, what we look at here is it a gross negligence that led to death? Jacob Matthew is the one one case which was Dr. Inamdar mentioned, where the doctor is expected to act is covered under it. Then we have the communication in good faith. Communication in good faith, the seventh one. There is a lawful act, lawful manner, proper care and caution, and no criminal intent. These are the things needs to be proved before the court. No criminal intent. How you are going to prove it? How you are going to prove that you are acted in proper care and caution? See, these are all the words of English which has tremendous consequences on a profession of a doctor. And as a lawyer, I want complete proof, proving beyond reasonable doubt that you acted under with no criminal intent, proper caution is taken. But these are all the demands of the law, and you cannot question the demands of the law. That's what sir mentioned, that you are subordinate to the regulatory authorities, you are subordinate to the will of the patient, and when you are subordinate to them, you are expected to adopt these things without questioning. So rather than cribbing on this, why it is like this, why I should be burdened, why I should be chastened, better we adapt to the law. See, things are getting more stricter and stricter day by day. And as Dr. C.S. Pastil was mentioning, from chaos, organization to autonomy to more regulatory and intervention of government. This is how every profession progresses. And we reached that stage where autonomy is giving way for regulation. And we have to adopt that regulation. And finally, this is a fear of injury. That is, we are talking about a sixth point, consent under fear. So again, here we need not create a fear and obtain consent of the patient. So if you look at the whole thing, how law looks at health sector. Does it look at it as a charity, a duty provided by the health sector to the society? The answer is no. We look at it as a fundamental right. It's our right that I should be given a proper health service. Sir was mentioning that very soon they are pushing for a law on health, that is Right to Health Act. Now once that law comes, again things are going to be more patient-centric, society-centric, and more than that, I would call it as a court-centric law, where the court decides everything. Nothing remains in the hands of the doctors. So here ascertaining liability, sir has covered it in detail. So I will just quickly run through those things. I will not take more time. So when evolution, how it took place. First it took place, Glanville Williams, the ancient legal luminary, he said the health sector should self-regulate. If there is no application of criminal law, maximum there can be a civil liability. This is the first opinion about the liability. The Bolam test, sir has covered it. Not guilty if action aligned with accepted practice. Follows standard of care based on medical consensus. No need for majority opinion as long as it's a credible body's opinion. So now here, I look at it as doctor-centric law. Doctor decides. If not me, my brother doctor, my sister doctor, they will take a call whether the action was proper or not. So from self-regulation, it came to regulation by the same profession. So there is no intervention of outsiders. Then we came up to the next level where the private complaint should be taken only if there is a prima facie evidence. Investigation officer should obtain independent and competent medical opinion. So from self-regulation, from self-decision, now there is an intervention of police. Things are slipping out of the profession. Then came the next one, Bolito addendum. This is added to Bolam test. So here, medical body's decision should be logically defensible. So now what happens is, in Bolam they said, medical professionals will decide. Now what we are saying, You decide, no problem, but it should be defensive. That means the decision can be questioned in the court and the doctor's body should stand up and defend it. Then come Montgomery, the 2015 thing that what sir said, that is where there is shift is to patient. From doctor centric, we move to the patient centric. Now here I am interested in showing you this. Look at x-axis and y-axis. Y-axis is about court's control, how much court controls the whole thing, and x-axis is about doctor's control. So when Williams mentioned there was complete doctor controlling it, court had no role to play. Then Bolam came, slowly things started moving towards court's control. Jacob Matthew came, Bolito came, and then Montgomery, doctor lost full control, court gained full control. So why I am not using it as patient's control is because it is always decided by the court and the patient is only pleading before the court. So court gained complete control over the medical negligence provisions. Now the question here is whether it's a good, correct development or a wrong development. The answer to this is not easy. Everywhere we are bringing more and more regulations and we are bringing more and more obedience, compliance, and things are becoming more compliant oriented rather than function oriented. This is one type of growth, and then there is going to be reverse. See, every time it's happened like that only. So once everybody said that banks should be nationalized. They nationalized the bank. Then they said no, banks should be privatized. They privatized. So things move in circles, and in that circle we have reached a circle where compliance is more important than the function itself. This is a growth which makes the professionals more defensive. Whether you want or you don't want, you have to save your skin. In the language of Dr. Inanda, you have to save your skin. So becoming defensive is not a choice. It is the only way ahead. So how do you defend yourself? I will just quickly run through this. There are three formidable defenses: informed consent, necessity, and good faith. I will skip this. I will not go in detail because you already heard it from Dr. Reddy. So I will just skip this. I will come to the next one, that's the last one, that is good faith. Now here, a good faith, action in good faith has to be done in this way. So there is three circles: good faith, fairness, and justice. And when you employ all these three, you develop a trust. And once you develop a trust, you need not bother about law. The best defense against medical negligence is the trust. And to develop trust, you have to bring these three circles into an action together: good faith, fairness, and justice. I will just try to explain with a small example. Now here is a man, a poor guy, has come to doctor and he is trying to tell the doctor that he is suffering, and doctor wants to give him treatment. The doctor says you have to undergo certain tests. The patient says, I have no money, I cannot undergo any tests. Now the first doctor is the doctor good faith. So what he will do? So he will watch, observe, draw some conclusions, and in good faith he will start the treatment. The treatment is like a shooting an arrow in the darkness because he has no test results in front of him. But he cannot undergo the test and he should be treated. So he is acting in a complete good faith. The second doctor is a doctor fairness. Doctor fairness, what he will do? It is unfair to treat him without knowing the nature of the disease. So I cannot treat you without test results. These are the tests. Take them, bring it to me. I will go through the results and then I will decide. is a doctor fairness. Then there is a doctor justice. So what doctor justice will do? He will call the lab. He will say that I am sending a patient, he doesn't have money, he cannot do all the tests, but I have given 5 tests, but out of that 2 are not very costly. Do that, don't charge him, but other 3 don't do it because they are very costly, it is unbearable for you also. Do the 2. With the 2 test results, he will see how to go about it, and then he will start the treatment. Now who is right, who is wrong? There is nothing called as right and wrong here. These are all 3 different approaches. And if you adopt all these 3 approaches depending on the nature, situation and other thing, you are creating the trust of the patient in you. So that's why what is required here is good faith, fairness, trust, all 3 together. Now coming to the law. The law works on theories. Now theory of liability. When a doctor should be held liable. So there is first theory of liability of the doctor, that is utilitarian principle. So read the first line. The first line says, right approach depends upon the benefits to the number of people. So as long as you are successful, you are right. The day you fail, you are wrong. Because utilitarian principle is about benefit to the society. What it leads to is suspended paralysis. They don't take action, they don't act, because if you adopt this principle, it's very dangerous to fix a medical negligence based on utilitarian principle. It is not a suitable principle. But there are cases which worked on utilitarian principle. Next is ethical relevance consequences. So here we are going to ask 2 questions. Why and what? Why you did that and what you did. So these are the 2 questions you have to ask yourself, why I should do it and what I should do it. So that is like content and obligation. So these 2 things you have to mention. So let me explain this with the help of a child going to a university or a school of law. So if the child is going to school of law, the first one is why they are going to school of law, to get a degree. What they should do to get the degree. Attend classes, participate in college activities, write exam, pass exam, get. So that is why and what. Apply the same thing to the medical professions. See, exam writing. You should not copy. Why I should not copy and what happens if I copy. So that is what is required to be understood. So ethical relevance consequences, eminent jurist George Hughes mentions about this. Now, content of a doctor profession is correct diagnosis, proper procedure, informed consent. Ground, why you are doing all this thing, established by the doctor's professional's role and the patient's vulnerability. That's why I have to be correct with diagnosis, I have to follow the proper procedure and I have to take informed consent. If you flip it, the flip side is patient. Patient content obligation is provide medical history, follow the prescribed treatment, respect the advice of the doctor, cooperate with the healing process. That is his what. And what is the why? Patient accepts the treatment that creates reciprocal duties and the patient trust on the doctor. So that is why that the idea of this consideration should be considered should be part of the liability under medical negligence. Now there is a difference between error of judgment and act of negligence. Error of judgment is not punishable, but act of negligence is. So error of judgment is where we go wrong, and doctors are like gods, but they are not God. They do commit mistakes, and whenever they commit mistake, the lawyer's job is to find the distinction whether it's an error of judgment or is it a negligence. If a doctor has a reasonable degree of skill, reasonable knowledge, reasonable care, not below the standard, expected standard, then if things have gone wrong, it's an error of judgment, not negligence. And believe me, error of judgment is not punishment. And one development which I want to bring it to your notice is the Bar of India Lawyers versus D.K. Gandhi, PS National Institute of Communicable Diseases. This is an important case because lawyers successfully pulled themselves out of Consumer Protection Act. Lawyers' profession is not part of a Consumer Protection Act. And the same attempt was made by the medical professionals in the Supreme Court. They said, no, you are part of the Consumer Protection Act. There are very distinctive reasons were given. I'm not able to recollect now. They are talking about the nature of service of the lawyers is there is so many possibilities are there that it cannot be brought under that medical negligence. So if Shanta case is still continuing, it is not overruled as far as that. So coming to Consumer Protection Act, I will just take up consumer rights, that is right to be informed, right to be assured of services at competitive prices, right to be heard, and right to seek redressal against unfair trade practices. So what I am planning to do now is, instead of taking you through these rights, I want to take you through the last part of my presentation. I am going to wind up with this. The last part of the presentation is how do you protect yourself as a doctor against medical negligence provisions. The last part I am taking up is this: mediation as an opportunity to be exploited by the doctor's profession. So there are 4 ADR: negotiation, mediation, conciliation, and arbitration. I think all of you should be having the fair idea. Out of all these 4, Consumer Protection Act adopted mediation. And in the mediation, they have said, that is Consumer Protection Act 2019 and the Consumer Mediation Act 2023, these 2 laws have come together and they have recognized mediation. There is a chapter 5 in Consumer Protection Act. There is one small line in the Act which says the experts or other professionals with at least 15 years of experience can be mediators. So why can't the doctors join the Consumer Commission as a panel of mediators? Because medical negligence can be mediated and settled. And if you can mediate and settle it, then why it should not be done? Instead of a lawyer sitting as a mediator between the patient and the doctor, why can't somebody from the profession who understands intricacies of the profession and who can educate the patient as well as educate the young doctor and bring out a settlement? That would be the best option before us. Because otherwise, in mediation, it has to be a law graduate to become a mediator. But there is one line inserted which talks about experts or other professionals with 15 years of experience can also be mediators. Only thing what we need to do is we need to register ourselves with the Consumer Protection Commission or Consumer Commission and ask them to put us in the mediation panel, and let whenever the dispute comes, we take up from the panelists and do it. But there is one matter that we need to keep in mind, that is matters that cannot be referred to mediation. Medical negligence can be referred, but not this one. The medical negligence resulting into grievous injury or death cannot be referred to mediation. It has to be decided by the Consumer Commission. The reason, I'll just take one minute and I'll wind up. The reason why the medical negligence leading to death cannot be mediated is because mediation is a private process and not conducted in the public gauge. People are not aware about it. If there is a medical negligence, if there is a death, people must know. because they should have an informed choice that whether to be treated by the same hospital where the death occurred or not. The only reason why it cannot be mediated is because of necessity of publicity. It has to be publicized in the interest of the society. I know there will be major damage done to the hospital's reputation, and they will take decades to overcome that drawback, that bad publicity. I understand. And in Goa, we had filed a petition in the court where whenever there is a death in a hotel or in any beach shack, whatever may be the reason, there is a death, there is a robbery, they write in the news that a prominent hotel in Kalangut, there was a death of a tourist. Now, why the name is not written? Why it is prominent hotel? We have a right to be informed. We decide whether to go and stay in the hotel or not. But they look at the commercial interest over the societal interest. That's the problem. And you have to go manage with the press and hide your name from being publicized. There was a death in my neighborhood. A child fell into the swimming pool and drowned. And the news came is in Old Goa, there was one apartment where the child died by drowning in the pool. Which apartment, where in Old Goa, no details are given. Because everything was managed. So same thing should not happen in case of a death due to medical negligence. And that's the reason why it cannot be mediated. Rest all can be mediated. The rest all should be mediated. And it should be handled by the professionals. Another suggestion is, why can't we have a grievance cell in the hospital with mediation wing? So you can settle it and sort it out at this. Because mistakes happen and we have to pay for our mistakes and we cannot be scared of that. Thank you very much for your patience, and I'll wind up my...
On behalf of everyone present here, I would like to express our sincere gratitude to our esteemed guests for the insightful speech on the role of Consumer Protection Act 2019 in medical negligence cases. Your valuable thoughts and guidance have greatly enriched our understanding of this important topic. Thank you for taking the time to share your knowledge with us. Medical negligence is not merely a legal issue. It is a matter that touches upon ethics, professional responsibility, and the trust that patients place in healthcare professionals. We shall now move on to the final speaker of this technical session. It gives me a great pleasure to invite our distinguished guest, Dr. Pawan Kumar Patil Sir, Member, Karnataka Medical Council, Gadag, to kindly grace the dais. Sir, we are truly honored by your gracious presence here today. On behalf of the organizing committee and everyone present here, I extend a warm and heartfelt welcome to you to this seminar on the laws relating to the medical negligence. It is now my privilege to present a brief introduction of our respected guest. In education, Sir has completed their MBBS from Sri B.M. Patil Medical College, Bijapur in the year 2003 and MS General Surgery from Sri B.M. Patil Medical College, Bijapur in the year 2010. Sir is having the experience of 23 years. Presently, Sir is the Managing Director at Dr. N.B. Patil Hospital, Gadag from the year 2010 to till date. Director, Gadag Scan Center, a unit of Kritikpura, Gadag Scan Center, 2013 to till date. Director, Gadag Heart Care, Gadag, 2016 to till date. Sir has made the publication on rare foreign body in GI tract Indian Journal of Surgery. And also, Sir is the organizing chairman of the first IMA National Medical Legal Conference held at Bengaluru. Sir is having 3 years of teaching experience as a junior and senior resident surgery at Sri B.M. Patil Medical College from the year 2007 to 2010. Speaking of professional development, he is trained in laparoscopy in Department of Minimal Access Surgery, AIMS, Delhi. Trained in upper and lower GI endoscopy. Trained in endourology, Delhi. Dealing with oncosurgery, urology, polytrauma and other specialties. Associated with the various government schemes for last 10 years and actively involved since 2010. Some of their affiliations like Life Member ASI, IMA, IAGES in the year 2012. Fellowship in Indian Association of Gastrointestinal Endosurgeons. Fellowship in Minimal Access Surgery. Fellowship in Indian Association of Gastrointestinal Endosurgeons, Upper GI. Executive Committee Member, Karnataka Private Medical Establishment Association from the year 2016 to till date. Secretary Private Medical Establishment, Gadag Branch. Member National IMA Standing Committee for Medical Legal Cell. Member National IMA Standing Committee for Medical Equipment Protection Committee. Member State Karnataka Private Medical Establishment Expert Committee for recommending standard protocols for treatments, procedures and prescriptions audit. Project Management Group of AIC STPI Bengaluru. Member IMA KSB Price Fixation Committee for IMA KSB and Government Committee. Elected member of Karnataka Medical Council 2020. Vice President IMA KSB from the year 2023 to 2024. Joint Secretary IMA National CGP from the year 2022 to 2023. We are indeed privileged to have such a distinguished personality among us today. As a token of our respect and appreciation, we would now like to felicitate our honored guest. May I request Dr. Prasanna Kumar Sir, Librarian, BLD School of Law, to kindly come forward and felicitate Dr. Pawan Kumar Patil Sir, Member, Karnataka Medical College, Gadag. Thank you, sir. Now, without further ado, I would like to respectfully invite Dr. Pawan Kumar Patil, sir, Member, Karnataka Medical Council, Gadag, to address the gathering and share their valuable thoughts on the topic of reforming medical negligence law in India, a regulatory perspective.
Good afternoon, everybody. Respected senior professors, Dr. C.S. Patil sir, professors from the law college and university. It is my great privilege to stand in this hall because Bijapur is my second home. I spent my 10 years here. This college is my alma mater, and I have learned a lot of life skills in this college. So, and standing before you and speaking on medical laws and regulations is a really proud moment for me. Thank you, Kulkarni sir, for giving this opportunity. And I should congratulate the organizing team because probably this is the first time such a medical negligence seminar or CME where I see all three connected professionals, the police, the law and the medical professionals that too with a full hall, sitting all at a time. It is really astonishing to see this. I thank the organizers for the same. Today, in my professional life, I have seen three different stages. One as the practitioner, medical practitioner. Second is as an administrator of a hospital, looking into the documentations and other aspects of the patient's care and patient rights. Third is now I am a member of a constitutional body, the Karnataka Medical Council, where I am an elected member, and I have seen the problems faced by both sides, the patients as well as the doctors. So then I felt the topic of what reforms in medical negligence law we can get in our country, that would be a better topic for this forum. So reforming medical negligence law in India, that is today's topic. I will be covering it in different headings, that is understanding medical negligence, that most of the earlier speaker, my mentor Dr. Yoganand Reddy sir and Dr. Babu Gowda sir has covered majority of them. What is the present legal framework of medical negligence in India, the current challenges and need for the reform, and finally the concluding remarks. I would like to begin with a scenario. An critically ill patient comes to a hospital or maybe to a doctor at around 2 a.m. in the night. He rushes to the patient, examines, sees the criticalness of the patient, explains the patient relatives about the critical illness, and there is a surgery which has to be done on the patient. They take the proper consent. They do all their best what can be done. They struggle for an hour or two with the surgery, and ultimately, with all the efforts, patient dies. Next day morning, there is police personnel in front of his hospital saying that there is a complaint on him, there is an FIR or a complaint. There is a media reporting saying that because of the negligence, patient died. Then the case goes to the civil court or the consumer court, or it comes to a medical council as a complaint. The case goes on for 2-3 years. Then finally, based on the medical expert opinions and the court proceedings, he is declared there is no negligence. Now, looking at this scenario, what happens to his reputation for that 2-3 years of the court case which he fights? What is the mental agony he undergoes? And coming to the patient side, how will we educate the patients that certain times there are known complications in medical field? As sir said, medicine is not mathematics. It is a science of probability, not a science of certainty. So, and there are certain genuine medical negligence cases. How to get justice to this patients at the right time and at right duration. This topic is all about that. So, what are the different aspects of medical negligence and how it is proved? The medical negligence is proved on four points. That is, one is duty of care. That is, each doctor has his duty towards the patient. That is his duty of care. He has to see the patient. Then there should be a breach or deviation from the duty. Not only at this point the negligence can be proved, this breach or deviation should cause some harm to the patient. Like there is a death which has happened in a patient. It should be proved that there was a breach in his duty which has caused that death. Then only the whole medical negligence can be proved. If there is a deviation but it has not caused any harm, then we cannot prove it as medical negligence. So there is all 4 points, and it should have caused some type of harm. Death is one of the forms. When the patient claim for negligence and they file a case, they file it as a prayer. Lawyers will know, the police people will also know that in any complaint they have a prayer. They might ask, I have been my mental agony, I had a mental agony, I had financial problems because of this, I have a deformity in my body because of the procedure which has undergone. So these are all different types of the end results or the harm he has faced. Now coming to what is the distinction between negligence and complaints. Not all complaints what we receive at the council or the court are because of the negligence. So there is a difference between complication. In the medical literature, there is a predefined set of complications to any type of disease or the procedure. When a doctor treats them, there can be complications. Like if you can say in common words, if I travel in a road in a bike, there are complications. He can fall. He can fall by hitting another vehicle or by just hitting also. So that is a known complication of riding a bike. Now, if he goes, there is a pothole and he falls in the pothole and falls, he sustains an head injury. Now, negligence is not wearing a helmet. So similar way in the medical profession also, there is a set of standard guidelines on operating or treating the patient. If there is any deviation and deviation is causing some harm, then only negligence is put. But he has done the normal procedure and there is a complication which has happened which is mentioned in the medical literature, then it is not a negligence. Non-identifying of a complication, not treating that complication is a negligence. Again, it is a deviation. So if he has identified the complication, if he has advised the patient correctly, then there is no proof of negligence. So the common thought process in the society of the public is, patient lands up in complication, they think that doctor has done some mistake. They file a case. This is because of lack of information and misinformation which is being circulated. The current legal frameworks in India are, the patient can complain with the local district KPMA redressal committees. That is the first step what they can do. They go to the police. Through the police it goes either to civil liability or a criminal liability based on the nature of the harm which has been caused. Second is Consumer Protection Act. Third is, as I showed, criminal liability, which was earlier 304 IPC, now it is 106 BNS. Fourth is professional disciplinary action, that comes to the state medical councils. That is the medical body where education takes place. I want to stress one point here is, the state medical councils cannot give opinions. As per the Jacobs-Mathews case, there is a guidelines for filing an FIR and arresting a doctor. Police people are here, that's why I am stressing on this point. Whenever a patient or a patient party comes for a complaint against a doctor, there cannot, even if there is a death, the police personnel cannot arrest a doctor without having a proper medical opinion from a medical body. That is to prove if there was a gross negligence, not just negligence, there was a gross negligence. There is a difference between simple negligence and a gross negligence. So, to prove that there is a gross negligence, there has to be a medical board opinion. And these opinions has to be sorted within 60 days as per law. Because the police personnel have to file a charge sheet, have to show that there is a negligence, they should file a charge sheet and then produce it to the court also. So they have a timeline. But what happens is, these complaints, because there is a body, known adjudicating body, Karnataka Medical Council, we have been receiving a lot of opinion seeking applications from the police department to the Karnataka Medical Council. The Karnataka Medical Council doesn't have the powers to give an opinion based on just a case scenario. It is an adjudicating body and not opinionating body. So once they have given an opinion, they cannot again further take up the case at Karnataka. So the medical bodies are formed at the district level and not at the state level. Boehm's test, as already has been explained by both the speakers very thoroughly and explicitly, it applies mainly in medical cases or any professional bodies. What happens usually in a legal process of medical negligence and how things go on? Complaints are filed, evidence is collected, first hearings happen, and then there will be examination, as sir said, chief examination, then cross-examination of both the parties, and then the final arguments and the final orders. This is the process. And same law applies here also. It is the duty of the complainant to prove the negligence based on whatever evidence they have collected from the patient's records. So evidences have to be presented when proving medical negligence. This makes things complicated while proving negligence from the patient's perspective, because they are not aware of medical knowledge, nor the legal experts who are helping them out to fight their cases are medically knowledgeable, or medical literature is not available. And with whatever limited resources of evidence they have to prove that there is a negligence. This hinders their process of justice. Now the role of medical councils, same, is a quasi-judicial body. We adjudicate only medical related medical negligence cases, as well as any deviations in the or violations in the medical code of conduct or ethics. And the disciplinary action what we can take is, we can give them warning, we can give them some disciplinary actions like attending some conferences, some activities. Next comes the cancellation, temporary cancellation of their registration, so that they cannot practice for say 3 months, 6 months or 1 year. Or sometimes when it is a very grievous, or they have had any other criminal cases which they have been proved in, then there will be a permanent registration cancellation also. This is the overview of how inquiry process takes place. What are the current challenges and need for reform in medical negligence laws? The key cases influencing medical negligence law in India are Jacob Matthew and versus State of Punjab, where it mainly says about gross criminal negligence has to be proved before taking any action. Then next is Kusma Sharma versus Batra Hospital, where it clearly says, don't have, when you are giving any opinion, medical opinion, don't have hindsight biases. What does it mean? Like, it is like seeing highlights of a cricket match and saying Sachin Tendulkar should have hit like this, hit like that. So it is easy to say after the process has taken place. Given that situation, given that place, if the doctor has acted, as Dr. Yogananda Reddy sir said, if he has acted to the best of the knowledge of medical profession, then there is no negligence. If he has deviated from that, then there are definitely some points of negligence. Then another case was Martin D'Souza versus Mohammad Issa, where it is clearly stressed that importance of expert opinion is needed. Some statistics on litigations. A lot of the earlier speaker said things, and even our Vice Chancellor and my teacher, Dr. Arun Inamdar sir, said things have changed over a period of years. A lot of litigations are coming. Presently, there are around 65,000 medical negligence cases were filed in India in 2025 across the Supreme Court, High Courts, and consumer forums, indicating significant rise in litigations. What happens? All these points have been discussed by the earlier speakers. There is rise of defensive medicine, avoidance of high-risk specialties, increased documentation burden to the hospital, which is coming down now by the era of digitalization, decline in doctor-patient trust, increased cost of healthcare. How does it increase the cost? If I miss out something, I might have the fear of this patient. If I miss something, he will go and file a case against me. So I will do whatever possible tests, whether it is indicated to his pertaining symptoms or signs, I'll get all the tests done. That has been happening now. So we have to balance that. Psychological impact on doctors, significantly yes. And there is a literature which says that because of this psychological impact, the lifespan of doctors have reduced by 5 to 10 years as compared to the common general public. Then there will be a delay in emergency care. He will take some time to take decisions whether I can handle this case here. If the patient, he will see the surroundings, relatives, how they are reacting. If they feel they are something little bit litigation oriented or they are violent, then they will say, no, you take him to the bigger center. So there will be a delay in emergency care. There are certain conditions where we call it as golden hour, be it heart attack, be it stroke, where we have to act within no time, within 6 hours, within 12 hours, we have to act. By doing this type of defensive or with the fear of litigations, this golden hour is lost because he has to travel again to a different hospital, again to a different hospital. Then it has a significant effect on impact on rural healthcare. Because of litigations or violence, people are fearful of practicing in rural areas because of limited resources in rural areas and also because of the litigation mentality. What actually drives medical litigation is poor documentation. All these points have been told. Communication gaps, significant communication gaps is what causes litigations. Unrealistic expectation. For communication gap, I'll just like to give one example. Many of you might have visited one or the other hospitals in Bangalore. I'm not comparing Bangalore or any other place. That commonly happens in bigger places. Why? Because commuting is a major issue there. Whereas we also, as an educating body or the medical council, we see 70% of the cases or 80% of the cases are from bigger places and not from peripheral like northern Karnataka or peripheral places. That is one of the reasons being, commonly what we see is in the small and medium hospitals, I might see a patient 2-3 times. I might talk to the patient 2-3 times. But that is practically impossible in bigger places because they travel 2-3 places, and going from one hospital to another hospital for a doctor, it itself will consume so much amount of time. So there is a lack of communication between the patient and the doctors. Having unrealistic expectations from the patient side also is a form for litigations. Financial disputes. I will cover 1 or 2 slides on that. Majority of the times at the end of the patient care, patient is happy. The conflicts majority of the time starts is during the financial disputes. So I have few solutions for the doctors here and for other public also. Inter-doctor criticism. This is again one of the reasons for litigations. I see a patient who has been seen by another doctor earlier. When I see him, even if I say, there are some intelligent people who might pick up that doctor has put something wrong and he will file a litigation. So I should be very careful when I speak to the patient, when I communicate with the patient. Not to comment anything about where he has seen, what treatment he has seen are given. Corporate hospital billing perceptions is wrongly misinterpreted. I know there are some incidences, but we, being a medical profession, commenting on any other professional billing is not right. So, whole and soul, it is like medical error itself is not a sole cause for litigations. Patient often value doctor's generosity more visibly than the doctor's technical competence. Here comes the billing aspect. Sir was telling, I treat simple appendicectomy. Don't glorify that I have done a significant. Don't threaten the patient that if you don't get this surgery done, you will die. And then you operate and then you glorify that I have saved your life, so I am billing you 2 lakhs. Don't do that. But similarly, there is another aspect of that. I do a simple appendicectomy. Patient is very happy. He is going home next day itself. Then routinely what is told to him and billed, still the common mentality amongst the public is concession in medical profession. We don't ask anything anywhere else. We go to a restaurant, we eat. We don't ask concession. We stay in a hotel, whatever standard hotel, we don't ask concession. But somehow this practice of concession, asking it to the doctor, is come as a routine in the society. I would like to tell my doctor's friends that don't take it as a negative aspect, convert it into a positive. Make a platform in your hospitals where billing problems can be addressed. Where they have to ask, whom they have to ask. They will go to the reception, the bill is given, they are asked to pay this much amount. They are in genuine problem or they are not in genuine problem. Still, you should give them a platform whom to ask for concession. Some patients, even if you give 200 rupees concession, they are very happy. Some you give 5,000, 10,000 concession, they are not happy. So one of my colleagues said, "Sir, you ಏನು ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಟ್ಟರೆ ಅದರ ಮೇಲೆ ಖುಷಿ ಇರೋಂಗಿಲ್ಲ, ನೀವು ಎಷ್ಟು ಬಿಟ್ಟರಲ್ಲ ಅದರ ಮೇಲೆ ಖುಷಿ ಇರ್ತಾರೆ patient." So use this tactic of society as a positive aspect of it. Give concession. He will go out into the public and say, "Hey, our doctor ಭಾಳ ಚಲೋ ಅದಾರ, ನಮ್ಮ ಗಾಡಿಗೆ ಬಿಲ್ ರೊಕ್ಕ ₹100 ಬಿಟ್ಟರೆ they will say to this to 10 people. And even out of that 10 people, 2-3 people will come to you. So use this as a positive aspect. Though it is a negative thing, use it as a positive. And most of the conflicts start at billing counter because they don't know whom to ask. So prevent that litigation. In healthcare, trust is sometimes built not only in the operating theatre but also in the billing counter. That is all what, and most of the arguments start at that point, and they are leading to violence also in healthcare. So make hospitals should create a formal platform where patient can ask for explanation of the billing before discharge. A simple conversation explaining charges or providing reasonable concessions can convert dissatisfaction into trust. Many disputes in healthcare arises not from treatment failure but from financial misunderstanding. And majority of the consumer court cases are also because of this, not because of any negligence. So violence against doctor, I would like to stress one or two slides on this. A recent healthcare workspace study found that 62.6% of healthcare workers experience violence. Violence need not be just hitting or pushing or damaging the property. Even a verbal abuse to a doctor or a healthcare professional is considered to be a violence in healthcare profession. So 62.1 is verbal abuse and 13.6 is physical assault. So it will lead to a lot of legal and social consequences, exploration of that violence on doctors' practice and the healthcare. Again, because of the violence, there is again litigation. You have to fight the case, or there is a negotiation. Media trial happens before you are proved you are guilty. All these things come and it causes a lot of psychological. One senior member told me before the talk, please highlight this. Suppose there is a violence against. Violence is created only because of one patient, but your hospital has 100 patients. There are critical patients in your ICU. Imagine the violence occurs, a doctor and his staff are hit, and there is a need for that doctor himself to treat in the ICU, and that patient also dies. Who is responsible for that death? Is it the doctor or is it the violence which has caused the delay in treating that ICU patient? So prevention is always better, and I should thank C.S. Patil sir. Through our organizations, we approached the law minister to bring in amount, and whatever from Kilpar they mentioned that out of 105 requests, 95 are enacted. Ours is also one of them, because C.S. Patil sir, he is such a simple person. The way he spoke, he literally lives his life like that. Because when we were drafting, he was sitting and typing the draft. To his stature, he can ask anybody to type. But he was so accommodative and he was discussing all practical issues, and he was so helpful, and it brought out a significant law. And I should say the Karnataka present Act, Healthcare Violence Act, is one of the best in the country. And the credit goes to C.S. Patil sir for drafting it and getting it implemented. So we thank you sir for that. Wherein even we had missed out social media advertising. Sir specifically said we will include that social media advertising. So concluding, why reforms is urgent? Litigations are increasing, insurance premiums are rising. What do you mean by insurance? It is not individual insurances. Hospitals also have insurance for these violence and litigations. They have something called as indemnity. So the premiums of these indemnities are increasing because, as sir said, 7 crores for a doctor. It's a huge money. From here, where he has to pay. Even the insurance companies won't pay 7 crores. The whatever 1 crore, whatever premium, the total amount of indemnity he will have, rest 6 crores he has to pay from his pocket. So, if you have more claim amount under your insurance, you have to pay more premiums. Young doctors are hesitating to take high-risk specialties and emergency cares. So, rural emergency care suffers when doctors fear criminal prosecutions. If law makes medicine fearful, society ultimately pays the price. So, we have to balance between both. So, all these 3 talks today are so enlightening that there can be significant reforms which can come. Few of the points for reforms is, there is some typing error. One is establishment, as sir was telling in, Babugoda sir was telling about pre-litigation medical review boards, mediation or medical review boards. These boards will evaluate claims before litigation, aiming to strengthen. Because there should be some body at every place where they can at least tell this is complication, this is negligence. There is some doubt that after we have taken over, we have been following that. We don't register all the cases which are coming to the council. We re-evaluate the complaints. If we feel that there is even smallest doubt of negligence, we register the case and continue the proceedings as per the civil procedure. But if there is no negligence, if we find there is not even a single smallest point, we dismiss at the entry level. So if such things happen, then litigations and the number of cases can come down. Graded negligence classification. Presently in India, WHO has classification. In India, we still don't have the classification for negligence, like minor, medium or major, something like that. Creation of structured medical mediation cells. As Dr. Babugoda sir was telling, mediation cells are required to make both the parties understand what is what and then mediate the issue. Then digital documentation. This is coming up in a very big way because documenting everything is a major burden and time consuming aspect in healthcare. Because if you don't document, tomorrow it can turn out against you in medical litigations. So documentation is a major issue. Few developed countries, I happen to participate in 2 of the international conferences where AI is being implemented. AI regulations still not come up. But some countries are using medical transcript, voice medical transcripts, where there is a voice recorder in your OPD. All that what you talk with the patient, even our Suddhi matadidru adu record agutte. But out of that, with the click of a button, only his medical history comes out. So it will save significant amount of your time in documentation aspect, and it will also help us in managing the litigations, because as sir was telling, not all that is written is explained to the patient, or all that is explained is written on paper. So in courts we see, sir, doctor might say, na helidri avarige paper ne gar bandilla. But what court sees is what is written is written. What is talked is not, no proof. So this digitalization will help reduce that also, the documentation, and everything is on medical transcripts. Rationalizing parallel proceedings. Simultaneously, a patient will file a case in civil court, consumer court, and medical counsel. It is a trouble for the patient. He has to run out on 3 courts. It is a trouble and mental agony to the doctor because he has to represent all 3 places. And you never know when each case. I can give an example when there is a litigation in consumer court and also in a medical counsel. The consumer court dismissed the case in 2020, but the medical counsel got ended in 2025. Only because they don't come. We keep giving them options, they don't come. So it keeps prolonging. So rationalizing parallel proceedings. There should be a good coordination between all these judicial platforms so that judgment happens at one place. Like BOLEMS, a medical body is adjudicating wait for that opinion and then take up other proceedings. Some type of reforms in such manner would help both the parties, patients as well as doctors. So important of immediate actions is medical negligence law should not become a battlefield between patients and doctors. It must bridge ensuring accountability, fairness and trust. The goal is not to shield negligence. The goal is not to harass honest professionals. The goal is to protect justice. When law and medicine walk together, society benefits. When they stand opposed, society suffers. So, one common thought process, everybody spoke about Boehm's test. Amongst the common public, there is a common mentality that if doctors only say, our friends are punishment kodangilla anta. This is a common mentality when we speak with public. You decide ಮಾಡ್ತೀರಿ ಎಲ್ಲ ಯಾರಿಗೂ ಡಾಕ್ಟರ್ಗೆ ಬರೀ. Believe me, in last 6 months, at least 4 to 5 doctors suspension has happened because of negligence. So whatever counsel, we have to follow civil procedure code. We cannot deviate anything. So that common perception amongst the public should go that we won't get justice if we are going to a medical body where they are adjudicating medical negligence cases. So I once again thank Dr. C.S. Patil, Dr. Kulkarni and all the faculty of BLD Law College for giving us this opportunity to stand before you and discuss the medical negligence laws, and I am really privileged for having delivered this talk in my own alma mater. Thank you.
Thank you, sir, for such an enlightening talk. Your insights on the reforms of medical negligence laws and regulatory framework in India have been truly valuable for all of us. We sincerely appreciate your time and contribution to this session. With this, we come to an end of our technical session. We will now have break for lunch. In case anybody have any doubt, any question, so we have discussion session right now, so they can come up with their doubts and questions. Okay, the questions, if you have any question, you can ask it after the lunch break. I kindly request everyone to rejoin after the lunch break for the paper presentation session. Thank you, everyone. Good afternoon, everyone. This is Afin Kazi, second year LLB student. After an insightful and enriching technical session, we now move forward to the next segment of today's program, the paper presentation session. Paper presentations provide a wonderful platform for young minds to share their ideas, research and perspectives on important legal and social issues. It encourages academic discussion, critical thinking and intellectual exchange. For this session, we are honored to have two distinguished chairpersons with us. Firstly, I would like to respectfully invite Dr. Chandrika Dodihal ma'am, Associate Professor, Department of Community Medicine and Deputy Director, R&D Cell, BLD, University, Vijaypur. We are truly honored by your presence, ma'am. May I request you to please take your seat on the dais. Next, it is my privilege to invite Dr. Prachi Parvatikar ma'am, Assistant Professor, School of Applied Science and Technology, BLD, deemed to be University, Vijaypur. We are delighted to have you here, ma'am. We request you to kindly take your seat. Let us welcome our esteemed chairpersons with a warm round of applause. To express our respect and gratitude, we would now like to felicitate our esteemed chief guest. I request Ms. Sana Kausar Mughlai ma'am, Lecturer, BLD School of Law, to felicitate Dr. Chandrika Dodihal ma'am, Associate Professor, Department of Community Medicine and Deputy Director, R&D Cell, BLD, deemed to be University, Vijaypur. Thank you, ma'am. Now I request Ms. Pallavi Yarnal ma'am, Lecturer, BLD School of Law, to kindly felicitate Dr. Prachi Parvatikar ma'am, Assistant Professor, School of Applied Science and Technology, BLD, deemed to be University, Vijaypur. guidance of our respected chairpersons, we shall now begin the paper presentation session. Each participant will be given the opportunity to present their research work. I request all the presenters to kindly adhere to the allotted time. Let us begin with our first presenter. I invite Dr. Kirti Vardhana Kulkarni to present their paper. With our paper presenters. Now I invite our first presenter, Dr. Sridevi ma'am from BLD Law College, Jamkhandi, to present her paper.
Good afternoon, respected chairperson, distinguished faculty members, and my dear colleagues and students. It is my privilege to present my seminar paper on the topic Medical Negligence and Landmark Judgments in India. The medical profession is regarded as one of the most noble professions because the doctors are entrusted with the responsibility of serving human life. However, when a medical professional fails to exercise reasonable care and skill while treating a patient, it may result in a serious harm, which the law recognizes as a medical negligence. In this presentation, I will briefly discuss the concept of medical negligence, the legal provisions in India, and some landmark judgment delivered by the Supreme Court. The medical negligence occurs when a medical practitioner breaches the duty of care owed to the patient and causes harm. With the advancement of the medical science and the increasing awareness among the patient, the number of medical negligence cases has increased in India. Courts have therefore developed the legal principles to determine liability and ensure justice. Medical negligence has emerged as an important issue in the modern healthcare system. The relationship between the doctor and patient is based on trust and a professional responsibility. However, when a medical professional fails to exercise reasonable care and skill in treatment, it may lead to the serious injury or the death of the patient. In such circumstances, the law provides the remedies to protect the right of the patient. Patients rely on knowledge, expertise, and judgment of the medical practitioners. However, when doctor fails to provide the treatment according to the acceptable medical standard, the consequences can be serious. Courts have therefore developed the legal principles to determine liability and ensure justice. This paper examines the concept of medical negligence, the legal provisions applicable in India, and major judicial precedents that have influenced medical jurisprudence. So let me tell you about what is the meaning of the medical negligence. So medical negligence refers to the failure of a doctor or the healthcare professional to provide a proper care, skill and diligence during the treatment, which results in an injury or the harm the patient. In legal terms, negligence is the breach of the duty caused by omission to do something which a reasonable person would do. And what are the essential elements of the medical negligence? To establish a medical negligence, the following elements must be proved. Firstly, I can say that it is a duty of care. The doctor has a duty to provide the treatment to the patient. And the second element is that the breach of the duty. The doctor fails to follow the accepted standard of medical practice. And thirdly, damage. The patient suffers injury or the loss due to the breach. And now, let me discuss with the legal framework in India. So, medical negligence cases may arise under the civil, criminal or the consumer law. And with this, I can say that there are some important provisions which included in India. The firstly, we can say that the Consumer Protection Act 2019, patients are considered consumers. And secondly, Indian Penal Code, the criminal negligence, and the law of torts, the civil liability for damages. And with this, relevant sections, IPC, Indian Penal Code, section 304A, which deals with the causing death by the negligence. And the Consumer Protection Act 1986, the patient can claim compensation for deficiency in service. And thirdly, we are having the civil law, which the patient can file suits for the damages in civil courts. And now, what are the landmark judgments in India? The first and foremost, let me tell you the few cases I am going to deal with that. That is Indian Medical Association versus VP Santa. So in the year 1995, the issue was whether the medical service fall under the Consumer Protection Act. The judgment was that the Supreme Court held that medical services are included under the Consumer Protection Act. The importance was that the patients are considered as a consumers and they can file complaints in the consumer court against the doctors as well as a hospital. And secondly, Jacob Matthew versus State of Punjab in the year 2005. Fact is that a patient died due to the lack of oxygen in a hospital, and judgment the Supreme Court held that criminal liability of a doctor arises only in cases of gross negligence, and the importance is that it protects doctors from the unnecessary criminal prosecution and distinguishes between the medical error and the criminal negligence. And the next one is that Dr. Balram Prasad versus Dr. Kunal Shah in the year 2013. Fact was that a patient died due to the improper treatment in a hospital. The Supreme Court awarded one of the highest compensation in India for medical negligence. The outcome is that it emphasized the accountability of the hospitals and the doctors, and it strengthened the patient rights. And what are the impact of these judgments? So I can point out only 3 points. So here it protects the patient's rights, and secondly it ensures the accountability of doctors, and thirdly we can say that maintain balance between the patient protection and medical profession. And the next thing is that what are the challenges? Challenges in medical negligence cases, some difficulties faced in medical negligence litigation, which includes complexity of medical evidence, secondly requirement of expert ceremony, and the delay in court proceedings, and lastly we are having a lack of awareness among the patient. And what are the important suggestions? So strengthening hospital accountability system, increasing patient awareness of legal rights, establishing faster dispute resolution mechanism, and protecting the ethical standards in medical practices. Lastly, conclusion. Medical negligence laws plays an important role in protecting the patient rights and maintaining accountability in healthcare services. It's strengthening the legal awareness and the ethical medical practices will further enhance trust in healthcare system, and to conclude, medical negligence is a serious issue which affecting the patient's safety and trust in healthcare system. The judiciary in India has played a very crucial role, an important role in developing the legal principles through the landmark judgments. So these decisions, it aims to maintain a balance between protecting the patient rights and safeguarding the medical professionals. Therefore, ethical medical practice and legal accountability are essential to ensure the justice and the quality healthcare. Lastly, I will conclude my presentation with a quote. When a patient enters a hospital, they place their life in the hands of a doctor. If the trust is broken, justice must heal what medicine could not. Thank you, wonderful.
Thank you, ma'am, for your insightful presentation. Now I invite our next presenter, Monsa HN ma'am, to present their paper.
Good afternoon, everyone. I am Manasa H. Sri Sharada School of Law, Chikkamangaluru. Today I am presenting my paper titled Medical Negligence under Indian Law. Here I am covering the synopsis like introduction, meaning of medical negligence under consumer protection law, and medical negligence under criminal law, and the suggestion, critical analysis, and last conclusion. So now I discuss one by one, starting introduction. So, healthcare services, I repeat, healthcare services are essential for safeguarding human life and well-being. Doctor and medical professionals are entrusted with diagnosing illness, providing treatment, and ensuring patient safety. This reasonability demands that they exercise a reasonable degree of skill, care, and diligence.
When a medical professional fails to meet the required standard of care, resulting in harm or injury to the patient, such conduct may constitute medical negligence. In India, medical negligence claims were traditionally addressed under tort law. Over time, however, consumer protection laws, legislation and criminal laws provisions have expanded the legal remedies available to patients. The Consumer Protection Act 2019 allows patients to file complaints against hospitals or doctors for deficiency in services and claim compensation. Meanwhile, the Bharatiya Nyaya Samhita 2023 provides criminal liability in cases of gross or reckless negligence causing serious injury or death. So, the main object of this paper is to examine the scope of medical negligence with the Indian law. So, this paper analyzing its meaning, legal principles along with some important judicial interpretation. So, the meaning of medical negligence. The meaning of medical negligence is the failure of a medical professional to exercise reasonable care, skill or diligence while treating a patient. Resulting in injury, it arises a doctor's conduct fall below the standard expected from a reasonably competent practitioner in similar circumstances. To establish medical negligence, 3 elements must typically be proven. The first one is duty of care. It means a doctor owes a duty to provide competent treatment, and the second one is breach of duty, and it means conduct falls below the accepted standard, and the third one is damages. Injury or harm results directly from the breach. So the next is medical negligence under consumer protection law. The inclusion of medical services under consumer protection legislation marked a major development in protecting patients under the Consumer Protection Act 2019. Patients paying for treatments were considered consumers and may seek remedies for deficiency in services. In Indian Medical Association versus VP Shanta 1995, the Supreme Court held that the medical services fall within the definition of service. This is the landmark judgment under the Consumer Protection Act. Except in cases of completely free treatment, this enabled patient to approach consumer forums for the compensation in cases of negligent medical services. So, and then medical negligence under criminal law. Criminal liability arises when negligence is gross or reckless, resulting in death or serious injury under the Bharatiya Nyaya Samhita 2023. Medical professionals may be prosecuted for acts of severe negligence that demonstrate disregard for life. In BNS, medical negligence in India is primarily covered under Section 106 subclass 1 of the BNS, that means Bharatiya Nyaya Samhita 2023, which replaces Section 304A of the IPC. Next one is the medical negligence under the tort law. Before I start tort law, first we have to know what is tort. Tort is nothing but civil wrong. It is a Latin word. It means tartar. It means twisted or crooked. Example for tort law is negligence and nuisance, defamations, etc. Tort law provides civil remedies for medical negligence, allowing patient to claim damages for harm suffered. A patient must prove duty of care, breach of duty, and causes of damage. In the case of Lakshman Balakrishna Joshi versus Trimbak Bapu Gadbole, the court held that doctors must exercise reasonable skill in choosing and administering treatment. Civil remedies generally include compensation for medical expenses, pain and suffering, loss of income and related losses. With that, and the one of the maxim is voluntaria non fit injuria. It means is a defense in tort law, meaning to a willing person, no injury is done. It means consent. When it is applied, the consent must be free, given in freely. If a person is forced or pressured or under an obligation, the consent is not valid or invalid. The suggestion and recommendations are increase public awareness about patient rights and legal remedies, and strengthen regulatory bodies to monitor healthcare standards, and establish specialized tribunals for medical negligence disputes, and encourage hospitals to maintain accurate medical records and clear communication, and promote a balanced approach protecting patients without penalizing honest medical errors. So I would like to conclude by saying the medical negligence law plays an important role in protecting patients while maintaining trust in the healthcare system. The Consumer Protection Act 2019 has strengthened patient rights by recognizing medical services as a form of consumer service and providing remedies for deficiency. At the same time, the BNS 2023 continues to address criminal liability in case where negligence causes serious harm or death. However, the law must strike a careful balance so that medical professionals are not unfairly penalized for genuine errors, while ensuring accountability for negligence conduct. Therefore, the medical negligence is an legal issue that lies at the intersection of healthcare and law. While the legal system aims to protect patients from negligent treatment, so a balanced appearance is necessary to maintain both patient safety and professional autonomy in the healthcare sector. Thank you, sir. Thank you.
Thank you, ma'am. I now invite our next presenter, Dr. Shamin E., to present their paper.
Respected judges, distinguished guests, and my dear friends. I am Dr. Shamin Benson, representing the Department of Community Medicine, BLD Medical College. The topic that I would like to present, that is the research that I conducted recently. Its topic is medical negligence, perception among undergraduate medical students, a cross-section study from Vijaypura, North Karnataka, India. So, introduction. So basically, on the 20th of February last month, there was a sensational case in the state of Kerala. A lady who had undergone an abdominal surgery some 5 years ago, she presented to a hospital with abdominal pain, and an X-ray was taken, and they found that an artery fossa was lodged there for 5 years, and it became a big issue. All the media has covered it, and even everybody in the government were affected, all because one nurse forgot to take the correct count of the instruments. So that is how significant. Now criminal cases have been lodged against all the people. So, in July 2024, the Bharatiya Nyaya Samhita replaced the Indian Penal Code, or IPC. It was a holdover from the British colonial authority. So, although the IPC reforms were generally well received, the medical community had expressed serious concerns about it, mainly because of Section 106 of the BNS. Why was it so? Because many in the medical field, they worried that this clause, which requires incarceration for physicians implemented in deaths brought on by rash or careless behavior during medical operations, could create a culture of fear and reluctance to execute crucial medical interventions. So Lord Mackay, he outlined the following criteria. First of all, the duty of care must be established. Then the duty should be proved that it was violated. Then the violation should result in the death of a victim. And finally, the jury determines that the violation should be classified as gross negligence and thus a crime. So this, and in various medical blunders can occur, then unscientific therapies, then disregard for medical advice, then complications that are out of healthcare providers, and also delay in seeking medical attention. All those things can happen. Then regarding this study was done to assess the knowledge, attitude and practice regarding medical negligence in the field of medicine among medical students in this particular hospital. Why was it so? Because the medical students of today are the medical practitioners of tomorrow. Coming to the material and methods, the study area of course is BLD Medical College. It was a cross-section study. An interview technique was used and the data was collected on a period of 2 months. The sample size was 150. Convenient sampling method was employed. An institutional ethical clearance was obtained, informed consent from the MBBS students were obtained, and KAP medical question and negligence questionnaire was given to them, and the data was analyzed using SPSS software. And what were the results? Coming to the social demographic profile, the gender, that is 51.7% of them were males. Then the majority, that is 83%, came from urban backgrounds. Then they were aged, the majority 93% were aged between 18 to 22 years. And most of them had less than 1 year of clinical experience. Then when asked whether they had any prior training, only 60% told that they had received some kind of training in medical law or ethics. Then when we asked some 15 questions regarding knowledge and 5 for attitude, we found that the knowledge score was 62%, they had good knowledge. Regarding the attitude, some 50% they had a positive attitude. This shows the knowledge questions that were asked. A large number of questions were asked, including what medical negligence referred to and what were the legal principles to determine medical negligence, and what is res ipsa liquidator, and what were the Supreme Court guidelines, and what is Bolam test. So these were some of the questions that were asked to find out the knowledge of the medical students. Then coming to the attitude, then whether the doctors were aware of the legal aspects of the medical negligence, and whether they should be included in the medical curriculum, whether they had fear of litigation, and whether training programs were conducted. Coming to practice, if at all they are following the routine procedures like even getting written informed consent, whether they are maintaining proper records, and whether they are following the normal treatment guidelines. And seeing the association between gender and knowledge, we found that in this there was nothing significant. We compared the gender, then whether they had received any formal training, and whether they are from an urban or rural background. But here we found that in practice we found that there was an association between whether they maintained proper medical records and also whether standard treatment guidelines were followed. They had this was significant because the p-value was 0.02 and 0.011 respectively. Regarding attitude and gender association, also we did not get any significant results. Now coming to discussion. A study which was conducted in Saudi Arabia, we found that there was 72.1 out of 72.1% of medication errors, only 41.2% were actually reported. So this was one of the findings. In another study which was done in Ethiopia also, we found that the knowledge level of misconduct that was a bit low, and they found that a lot of malpractice was happening in surgery. That is, the wrong patient was done surgery, and also there was inadvertent harm to the nearby organs in 10.8%, and a lot of medical problems were elicited. Another study in which 420 MBBS students took part, there also their knowledge, they had around 50%, they had correct information. So basically what we see is that the WHO, they are taking that they are trying to increase the standards of care so that such problems can be alleviated. What is the conclusion? We found that medical negligence is actually a real issue, and the doctors of the medical students of today who are the doctors of tomorrow, more knowledge should be provided to them, then more seminars and other things should be done for them so that their knowledge regarding medical law, ethics and even medical negligence improves. These are the references, and just a few words. So what is medical negligence? So medical negligence means a doctor has to give a reasonable amount of care. That is, any doctor in any circumstances should be providing such a reasonable amount of care. If that is not provided, it can constitute medical negligence. Then there is something called Bolam's law. So here actually what it refers to is the doctor is not negligent if he or she acts in accordance with the practice that is generally followed or instituted by a medical body. Then for a medical negligence case to be convicted, there should be the duty of care should be established, then the breach of duty should be established, and causation and damage also should be there. Now, what are some of the examples of medical negligence? We see that misdiagnosis or a delayed diagnosis, then surgical errors, that is surgery on the wrong side or wrong limb or even the wrong person, then medication errors, that is wrong dosage of drugs, then failure to get even an informed consent and improper follow-up, and all these things, they are taken as medical negligence. Then there is something called the types of medical negligence, which include civil negligence, criminal negligence, and professional misconduct. In the case of professional misconduct, it is the National Medical Authority Commission that takes care of it. So I told about medical negligence, volunteers, elements, examples, types. Then there are three specific landmark judgments. That is Jacob Matthew versus the state of Punjab, and the Indian Medical Association versus VP Chani, and Ushan Sharma versus Batra Hospital. So these three things, they have formulated how medical negligence cases are treated in India. So with this, I would like to conclude that medical negligence is a real serious thing, and doctors as well as lawyers should take the interest of the patient at heart, and more training should be given to medical students as well as doctors, and patient care should not be compromised. With these words, I close. Thank you.
Thank you, sir, for your insightful presentation. We have now come to the end of presentation. To provide valuable insights and observation on today's presentation, I would now like to invite our respected chairperson, Dr. Chandrika Dadihal Ma'am, Associate Professor, Department of Community Science and Deputy Director of R&D Cell, BLD deemed to be University, Vijayapur, to share their thoughts and remarks with us.
Thank you so much for considering me to be a part of this presentation. It's been quite an insightful presentation. I think I can speak from medical side because since I'm a doctor, all two of you who presented, you gave your views that awareness among consumers or awareness among people, public has to be increased. I think you can add awareness also should be given to medical people. Just like the third person who presented, Shamin said, lot of people, including me, we do not know what happens if we do any kind of negligence. Probably if we are well aware, we shall be more vigilant in our rendering our services, try to be, I think, more understanding of what are the consequences. For unintentional injuries at least would be decreased. But it's a very wonderful presentation. All of you presented very well. Thank you so much, and a huge round of applause to all of you.
Thank you so much, ma'am, for your valuable words and insightful observation. Now I request Professor Dr. Ajay Kulkarni, Sir, Dean Principal, BLD School of Law, to kindly grace the dais. Now I request Professor Dr. R.J. Kulkarni, Sir, Dean Principal, along with the chairpersons, to present the appreciation certificates for the paper presenters. Firstly, I would like to call Dr. Sridevi ma'am to kindly collect the appreciation certificate. Thank you, ma'am. Now I request Monza ma'am to kindly collect the appreciation certificate. Thank you, ma'am. I now request Dr. Shami E. Sir to kindly collect the appreciation certificate. Thank you, sir. As we come to the end of this paper presentation session, I would like to express my heartfelt gratitude to our respected chairpersons for sparing their valuable time time and guiding us with their wisdom. I would also like to congratulate all the participants for their excellent presentation and sincere efforts. A special thanks to the organizers and everyone present here for making this session meaningful and successful. Thank you once again.
ಮ್ಯಾಮ್ ಸ್ವಲ್ಪ ಕ್ಲೋಸ್ ಆಗಿಬಿಟ್ಟು ಓಕೆ ಓಕೆ ಗಾಯ್ಸ್ ರೆಡಿ 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 ಓಕೆ ಓಕೆ ಗಾಯ್ಸ್ ನಿಂದರ್ಸು ವೇಟ್ ಮಾಡಿಸ್ ವೇಟ್ ಗಾಯ್ಸ್ ವೇಟ್ ಇಲ್ಲಿ ನೋಡ್ರಿ ರೆಡಿ